Can I just say something about Andrea?
Good morning, everybody. Welcome to a big day in the Tyler Robinson case. Really a big week. We're here for the preliminary hearing. Just waiting for things to get started. It's media scrummy kind of morning over there in front of the courthouse in Provo. This is the AP's feed that I am monitoring for things to get started. They've been out there with looks like probably a good 30 plus photographers and camera folks and stuff like that, just out there to catch the pictures of everybody coming into the courtroom. We are scheduled to go all week this week, but it's not clear if we're going to actually need all of that time. That is still a little bit of an open question in terms of what is actually going to be presented and what is not. And part of this is because there have been kind of some last minute changes, I guess, to what some of the anticipated testimony and evidence and so forth is going to be. I'm trying to, give me a second here, pull up and share with you, here we go, what we are expecting. And this is based on the preliminary hearing witness and exhibit list. 6 different witnesses. Now, we did hear at the last hearing, the last court hearing, the defense has wanted to call some of the state's forensic experts, I believe primarily from the FBI and the ATF, but not necessarily that clear. The state has not opposed that and has cooperated with the arrangements for that to happen. So the defense indicated 3 experts that they will be calling. So we can add those kind of to this list of things that we can anticipate being presented. Not all of them are going to be live. We know, for example, Lance Twiggs, we already know Lance Twiggs is not going to be here in person. His testimony is going to be delivered by way of what Utah calls an 1102 statement. And 1102 is based on a rule of criminal procedure that defines what reliable hearsay is for purposes of the preliminary hearing. And it includes statements that are made under penalty of perjury or after a warning that you can be subject to criminal prosecution if you sit down for the interview and then don't tell the truth. So that we know will be not live testimony. We also strongly suspect that the family friend who assisted with the surrender of Tyler Robinson on September the 11th is also providing an 1102 statement. And then the evidence that we're anticipating, a lot of video and photographic evidence. A lot of these written statements. Some of them are just going to be authentication, meaning they're going to be statements of people who keep and maintain records to establish that these are videos from the UVU surveillance system and how they were recovered and handed over to police and things like that, just to establish basic foundational requirements that the thing is what they are purporting for it to be. Things like the medical examiner report that is going to contain some important information. And then, of course, Discord chats, text messages, photographs again, and then some of these ATF and FBI DNA and ballistics and toolmarks reports. So a fair amount of evidence that is being anticipated. And of course, $1 million question in all of this is going to be, so what exactly, oops, give me a second here. What exactly is the defense going to do with all this? What kind of challenge, if any, is there going to be to the substance of any of this evidence? We know that they take issue with the foundation for some of it. That's already been kind of previewed in some of the court hearings. For example, the DNA evidence, some of that is apparently a mixture. a complex mixture of more than 5 individuals. This introduces some real technical problems when it comes to what they call deconvoluting that mixture and being able to identify individual contributors to it. So we are expecting that at some point in the process, there will likely be a scientific challenge to that type of evidence, but this is not the stage where that kind of thing happens. Nevertheless, kind of expect they're going to make a record of objections along those lines because of the litigation that they've already engaged in. They've argued that hearsay, just in general, in this hearing is unconstitutional. They have taken steps to preserve that for future appellate review. And so, to continue to make their record of what they are contending is unfair about this particular process, it seems likely that they're going to continue to highlight things that they think are going to be unreliable or just otherwise not good evidence, so that they have that argument for future appellate purposes. So just waiting for things to get started over there in the courtroom. Let me give you some expectation of what's likely to happen here, because many of you haven't joined me for a full day hearing before. I'm going to actually try to do things a little bit different this time, which I know is going to be a source of amusement to many of you longtime followers of the channel. I really am going to try to keep this stream primarily to just watching the court hearing. As many of you know, I take detailed notes throughout. My goal is to just try to take in as much as we can, not talk over the court, not give commentary, try to keep it minimal while things are actually happening, and reserve that for the breaks. We typically will get a mid-morning break, a extended lunch break, and then an afternoon break when court is in session all day. So I'm going to try to keep my commentary to those primary points in time, and then reserve what I normally do at the end of the stream, which is an extended recap, going through my notes, talking about some of what it means, some of the legal questions that come up, just sorting out some of the ins and outs of the court process itself and what it means and what's happening. Help try to translate that for folks who aren't necessarily as familiar with the criminal courtroom as I am. And so my goal this time is really going to be to save the recap for later on. Planning to get through the hearing, watch it, take our collective time to get up, walk around a little bit, have something to drink, a few calories. These sorts of things are important to keep your energy up during a busy week. But then come back in the evening. I've got it scheduled for 7:30 Pacific to do the recap and a little bit more of the relaxed conversation about what did we see today, what is happening, and what does it mean. So that's what to expect in terms of my channel. Now it is, yes, a long day, and so I may need to step away periodically. Again, those of you who are longtime followers of the channel, you are familiar with the scene around here. We have animals and bonsai trees that need attending throughout the course of the day. The bonsai trees, by far, more than any of the other living things, they are extremely demanding pets. And it's summer, and of course, we're about to have a heat wave. So I do, during the breaks, sometimes need to periodically go out and check the bonsai trees and see if they need water. Because if they need water and it's 90 degrees out and they're not getting it, then I won't have bonsai trees for very long. But otherwise, I don't tend to step away a whole lot. We'll just go ahead and use the downtime that we have to continue the conversation about the case. So everything is looking good to go. I know there were some concerns and some questions over whether this is going to be delayed again. It's been already delayed once, and there have been continued efforts, primarily by the defense, to continue to delay it. We are now just about 10 months after the shooting itself, the death of Charlie Kirk. And so, you might think if you're not real accustomed to the capital case time frame scale of kind of how things happen, you might think, wow, that seems like a really long time. For a non-capital case, yeah, it probably would be. For a capital one, not really that extraordinary for things to take a really, really extended amount of time. But at this point, no, we are all systems go for now. The last thing that was kind of holding up the possibility that the hearing was going to be delayed further is the defense had requested to the Utah Supreme Court to review some of the kind of interim decisions that Judge Graff has made about things like media being allowed in the courtroom with the cameras and hearsay, that this Utah rule that allows quote unquote reliable hearsay to be presented as part of the case for probable cause that we're here to establish in this preliminary hearing. So those rulings have gone against the defense. The defense tried to get the Utah Supreme Court to review those immediately. Normally, you got to wait till the end of the case to review all of your issues. It takes a pretty extraordinary type of claim for the Supreme Court in any jurisdiction, really, to say, yeah, you know what, we're going to go ahead and take this one up right now because it's just so clearly a wrong decision and it's going to cause a lot of problems if we don't immediately correct it. And these just were really not that types of issues. So I was not expecting any type of stay or intervention by the Supreme Court to put the brakes on the preliminary hearing while this attempt to appeal is ongoing. But nevertheless, they did formally, it has been reported in several outlets, it's been formally rejected by the Utah Supreme Court. They are not going to consider that appeal at this time. So that doesn't mean Tyler Robinson can't raise these issues and these concerns. It just means that he's going to have to wait until the case is final. And, depending on how things get resolved, there may or may not be a reason for him to appeal or grounds for him to appeal. But assuming that he does, then these are arguments that he'll be able to raise at that time. So no more delays. We are anticipating that everything is a go at this point, and now it just remains a question of how long is it going to take them? What exactly are we going to get? And how long is it going to take them to get through? Last thing I guess I'll say in terms of what to expect. Everybody's already going to laugh. Well, the last thing Andrew's going to say as if, yeah, I know. Fair point. Last thing really, though, in terms of what to expect, involves the evidence itself, because we do already know some of this evidence is it's not pleasant. And there's, far more than what's already public that going to be part of the case. Autopsy photographs, variety of different angles of the shooting, and the aftermath, the sounds, all of that type of thing. Not going to be very pleasant. And we already also know that there's going to be some restrictions on what we're shown, and that's not even necessarily coming from the court. It's coming from the prosecuting attorney, because they kind of they have a lot of discretion about how they're going to put their case on, as long as it's legally sufficient. And because the probable cause determination is something that's made by the judge, they don't necessarily have to go publish everything to the courtroom. Looks like things are stirring inside the East Idaho News, so I might switch over to that stream and just make sure we are ready for things to start happening when they do. Take our sound off there and make sure it's muted on the other channel. All right, good to go. We got a couple options here just in case. As you know, sometimes we have sound issues from the various different streams. Some of the channels just have, I think, better mixing and stuff like that. It's all the same. It's all the same feed, but they process it a little bit differently. So we will try to get the best sound. Anyway, because the prosecutor has a lot of discretion about, are we going to publish this to the courtroom generally, and then when we do, how do we do it? We already know, they've told us, they're not going to be showing these videos, for example, in open court. They're not going to be displaying them to the audience. They're not going to be showing them on screens where the camera is going to be able to pick them up. They're going to turn the screens away from the audience so that if they need to play something, it's going to be for the judge's eyes only. So not expecting that we're going to get, a whole bunch of video angles of Charlie Kirk being killed for public inspection at this point. Frankly, it's not something I have a problem with. There's already been a little too much death gooning over a lot of this video stuff. So it doesn't really surprise me or offend me that the court and other folks would be recognizing that we don't necessarily need to add to that spank bank, do we? But then there are some other exhibits that kind of been back and forth from the court about how this is going to be handled. There was initially a kind of agreement by both the state and the defense that we don't think the public should have access to the preliminary exhibits at all. We think that they should just be closed to the public. And initially, Judge Graff was seemingly receptive to that. But it seems from the last hearing as well that kind of as time has gone on, perhaps he is reconsidering that. He wants to take it on more of a case-by-case basis in terms of what the public will be allowed access to and what they won't. Something like the autopsy report is, to my mind, likely to be in the gray area of where the judge is kind of struggling. Because yes, autopsy reports can be very explicit. They can be very graphic. I mean, the whole process itself is a little gross, and they document it throughout, photograph it, and everything like that. But at the same time, it's also pretty dry and technical. It's a lot of anatomical words and different kinds of just technical explanations for what they are observing medically in the body that they are analyzing. And it's important information, particularly in this case where there's been all these swirling questions about what happened and yada yada. The actual medical evidence is potentially one of the most important things in the case, and that is often the situation. Were it not for the autopsy and the medical examination over there in Massachusetts in the prosecution of Karen Reed, yeah, we might not know that there's no medical evidence that John O'Keefe was ever hit by a car. None. No doctor was yeah, that's a car injury accident. No, in fact, the guy looks a lot more like he got beat up and hucked out onto the lawn at some point in the early morning hours. So determining exactly how the mechanism of death was produced, extremely important part of a murder case. It has been one of the biggest disputes, kind of biggest sources of confusion and question throughout this case. How could it be a 30-06? Well, that's the kind of thing that the medical examiner normally is gonna explain to us and talk to us about. So how much of that we are going to get to see still kind of remains up in the air. The medical examiner himself is not a witness, not called to come in and testify personally, but they do apparently intend to offer the autopsy report into evidence, again, under this rule for reliable hearsay to establish the probable cause burden. Are we going to get to read it? Are we not going to get to read it? These are the main questions that I have going into this hearing is largely procedural stuff like that. I am am concerned about the transparency, but we've had a very good judge in the case, and he's been one of our biggest advocates for courtroom transparency. So just continue to hope that he maintains that attitude. Hey, I already said last comments and everything, but of course you guys knew that wasn't true. I'm going to add one more thing about how things are going to go, which is just that, as many of you guys know, we favor a free speech environment in the chat. We are not a we're not a bubble. We are not a echo chamber. We welcome different opinions, different beliefs, different interpretations. But we do require that you treat other people with respect. We are here to debate ideas. We are not here to call names and to throw out unfounded accusations and so forth. And in this particular case, because of the attention to this hearing and this process, we're going to be a little bit more stringent about the kinds of things that can get the stream taken down. So just moderate yourselves, guys. We don't want to have to do it for you, but there are certain things that cross the line, and so don't test it, and it won't be a problem. But yes, we keep things fact-based here. We are interested in the evidence. That's why everybody is here to watch and see what it is. And maybe there will be disputes about it. Maybe there won't. But that's really what we are here to just have that conversation about.
Court is now in session.
And we're off.
Case 251-403-576, State of Utah versus Tyler James Robinson. Counsel, can you enter your appearances, please?
Chad Brunander, Ryan McBride, David Sturgeon, State, Mr. Jeff Gray, County Attorney, and Chris Ballard are also present.
Good morning.
Good morning, Your Honor. Kathy Nestor, Michael Burt, Richard Novak, and Stacy Visser here on behalf of Mr. Robinson, who's seated to my right.
Good morning. Mr. Robinson, good morning. For the record, the court also recognizes the presence of Ms. Erica Kirk. Ms. Kirk, good morning. First, with respect to courtroom protocol, to maintain security and decorum, any individual who exits the courtroom during proceedings will not be permitted to re-enter until the recess. All counsel are expected to take reasonable measures to safeguard confidential communication. Such measures may include the use of screen protections on electronic devices and care to avoid the inadvertent capture of privileged or private discussions by recording equipment or by those present in the courtroom. In addition, the microphones at your tables have been turned off. Again, in an attempt to try to minimize the possibility of any of the communications being captured. I ask that if you are speaking, that you come to the lectrum, and that microphone will be live. And so that's the best way that we can hear you, and it is captured on the record.
Oh, it's going to be bad for objections.
All right. Second, the court will address the camera operator, and the court knows there is no still photographer for today's proceedings pursuant to the court's ruling from last week. To our camera operator, would you please approach the lectrum?
Going to do our struggle session with the
microphone. There we go.
Camera operator.
Could you state your name for the record?
John Wilson, KSL News.
Mr. Wilson, what duties will you perform today?
Shooting the proceeding according to the decorum order.
All right. And have you had a chance to fully review the court's standing decorum order?
I have, sir.
All right. And you understand all the requirements set forth in that order as it applies to your activities today?
I'm going to switch to AP
Do you
so
require
that we
additional
can
time
have.
to review the order? Or
Oops. Give me a second here. Nothing is really happening, so don't worry, guys. All right. So we can have some closed captions. And that will help.
Next, turning to the amended motion to allow the use of portable electronic devices filed by the news media and their counsel. The court appreciates the arguments presented in the motion and recognizes the importance of the press in the criminal justice system. Having considered the motions before the court, the request to permit representatives of the news media to use portable electronic devices during the preliminary hearing is respectfully denied. The request to permit counsel for the news media to use portable electronic devices during the preliminary hearing is granted. As officers of the court, counsel shall be held to the same standards applicable to the counsel for the parties and comply with the court's standing decorum order. I wish to turn to the matter before us today, the upcoming preliminary hearing, and the court is mindful of the safety and well-being of all parties, counsel, witnesses, court staff, and members of the public who are present. The court is also mindful of the duty to protect and uphold the constitutional rights of both Mr. Robinson and Ms. Kirk. To serve those important interests, the court reminds all persons who will be in attendance that the portable electronic devices will not be permitted in the courtroom or on the fourth floor. In addition, each person who is in attendance will be afforded the dignity and respect due to them, and pursuant to the standing decorum order, all spectators shall be quiet, civil, and orderly. Spectators shall not engage in any distracting, disruptive, provocative, disrespectful, uncivil, or threatening behavior of any kind. Spectators shall not make any audible comments of any kind, shall not shake or nod their heads, shall not otherwise make any gestures during the hearing. And the court recognizes that this hearing may invoke a motion from everyone, and that the court understands the human nature of that, but also it's important that this courtroom is orderly. Spectators shall not wear or display any pins, buttons, signs, clothing, or photographs expressing support for or against any person related to this case, or the status of this case as a capital offense. Turning to counsel. Before we begin, I want to acknowledge that over these past 10 months, I've had a chance to observe each of you, and I find that you are all competent, prepared, and that you care deeply about this case. I ask you to continue to conduct yourselves in accordance with the rules governing professional conduct, civility, and ethics. I also ask that you remain mindful of the constitutional rights of all parties, and in every engagement that you treat each person you engage with the dignity and respect they are inherently due, as they are human beings. I want to turn also to objections, the format that I wish to follow if objections are made. When an objection is made, all parties shall pause so that the objection may be heard. Speaking objections are not permitted. If any party believes that an extended argument is necessary, particularly on sensitive matters, that party may request to approach the bench, and all parties will approach the bench. Both sides will be afforded an opportunity to be heard for or against the objection, after which I will issue a ruling either sustaining or overruling the objection. Once the ruling has been made, direct or cross-examination may resume. I anticipate that we will begin each morning at 9 a.m. with the exception of Wednesday, when we will begin at 1 p.m. We will take a 15-minute morning break and a 15-minute afternoon break. If there is a situation that necessitates a break, please approach the bench and we can address that. We will recess for lunch at noon for 1 hour each day, with the exception of Wednesday, and court will resume at 1 p.m. and continue until 5 p.m. each day. Does either party need the benefit of the record?
No, Your Honor.
Thank you, Ms. Nestor.
No, Judge, thank you.
Thank you, Mr. Gernander. Do either party wish to invoke the exclusionary rule?
Defense invokes, Your Honor.
All right. The defense has invoked the exclusionary rule. I ask that all witnesses, if present, be excused from the courtroom, and ask that each party monitor the courtroom to ensure your witnesses aren't present, as I'm not familiar with who they are. Of course, victim representative is excluded from that rule, as is the case manager pursuant to the rules. Okay, and I anticipate that from here on out, that they're just going to come to the lectrum, so. Okay, so just for the benefit of the record, to the questions, the yes or no questions, well, the parties have entered their appearances and they're all present, and neither party wanted the benefit of the record. Ms. Nestor invoked the exclusionary rule, and Mr. Grunander, if you'd like to approach the lectrum as the microphones at the tables are not activated.
Thank you, Judge. We anticipated that the defense would invoke the exclusionary rule. We consulted with defense for just a couple of minutes prior to the start of this hearing. We essentially have two case agents, Your Honor, David Hull and Brian Davis, both from the state of Utah. The defense has consented that both of them can be present. So one is seated at my table, the front table. This is Brian Davis, Agent Davis, and Agent Hull is seated on the bench just on the other side of the bar. He will be present for this hearing as well. Both of these agents will be testifying as part of the hearing.
Thank you. Ms. Nestor, and your microphone's dead. If you want to come forward, and it sounds like you've stipulated, but just for the benefit of the record.
We have stipulated, Your Honor, for purposes of this hearing only.
Thank you. All right, so Agents Davis and Hull are permitted to remain in the courtroom during the duration of the preliminary hearing. Any other business that we need to address before we turn to the business of witnesses? Mr. Novak.
Thank you, Your Honor. Richard Novak for Mr. Robinson. Your Honor, the court had issued an order, maybe it was early last week, asking the parties to meet and confer about the question of whether exhibits will be published. And we did, and we can either deal with this as a general matter, or we can deal with it on an exhibit by exhibit basis. But I just wanted to make sure that we didn't lose track of that issue. The court had earlier entered.
Okay, guys, I am going to switch over to KSL.
And we did,
Is better sign.
and we can either
sound.
deal with this as a general matter, or we can deal with it on an exhibit by exhibit basis. But I just wanted to make sure that we didn't lose track of that issue. The court had earlier entered an order granting in part the defense motion to exclude, I'm just going to say technology in the courtroom because it's a shorthand for video cameras and photography and microphones, because the parties had earlier stipulated that none of the exhibits would be available from the preliminary hearing, would be available for inspection or copying. I understand that publishing the exhibits in the courtroom may technically be different than that, but whenever the court is ready to deal with that issue, we just want to make sure that we do so
Thank you, Mr.
before it's
Novak.
too late.
That's always the right time to do it.
Okay, thank you.
Turning to the state in defense, do we anticipate this being a long argument, or is it something that we can handle? That there are some stipulations that we can address right now, and then the remainder we can address on an exhibit by exhibit basis. Mr. Grunander.
Judge, I don't know that we have any stipulations, but with that said, it is correct. Mr. Novak's correct. We did meet and consult on this issue. I wanted to give the court just a brief roadmap, but part of that was exhibits 7, 8, and 9 that we propose introducing will be graphic in nature. And those were the exhibits I was referring to at the last hearing, where we would like to take a short break before they were published, if they are published, whether it be by way of video and or audio. Judge, I don't see any TVs or monitors here in the courtroom today with respect to publishing something that would go beyond counsel table and your honor's bench. So I don't know how much this is of an issue this is going to be anyway. at least with respect to pictures or video.
Thank you. That's a great point. And the court's thought about this issue in regards to publication of exhibits. Obviously, the court will entertain all motions before any, but after considering it, here's the 2 points that I wish to address. In regards to the exhibits, there is benefit to publication of certain exhibits, but I also do not, and this is going to the camera operator, do not want them to be displayed on TV. I believe it is important that the parties know that the exhibits are being viewed by the judge in real time and in open court. However, what I will do is have the monitor placed against that wall to reduce the possibility of it being broadcast. And so on the exhibits that the court grants to be published in court, and not going to Mr. Novak's point, not to be given copies to, and the court is trying to be mindful that if it's shown on TV, that's essentially giving a copy to. And so the court is taking Mr. Novak's point in consideration. And so the anticipation is, and I know I'm catching staff a little bit off guard, is placing that television right behind Jeff, our bailiff, to minimize the accidental capture by the camera and in allowing it to be displayed. I recognize that that is not the ideal spot for viewing, but I'm also trying to balance the rights and important considerations that defense has made. And again, this will be on an exhibit by exhibit basis on what is published or what is not. But for the exhibits that the court rules can be published in open court, that is going to be the location of the monitor. And again, the court spent a bit of time weighing what should be done, where the monitor should be placed to accomplish the purposes of publication, at the same time protecting, especially as it may relate to sensitive material if the court deems that to be publishable in the courtroom. Any
Understood. Questions
that I can address from either side or clarification needed or thoughts that you wish to share?
No, I think I understand completely.
All right.
Thank you.
7,
All
8,
right.
and 9 are the
And
videos.
Mr. Grunander, as it relates to that, are we anticipating the possibility of that coming up very soon in regards to publishing potentially exhibits?
Not real soon, but today certainly I would anticipate, Judge. For the course information, we anticipate presenting 4 witnesses. They're all law enforcement witnesses. Officer Chris Bagley, he's now with Spanish Fork Police Department. He was with Utah Valley University Police Department. He'll be the first witness. The second witness will be Agent David Hull, and those exhibits 7, 8, 9, we anticipate coming in through him. The third witness will be Agent Brian Davis, again with the state of Utah, a case agent who's here presently. And lastly, Sergeant Jennifer Faumoina, also of the Utah Department of Public Safety. And we do anticipate admitting between 40 and 50 exhibits.
Thank you. All right, Mr. Grunander, I apologize. You walked away before I got my question out. If we anticipate taking a break around 10:30, do you anticipate any potential exhibits for publication being requested prior to 10:30?
I do, Judge.
Okay.
I do. I think the first several exhibits should be published. So.
All right. Well, let's do this. I want our preliminary hearing to move smoothly and with the least amount of delays as possible. So let's take a brief break to allow the placement of that monitor, a brief test to make sure it's working, and then we can be seamless in moving forward.
One quick question, Judge, for council's benefit. Are the monitors at the tables going to be turned on?
The monitors are, and
Okay.
that's why I wanted to give that instruction early on for each party to monitor their monitor. Because if the camera is doing a wide sweep picture of the courtroom, I can't prevent the accidental capture. Obviously, the decorum order anticipates not focusing in to the point that is focused on your monitors. But I ask all the parties to be mindful, especially as it relates to the sensitive material that may be published or may not. But please just take a look at that and be mindful of that. But I will leave it to you. So I believe it's important that all parties see what is before the court. So if you have objections, it's right there. You can say, okay, I see what the court's saying. I have objection or not, or just to confer with your client. I just want to make sure that there is no misunderstanding of what's being presented, to allow all parties the benefit of the record, and it is clear what is being presented to the court for consideration as evidence. Thank you.
And we do have one exhibit that will be in physical form. And so we will be using the easel, I think that's just over by the jury box.
All right. Thank you, Mr. Grunander. Before we break, I do wish to remind the parties that this is a preliminary hearing. It is a probable cause standard. And if you could keep that in mind as you're presenting your evidence, this is not intended to chill what you present, but keep in mind that the standard is probable cause, and that is what the court as a magistrate will be looking to. All right, with that, let's, how much time do we need for the placement of the monitor? All right, well, let's break for 6 minutes. Well, let's make it easy on ourselves. Let's just come back at 9:35 and we'll resume court at that time. Thank you.
All right.
So we are pausing for about 9 minutes for all these preliminaries. Actually, I got to tell you guys, as preliminaries go, this was not bad at all. This was actually, from my perspective, extremely organized. They've been anticipating these issues for a long time, as they've described, and as I talked about at the top. These have been parts of conversations in the court for a number of hearings to date. So here's what I am getting from all of this. Exhibits that are published in the courtroom will be visible to the people that are present in the courtroom, because they are setting up the monitor over on the side for that specific purpose. They are not going to be visible to those of us at home. The judge is specifically saying he's putting the monitor in the location that it is, so that the cameras will not be able to capture it. We might get inadvertent captures from the monitors that are there on the counsel table, probably also up there on the lectern. And he's not going to go crazy to try to prevent, any and all glimpses, I guess. But there is going to be a bit of a difference then between what we are able to see here at home in terms of the substantive evidence and what is going to be visible there in the courtroom. So we are going to be dependent on some of those in-courtroom reporters for details about the particular exhibits. Why is he doing this, you ask? I'm gonna mute this kind of weird sound stuff they have going on. Why is he doing this? It largely has to do with the posture of this particular hearing, because it is a probable cause hearing. This is just there to ascertain, for the judge to pass on whether there is enough here to warrant having a trial at all. Is this suspicion, this allegation, the series of allegations against Tyler Robinson, is it well enough founded in evidence for it to be justified? But it's important to remember that, of course, this is not the trial. And the trial is, if it happens, going to be probably a couple years down the road. It's going to be decided by a jury that's drawn from the local community. They're already concerned about people drawing strong opinions about the case based on partial and incomplete information. And so there is a risk, and it is kind of common in these types of processes, that too much of the evidence is out there then it's going to be harder for people, it's going to be harder for people to keep an open mind, to hang on to their epistemic humility, recognize the limits between what you know and what you don't know. And so that's really the thinking behind restricting the access to the preliminary hearing exhibits at this time. Now, there's really no question, constitutionally speaking, these exhibits are court records. They are judicial records under the First Amendment standard. And as judicial records, there is an extremely strong presumption that we the public, get access to that. It is part of our right to monitor our government, petition our government for the redress of grievances, to know what is going on in the court. And so anything that the judge has relied on to make his decision, extremely strong protection for public access. But that doesn't mean we get to see it all right now. That's really all this is about. It's a timing question. It doesn't mean we all get to see it and have it available at our fingertips and watch it over and over and clip it and so forth right now. Because there is a trial that has to be protected and a process that has to be protected. And so if too much is already out there, then you just run a greater risk that the preliminary hearing kind of ends up substituting for the trial in the court of public opinion anyway. And that's not appropriate. It's a very different process. It's a very different standard that they have to meet. The probable cause standard is extremely low. It's not hard to meet it. It's basically reasonable belief that there's reason, suspicion here that there's links that would tend to show involvement in a crime. That's really it. It's not hard to do. And so because of that, the evidence that is presented is the evidence that is needed to achieve that. It does not mean they are presenting their entire case here, vetting their entire case. There may be quite a lot that we don't hear yet, in part because investigations tend to be ongoing throughout the course of the trial, but also just because it isn't necessary. One of the things that we did not see, for example, in the exhibit list, and that I'm not anticipating much testimony about, one of the most important things from my perspective that we're likely to get in the case, and that's location. That's location data. That's stuff from the phone extraction, the vehicle. We know that there was some car systems that were also extracted. When a device is extracted, that means they are making a digital copy of it and then analyzing it, basically using a variety of different tools to go in and identify what is in the phone. Sometimes you get like what's been recently deleted, how has the phone been used, and a big piece is where has this phone been. If you got location services on, if you needed to Google map your way to a campus you've never been to, yeah, that's going to create a footprint. And so a lot of that is, to my mind, just extremely important evidence. But nothing in the exhibit list or the witness list suggests that we are going to hear that in this particular proceeding. And again, that's likely because a lot of this is probably ongoing. This is evidence that they obtained only after the arrest, after the initial charging decision. It didn't play a part in the initial charging decision. So they're not going to present it here. But if you watch this thinking this is sort of like the entire trial and that's not presented, you might have the mistaken impression that it doesn't exist. You might be forming opinions about the case based on partial information, incomplete information. So that, I think, is a lot of the thought process behind doing some of that minimization. The risk that it will be misinterpreted, that it will be misunderstood, that it will be misconstrued as meaning something different than what it does, given the nature of this particular process and where we're at. I don't love it. I'll be the first one to say I don't love it, but I do get it. And as far as compromises on kind of public access and our ability to see things and know what the case is based on, I don't really think it's a bad one. So we will get to be able to, like I said, to the extent he allows the stuff to be published, it will be visible to the people in the court. So we will be dependent on the courtroom reporters to share with us the details of what they're able to observe. So I do hope they're paying attention, media folks. Media folks, this is where you can be a real value add in this process, because we can see the stream for ourselves. We already know what the highlights are going to be. This witness testified and said X, Y, and Z, and here's the main evidence that came out and stuff like that. We're all going to be able to see that from home just by watching this live stream. But what we won't be able to see is what is shown on that screen. Media, this is where you can be a massive value add, okay? Pay close attention. Take notes of the details and share them with us. That would be a great public service, and we would appreciate that immensely. But they are going to consider it on a case-by-case basis. Frankly, I don't think he's even going to allow the shooting videos to be published openly in court. We'll see. We'll see. But I would just be surprised. Yeah, it's graphic. Extremely graphic. And it's really not uncommon for there to be restrictions on publicity associated with those types of things for the benefits of the victims, okay? The family members, the survivors, the children of Charlie and Erica Kirk, all of these people that don't necessarily want to have the risk of being confronted by these things that they're trying not to see. Okay, they're being accommodated to be able to leave the courtroom if this stuff is shown so that they don't have to see it. Well, if it's out there in public, it's just potentially everywhere. It's not uncommon for there to be restrictions on dissemination of that type of thing. And under Utah's rules, Utah has a very comprehensive set of rules that we have navigated already throughout the course of this hearing, the course of this case, that establish in terms of like court documents, court files, different levels of protection. Presumptively public, but some things aren't. If you got to publish something that's got attorney work product, attorney work product stuff in it. For example, you need to file something to the court to get approval of defense costs. One common example of a situation where this stuff is not the type of thing the public normally gets to see. It is privileged. So you can't just have that open in the open court file. Utah has very extensive rules about what level of protection gets provided to a whole variety of different pieces of evidence. And this type of graphic imagery gets protection under the Utah rules. I can maybe, they're probably going to go live pretty quick here, but I can probably find that rule if anybody is interested, and we can take a look at that during one of the breaks. But so because of that, I mean, the rules address it. It's not meant to be public. So I'm not expecting the judge is going to publicize a lot of this graphic stuff. But then the counterpoint, the one that I'm, again, most interested in, the medical examiner's report, the autopsy report, the language will be descriptive, but it's not graphic in the way that watching somebody be shot. Like, unfortunately, far too many of us kind of had to see whether we wanted to or not back on December 10th of last year when the videos were everywhere on Twitter from the attendees who were present. Autopsy report is, it might have photographs as part of it. Sometimes they do, sometimes they don't. It's a little bit hard to predict how they will actually do that. But for the most part, what's there that matters is the words. What do the words say? What do the words say vis-a-vis the mechanism of death, the cause of death, etc. Any evidence recovered during the course of the autopsy. That's the type of information that we need and we want. It's technical and it's descriptive, but it's not graphic in the kind of way that a visual depiction is. So think there might be some wiggle room there with the court in terms of publication where we might get to hear words, but just not see, not see visuals for ourselves. Let me, I realized I'm behind. Okay, we're back to live now. KSL was like, because KSL is the official, they are running the feed for this show. So I that might be like why they're kind of a couple seconds ahead of everybody else.
Parties to the state, are you ready to proceed?
Yes, we are, Judge, but prior to calling our first witness, I would like Mr. McBride to make a brief report on discovery updates, and then just inform the court that the state has provided copies of all exhibits for today's proceedings to the defense in advance of this hearing.
All right. Mr. McBride.
Another discovery update.
Yes, Your Honor. My report at the last hearing is the latest report. As of June 18th, we had provided approximately 100% of the material in our possession. Over the last week, we have received additional materials from SBI due to preparation for this hearing. Those materials have not yet been provided, but they will be as soon as this hearing is complete.
Thank you. Defense, I require the benefit of the record.
No, Your Honor.
Thank you, Ms. Nestor. And in case the mic didn't pick that up, she declined. All right, turning to the state, you may call your first witness.
Your Honor, the state calls Officer Chris Bagley.
Officer Bagley, if you'd like to come forward, and it looks like he's being brought into the courtroom. All right, Officer Bagley, if you wouldn't mind coming forward past the lectern and being sworn in.
You do solemnly swear that the testimony you shall give in the case now pending before the court will be the truth, the whole truth, and nothing but the truth, so help you God.
All right, Officer Bagley, if you wouldn't mind having a seat at the witness table. And after you're situated, to your left is a bottle of water. And if you wouldn't mind bringing the microphone toward you to ensure that it picks up your voice.
Can you hear that?
I can. Thank you. Mr. Gernander, your witness.
Thank you, Your Honor. Good morning, sir.
Good morning.
Will you please state your name for the record and spell your last name?
Christopher Bagley, last name spelling Bagley.
And how are you employed?
I'm employed with the Spanish Fork Police Department as a police officer.
As a police officer. What is your position or your rank there?
I'm just a senior officer.
Senior officer, okay. How long have you been with the Spanish Fork Police Department?
About 5 months.
5 months. How long have you been a police officer?
26 years.
Okay. Will you briefly describe, for the court's benefit, your training, what you did to become a police officer?
I did the Utah Post Academy, which is about 600 hours of training for basic things to become a police officer, report writing, arrest control, stuff to that effect.
When you say Post Academy, is Post an acronym?
It is.
What does that stand for?
Police Officer Standard Training.
Okay. Were you certified through Post?
I was.
Okay. And what did that certification require?
Going through that post and graduating, all the academy, all the credits that you can get up with hours, and then physical fitness, stuff to that effect, and then graduating from that to earn the certificate.
Was there also testing involved
There was.
at the academy?
Yes.
Okay. Were you employed in September of 2025?
I was.
And where were you employed then?
Utah Valley Police Department.
And how long did you work for the Utah Valley University Police Department?
5 years.
5 years, okay. And do you recall what your position or your rank was there?
A senior officer there.
Senior officer, okay. Describe, if you would, just your general duties as a police officer at Utah Valley University.
There at Utah Valley University, we patrol the campus, we'd walk around, we'd patrol, we would do investigations if there was crimes to that effect. We'd make sure that students or staff, if they needed something, we'd be there for them. So basic police, kind of like a school resource officer, community-oriented policing.
Okay. Was this a full-time position?
It was.
Okay. Did you work in law enforcement prior to UVU?
I did.
And where did you work?
I worked at Utah County Sheriff's Office for 13 years. Before that, I worked with Springville City Police Department for 6 years, and also with the Salt Lake County Sheriff's Office for a year.
What were your positions with those departments?
Varies. I did K9, I did SWAT, I did motors, senior officer, FTO officer, detectives.
Okay. While you were at Utah Valley University, did you have access to the video surveillance system on campus?
Yes, I did.
And how so?
It was at our desktop where our police station is. We have desks, and on our desktops, we'd have access to it there. Or we'd go into dispatch and they'd have a wall full of camera systems that we could look at.
How familiar did you become with that system?
Very familiar.
Can you describe how you became very familiar?
Like I said, it was one of our daily routines that we'd go in there. If we were looking for somebody or tracking something back, we'd go in, we'd go back to that time frame. We could trace somebody to track somebody through campus. I'd also turn around and make some maps, so it was easier for dispatch or somebody to click on an area in this campuses where the buildings were and be able to click a little bit easier and get a faster response. So made some maps and stuff like that.
And how often did you use this system?
Every day.
Okay. Did you become familiar with the campus at Utah Valley University when
Yes,
you
sir.
were working there?
Yes.
And explain how you became familiar with it.
Like I said, we'd walk around. I would train other officers. We'd make sure that we knew all the ins and outs, the back doors. We'd make sure we knew where every classroom was, where every entrance and exit was. We'd secure the building. We patrol the neighborhoods. We patrol around campus. And then we also have off-site campuses that we drive to and make sure that they're secure also.
Okay. You mentioned that you patrol the neighborhoods
Yes.
surrounding campus.
Yes.
What about the neighborhood to the north and east of campus?
Yes.
Okay. What was your purpose for patrolling those neighborhoods as an officer for UVU?
One, it was right next to the UVU, so we patrolled it. Sometimes people would run up in that area or be walking up that way. We'd have stolen bikes, stuff like that. So we'd go into the areas, look for stuff. Also with Orem Police Department, we'd go back up them quite a bit for other calls, and a lot of it would be in the area.
Okay, so back up just a little bit. So Utah Valley University is located in what city?
Orem, Utah.
Orem, Utah. Okay. How familiar did you become with the buildings on campus
Very familiar.
and the walkways?
Very familiar.
You mentioned the entrances and exits to the buildings.
Yes.
What about parking structures?
Yes.
Same answer for that?
Yes.
Okay. Are you familiar with the courtyard or the outdoor amphitheater on campus?
I am.
And generally speaking, where is that located on campus?
It's more of the central, it's an outdoor area centered by a bunch of buildings on around it. So it's in the center of the campus pretty much.
Okay. Can you describe what it looks like, this courtyard, this amphitheater?
It's kind of like an amphitheater look. So you got some grass and a couple of steps that go up. You got some cement on top with some bushes and flowers. You've got places where people can sit and eat. They come out and study and relax on the grass. And there's a waterfall with a little pond that comes down into a stream. So
Okay. Are you familiar with the surroundings, the buildings around the amphitheater?
yes, I am.
Okay. In relationship to this amphitheater, this courtyard, where is the Hall of Flags located?
It would be directly west of the courtyard.
Okay. Is it part of the courtyard or is it just off of the courtyard?
It's kind of the courtyard. It like butts up right against the courtyard. So it'll be the west side of the courtyard.
Okay, so to the west of the courtyard. Is there a walkway across the Hall of Flags?
There it is.
Okay,
There's an
and
inside one and an outside one.
Okay, so what is the Hall of Flags then?
The Hall of Flags is a kind of like a bridge between two buildings that all the flags throughout the world are represented in there with some chairs where people sit down and relax with windows so you can see through all the way to the Utah Lake.
Okay. What are those two buildings that are connected by this hall of flags?
The Fugal building over to like the science building area.
Okay. So you mentioned the Fugal building.
Yes.
Where's the Fugal building located in relationship to this courtyard?
It's to the south of the courtyard.
Okay. Does it run up against the courtyard,
It does.
the building? Okay. What about the Woodbury Business Building? Where's that in relationship to the courtyard?
That's kind of southeast and it runs up right against the courtyard also.
Okay. And in relationship to the Fugal building, where's that Sorensen? Or excuse me, that business building, the Woodbury Business
Woodbury
Building?
business is right directly east of the Fugal.
Okay. What about the Sorensen Center? Where is that located with respect to this courtyard?
The Sorensen Center is going to be kind of like a northeast of the courtyard.
Okay. Does it, again, run up against this courtyard?
Yes, it does.
Okay. And where is it in relationship to the business building?
Woodbury Business Building is just directly south of the Sorensen.
Directly south. Okay. The Losee Center, are you familiar with that building?
I am
And where is it located on campus?
directly east of the courtyard amphitheater area.
Okay. Does it run up to the courtyard? The Losee Center?
No, not really.
Okay.
It doesn't
So,
run right up against it. So the Sorensen building is kind of like right between those two.
okay. In relationship to the Sorensen building, what direction is the Losee building?
East.
East. Okay. Are you familiar with the LDS Institute building on campus?
Yes, I am.
And where is that located?
That is going to be located north of the Losee building and just kind of like northeast of the courtyard.
Okay. And is there a parking structure next to this Institute building?
Yeah, there is.
And where is that?
That is going to be, so you mentioned the Institute building is going to be north of the Losee Center. There is a parking structure that has several levels of parking. It's going to be directly west of the Institute building. And then they also have a parking lot to the north of that across the road.
Okay. With respect to the parking structure,
Okay.
can you describe for the court how one would enter this parking structure, driving and even walking? How do you enter and exit that structure?
So on the north end of the parking structure is Campus Drive. You can drive in and exit on the level 1. So that's the ground level. That's where you'd enter if you're driving in or exiting back out on campus. Then it goes up to level 2. And on level 2, exit, it's what's called Heat Plant Road. In between the Institute building and the garage is a little road. And there's an exit right there that you can drive out. You can also, if you were parking there, you could walk out right there at that exit only where I was talking about on that southeast side. You can walk out there, or on the north end of that garage, there are some stairs that go up all the levels and it goes down to the bottom level and across the street through a tunnel to the LDS Institute building. And then when you pop up on level 2, you can walk over to the Institute building.
Okay. Can you describe how long of a walk it would take from that parking structure to get to the courtyard on campus approximately?
A couple of minutes, because when you go to that far southeast exit, you can walk directly almost to the courtyard. You can also walk along the south end of the LDS Institute building up towards the Losee building.
Okay. Officer, I'm going to turn your attention to State's Exhibit number 1. It should come up on your monitor there.
And it's going to come up on his
Let me know when
also.
you can see that.
I can see it.
Just for staff, let's go ahead and not publish it until it's admitted into evidence. So we're going to take it off the monitors. But for the witness, he should be able to see the exhibit. That's fine. So table monitors, witness, but not the main monitor. Thank you. All right, Mr. Grunander, thank you.
Thank you, Judge. Do you see that's Plaintiff's Exhibit number 1, Officer?
I do.
And do you recognize that exhibit?
Yes, I do.
And what is that?
This is an area of the buildings plus the courtyard in the middle is all the grassy area. So this is an area of the campus at Utah Valley University.
Is it a photograph?
Yes, sir.
Okay. Are you familiar then with what's depicted in this photograph?
Yes, I am.
Does it fairly and accurately portray this area of campus?
Yes, it does.
Okay. Can you tell the court what direction the camera is facing when this photograph was taken?
It's kind of facing north and a little to the east.
Okay. Does it depict a number of the buildings that we've talked about today?
Yes, it does.
For example, the Hall of Flags, does it show the Hall of Flags?
Yes, it does.
The walkway of the Hall of Flags? What about the Sorensen Center? Does it show that?
Yes, it does.
The Woodbury Business Building?
Yes, it does.
The Fugal Building?
Yes.
What about the Losee Center? Can you see that from this photograph?
Yes.
Is this photograph a fair and accurate depiction of this area of UVU campus on September 10th, 2025?
Yes.
Your Honor, the state offers State's Exhibit 1.
Your Honor, we would object to failure to lay a foundation for, oh, I'm sorry.
It is a little bit tricky because that microphone.
Sorry about
Ms.
that.
Nestor.
Your Honor, we would object to inability to authenticate. There's not been a foundation laid that this officer took this photo, can verify when it
doesn't
was
have to.
taken or by whom it was taken, so we would object.
Mr. Grudenander.
Would you like us to argue now or approach the bench?
Well, as it relates to this, I'll hear argument.
Okay. Judge, first of all, it's very clear, well-established law that the person who took the photograph is not required to be present to lay the
Correct.
foundation for it. What's required for foundation is that the witness has knowledge of what's depicted in the photograph and can testify to its accuracy. And that's exactly what this officer has done. We laid an ample amount of foundation about this area of campus. He's confirmed that it depicts this area of campus that was previously described. He confirmed the buildings that he can see there. He also confirmed that it was an accurate depiction of on September 10th, 2025.
Thank you. Any further argument, Ms. Nestor? And Mr. Grudenander,
We did file a standing objection at the very beginning of the hearing. I would just refer to our standing objection as well. I know this is there's no written testimony in this, but just out of an abundance of caution, I want to also refer to our standing objection.
thank you, Ms. Nestor. All right, having considered the arguments, I find I'm going to overrule the objection and admit Exhibit 1. This witness has firsthand knowledge of the location as well as the building locations that foundation has been laid. He also stated it was a fair and accurate representation of what's being depicted here. And for those reasons, the defense objection is overruled. State's Exhibit 1 is admitted into evidence and may be published to the courtroom.
Okay. So the state would move to publish that to the courtroom.
It is so granted.
Officer Bagley, are you able to see the monitor that's here in the court that's pointed towards the gallery?
Yes.
From where you're seated, are you comfortable in describing where the courtyard is on that photograph, on that exhibit?
Yes.
And for the record, where is that located?
So all the grass that looks like a triangle, the amphitheater look, that is going to be the courtyard amphitheater area. It's got the tent in it, the white tent that's at the bottom on the far left of the picture. That would be the courtyard area. That's surrounded by buildings, more of the grass area.
I'm going to approach the photo. Well, I'm just going to, when you look at this exhibit to the left of the photograph, there's a walkway there. What is that walkway?
So the red brick walkway that's going north to the top of the picture on the far left is going to be the Hall of Flags, the outside top of it.
Okay. On the bottom of this photograph, there's a white roofed building. It's the largest building, at least as far as what's depicted on this exhibit.
Yes.
What building is that?
That would be the Fugal building.
Okay. And just to the right of that, so that would be to the east of the Fugal building. What building is that?
The other red brick pathway area, that is the Woodbury Business Building.
Okay. And if I were to walk north, so left on this photograph with respect to that red brick walkway area, there's another building sort of triangular in shape, the rooftop. What building is that?
With that white rooftop, that would be the Sorensen building.
That's the Sorensen building. What about the Losee building? You've described that. Where is that located on this photograph?
If you go to that triangle white roof, if you go directly to the right, so the right side of the picture, That is going to be the Losee building. It's got several levels.
Is it to the right and up a little bit as
Yes.
well? Okay, and that would be east on this photograph, is that
And
correct?
it's got the gravel rooftop.
Gravel rooftop, okay. I referred you to the LDS Institute building. Are you able to see that in this photograph?
Yes, you are.
And where is that
Not
located?
yet.
That's going to just be directly north of the Losee building. It's going to be that other white roofed building on the far top of the picture.
Okay, thank you, officer. We can take that down, Your Honor, as far as the publication. Officer Bagley, I'm going to take you back to the date of September 10th, 2025. Do you recall that day generally?
I do.
Were you working that day
Yes, I was.
at UVU?
I was, yes.
Okay. Do you remember what time your shift started approximately?
Yeah, it approximately started about 11 o'clock in the morning.
11 o'clock in the morning? Okay. Did you receive a specific assignment shortly after coming on to duty?
Yes, I did.
And what was that assignment?
It was to secure the top of the Hall of Flags on the south end. So we had people that were gathering on top of that were looking down on top of the tent. So we wanted to secure that area. So I was put up on top of the Hall of Flags on the south end.
Okay. My apologies, Your Honor. Could we have Exhibit 1 published again?
Go ahead and republish State's Exhibit 1. Thank you.
Somebody
You
said it
mentioned
was
that
gonna
you
be
were
quiet
securing
that
the
day.
south end of the walkway on top of the Hall of Flags.
Yes.
And so where do we find that in this exhibit, officer?
So if you can see the tent, the white tent, there's that rooftop where the red brick is. I was on top of that, and there's some, actually looks like yellow crime scene tape. That was some of our barrier that we put up so people wouldn't go above that and walk. So I was sitting right by those flower plants that were by the fugal on the south end.
So is the south end on the bottom of this photograph?
Yes.
Where that walkway kind of begins from the bottom?
Yes.
And you've referred to a tent. Is that the white object we see inside the courtyard?
Yeah, that square white object with the tent.
Okay, thank you. So you were securing that area.
Yes.
Did you have the opportunity that morning, you mentioned you checked on about 11 o'clock
Yes.
that morning and later to walk around campus that day?
Yes,
Did you walk along the Hall of Flags that day,
I did.
that walkway?
Yes.
Did you visit the courtyard that day as well?
Down below, yes, on the south end. I was down there.
Okay. Let's see. Officer, I'm going to turn your attention to State's Exhibit number 2. And that should come up on your monitor there. Let me know when you see that, if you would.
Your Honor, if we could maybe not have it on the lectern screen, we're getting reports that the documents shown on the lectern screen are being live streamed. So maybe if we could just not show that one until it's admitted.
Mr. Grunander?
I'll submit it to the court, Judge. I've got copies of these for myself
Okay.
that I can refer to as I'm asking questions.
All right. Well, I'll go ahead and grant the request by Ms. Nestor. We'll go ahead and there should be a power button to turn it off.
Not sure where that's at.
Thank you, Jeff.
So she's got somebody watching.
And if at any point, Mr. Grunander, you do need to use the monitor, let's revisit that. And obviously, Ms. Nestor, you can renew your objection if needs be. But for now, the monitor's turned off. Let's go ahead and proceed.
Thank you. Officer, do you see State's Exhibit number 2 on your monitor?
Yes, I do.
And do you recognize that?
I do.
And what is that?
This is a picture of from the east side looking west of the campus.
Okay. Are you familiar with what's depicted in this photograph?
Yes, I am.
Okay. And does it show, for example, the Losee Center that we've talked about?
Yes, it does.
Does it depict the Woodbury Business Building that we've talked about?
Yes.
What about the Fugal building?
Yes.
Does it show the Sorensen Center
Yes.
and also the Hall of Flags?
Yes.
In this particular exhibit, can you also see the courtyard?
I can. A partial of it.
A partial of it, okay. Does it fairly and accurately depict this area of campus of UVU on September 10th, 2025?
Yes.
Okay. Your Honor, the state offers state's exhibit number 2.
Your Honor, we renew our standing objection. We also argue that a foundation hasn't been laid in terms of the time this was taken or who took it, and at what point in time this was created and how. So I don't think he has any personal knowledge of that, and we'd object.
Mr. Grunander.
Same arguments, Judge. He has testified that he's familiar with it. He has
Yep.
personal familiarity with it. He's testified that it's fair and accurate as of the day of September 10th, 2025. And that's what was asked of him.
All right. I will go ahead and overrule the objection by defense, noting that the witness has laid, he has expressed that this is a fair and accurate representation of what it purports to be, and he's familiar with it. He was there on the day on September 10th, and because that foundation has been laid, State's Exhibit 2 is admitted and may be published.
Exactly
you,
correct
Judge.
here in the comments.
State moves to
MLS.
publish Exhibit 2.
All
Good
right.
call. Checking him. Check him
Officer,
out.
I'm going to direct your attention to this exhibit on the monitor facing the gallery of the court today. Can you describe, there's a large building in the middle of that photograph, slightly above the middle, but what building are we looking at there?
You're looking at the top of the rooftop of the Losee building. It's got two different grays, like a lighter gray and a darker gray.
Are you familiar with that rooftop then?
Yes, I am.
And what's it made of?
It's made of gravel.
Gravel, okay. You mentioned 2 different grades, or did you say grays?
Grays.
Grays, okay,
Yeah, grays.
all right. Now you described that you could see the courtyard, but it wasn't easily visible in this photograph. Where is the courtyard located on the state's exhibit number 2?
So you got the white roof that's going to be in the middle, just to the top of the building where the Losee is. I described there's a white roof there. That's the Sorensen building. And it's just below that. You can see some grass, and that's where the courtyard is. It's just to the left of that white roof.
Your Honor, I'm going to ask if the witness could actually come down from the stand and point out where the courtyard is located in this exhibit for the court's benefit.
All right. Do we have a second microphone so it picks up his voice? Okay, Ms. Nestor, thank you for allowing us. Officer, you may step down, approach the monitor, and I would ask that you speak into the microphone when responding to a question.
Okay, can you hear me?
I can. Thank you.
So officer, for our benefit, would you describe again where the Losee Center is in this photograph?
The Losee Center is going to be this one with the gray roofs. It's got two different colors of gray.
2 different colors of gray, okay. I'm blind, I can't see those 2 different colors from here, but can you describe where the court, looks like we went blank.
There we go.
Can you point to where the courtyard is located on that exhibit?
Courtyard is going to be here where this grass is in this area right here.
Okay. And what about the Fugal building
Hugo building is going to be this building right here.
and the Woodbury Business Building then?
Woodbury is going to be this one right here with this red brick path.
And the Sorensen Center?
Sorensen Center is going to be this white roofed one that's right here.
Okay.
Mr.
Now on this
Grunander, better
exhibit, can
record
you
is
see the
needed.
LDS Institute building and the parking structure that we've talked about?
No, not really. You got the back side of the Institute building, which is right here, and the parking structure's over there. So
Okay.
This one right here
Mr.
does
Grunander,
not
let me
make a good
stop you
record.
just for the benefit of the record, because the record is picking up the audio. When you're pointing it to, and I know it may be a little bit laborious to do this, but as you're
Thank you,
identifying,
Judge.
indicate the general location on it,
Right
the left
here.
side, right side, middle, upper, lower, just so the record knows to some degree where you're pointing. In that way, because the video isn't being captured. So if you would do that, it just creates a more complete record. Thank you.
Understood. That's fair. Thank you, Judge. So again, let's point to the courtyard, and if you'll describe as best you can where that is located on the photograph.
On this photograph, the courtyard is going to be this grass area that's going to be towards the top of the picture. The baseball field's behind it. It's closer to the surrounding buildings. There's some grass in there. That would be the courtyard area.
Okay, we've talked about the Hall of Flags and the walkway above that hall. Where is that located on this photograph?
The Hall of Flags is going to be right by the courtyard, just to the west of it. There's a red brick towards the top of the picture. There's a red brick pathway that goes from the Fugal building, which is on the left of the picture, towards the right of the picture, which is the science building area.
Okay, and then the Sorensen Center, is that the building in the middle with the large white roof?
Yeah, it's going to be kind of towards the upper part of the picture, middle of it. It's going to be a white roof. That will be the Sorensen Center.
And it just to the north and east of the courtyard?
Yes, north and east.
Okay, and then finally, if you would describe the Losee building, the location of that on this exhibit.
The Losee building is going to be pretty much in the middle on the right side, so middle to the right. It's going to have two different colors of gray, a darker gray and a lighter gray. There's a red pathway, and that will be the Losee Center.
Okay. You mentioned, officer, that there were different stories on the Losee building. How many stories does the Losee building have?
There's 4.
4 stories? Okay. You mentioned that you were familiar with the rooftop. Do you know how to gain access to the rooftop of the Losee building?
Yes, there's actually an outside stairway right here that comes up. It's going to be just to the south of Losee building. There's a red pathway right directly in the middle of the picture. Off to the south of that, on the left side of the picture, is an outdoor stairway.
Is that open to the public?
It is.
And how would someone access the roof from that stairway?
If they came up, they would put them right here on this pathway that goes between the Losee Center and down towards the computer science building. There's a red pathway. There's actually a little handrail, like a little guardrail, probably about a couple feet high, that somebody could jump over.
Is that area restricted? Is it off limits?
Yes, it is. There's kind of like a natural barrier with the guardrail, and from there on, there's no path. It's gravel roof, so it's not paved like everything else.
But someone could hop over that railway?
Yes.
Okay. Thank you, officer. You can take your seat again.
A little better at using the words to describe what they're looking at. This can all be a little bit painful, this foundational background stuff, but it'll move on from here.
Officer Bagley, I'm now going to refer your attention to State's Exhibit number 3. That's going to come up on your monitor as well. Let me know when you see that.
Yes, I do see it.
Okay. And do you recognize that?
I do.
And what is that?
This is a drone picture of the campus, more of the courtyard, looking eastward.
Okay. I've asked you about several buildings on campus. I'm going to ask you about those same buildings, whether they're depicted in this exhibit, okay? Do you see where the Hall of Flags is located?
Yes, I do. It's down towards the bottom. It's a red brick pathway. It would be the Hall Flags.
Okay. What about the Fugal building?
Hugo building's going to be to the right of the picture. It's going to be a white roof building off to the right, directly south of the courtyard.
And the Woodbury Business Building? Where's that at?
Woodbury is going to be another red path. That's going to be just to the east of the Fugal building. It's got a gray roof and some red path.
The Sorensen Center?
Sorensen Center is going to be on the left of the picture. It's going to have a white roof, different levels, and that would be the Sorensen Center.
Okay. The Losee Center, where's that located in relationship to the Sorensen Center that you've described?
Of the Sorensen Center, it's going to be just directly east of the Sorensen Center towards the top of the picture. You can see the two different colors of gray of the gravel that's on the roof.
Okay. And can you see the courtyard in this photograph?
Yes, you can.
Okay. Is this picture a fair and accurate depiction of this area of Utah Valley University's campus on September 10th, 2025?
Yes.
State offers Exhibit 3, Your Honor.
She'll object, he'll overrule.
Your Honor, we renew the standing objection. We also object again that this individual can't identify when the picture was made or how it was made or by whom.
Mr. Gernander.
Same response, Judge. And just for the record, I was also point the court to State v. Purcell, which is a Supreme Court case here in the state of Utah, 1985, which essentially stands for the proposition that if a competent witness with personal knowledge of the facts represented in a photograph can testify that that photograph accurately represents those facts, the exhibit's admissible. He's also spoke about the date being September 10th, 2025. The showing that's required here is essentially a prima facie showing. We're not required to show proof beyond a reasonable doubt, for example, that it was accurate that day or even a preponderance of the evidence. But we'll submit it on that, Judge.
All right, I'm just taking a brief glance at the case you cited.
I can give the citation if you're on
If
would like.
if you have that, I'd appreciate that.
It's
711.
711
P second,
Pacific 2nd,
243,
243.
1985.
And I'm looking at page number 245.
All right.
I got it. We can
The
talk
court
about
finds
it.
that the witness is familiar with the scene. He testified that it is a fair and accurate representation of what State's Exhibit 3 purports to be. And the court finds that necessary foundation has been laid and overrules the objection. State's Exhibit 3 may be admitted, is admitted, and may be published.
State would move to publish State's Exhibit 3.
All right.
This should be the last of the drone photos, guys, pursuant to the evidence list.
May I approach the witness, Your Honor?
You may.
Officer, if you would come down into the well of the court, I'm going to ask you a few questions about this Exhibit 3 as well.
Okay.
Can you point out where the Hall of Flags is located and describe that for the record?
The Hall of Flags is going to be down here on the bottom of the picture. It's going to have a red brick pathway with some flowers along the top of it.
You mentioned that you were securing an area of that
Yes.
hall, that walkway. Where were you stationed?
I was down here by the end of the flower pots, which is down here on the south side towards the Fugal building on the far right of the picture.
Okay. In relationship to where you were stationed, where is the Fugal building then?
The Fugal building is just to the right of me, so it would be on the south end of me,
Okay. And so it's on the right side of the photograph there?
far right side of the photograph, yes.
What about the business building?
The business building is just going to be in the middle of the picture on the far right. It's going to have some red brick pathways. It's going to be multi-level, and that would be the Woodbury building.
Okay. The Sorensen Center, where is that located on the photograph?
CH with the
Sorensen Center's
important
gonna be
questions here.
Middle to far left of the picture. It's going to have a white roof on top of it, multi-level.
They better not
Okay.
be
And the Losee Center,
hydrangeas.
where is that
Okay,
located?
boring ass
Losee Center is going to
hydrangeas.
be towards the top of the picture, kind of off-centered a little bit, but it's going to have the 4 or 5 floors that are
Some
the
nice
4
Utah
floors that are sitting right there.
wildflowers.
Okay.
There's lots of them.
Can you describe those stories, what we're looking at? Where do you find 1, 2, 3, 4, and possibly 5?
So this is ground level where the courtyard is. So this, as you go over in towards the Losee building inside, there's an elevator that'd be ground 1, level
Okay.
1. Level 2 would be the second one where these red ATVs are sitting on the grass right there in the middle of the picture. If you go up from that, that would be the 3rd level, and your 4th level, which is the actual top level of the building, is that very top one with the windows that you can see.
Okay. Is there an atrium on the top of that?
There is an atrium. It's got a little sphere on the top of it. It looks like a little square right on top of the Losee building. That would be an atrium.
Now, you mentioned 2 shades of gray on the rooftop of the Losee building.
Yes,
Can you see that on this exhibit?
I can. So where the atrium is a lighter gray gravel. And on the west side, because I'm looking east, on the west side,
Here,
there's
here.
2 ventilations for
So
the Losee
basic.
building, 2 vents on top of that. It's in the darker gray
Okay.
gravel.
You mentioned you're familiar with the rooftop of the Losee Center, correct?
Yes.
When someone is standing on the Losee Center, can they see down into the courtyard?
Yes, they can.
And where is the courtyard located from
It's
the
going to
rooftop?
be in the center of the picture with the grass and the atrium style steps.
Would that be west of the Losee Center then?
Yes, it'd be directly west of the Losee Center.
Okay. Now, in a couple of the other exhibits, we saw a tent that was down, set up in the courtyard. Can you see that tent set up in the courtyard in this photograph?
You cannot, in this picture, you can't. It would be where I explained where the hall flags is. It's directly underneath the hall flags, like just on the grass right there.
Okay, is there a clear line of sight between the tent and the top of the Losee Center, the rooftop?
Yes, there is.
Okay. Is some of it obstructed?
Yes.
Obstructed by what?
The Sorensen building that's right here, this white roof that's going to be, this kind of obstructs a little bit of the view of the courtyard.
So where would you have to be standing or perhaps lying down on the Losee Center to see into the courtyard where that tent was?
On the far south side of the Losee building, you could have a line of sight towards the courtyard.
And that's the top roof
The top roof, yes.
with the darker shade of gray? You
Yes.
see?
They are all over
Okay,
the
thank
Pacific
you, Austin.
Northwest. It's the only place acidic enough that they will still be blue. Everywhere out here, we're very alkaline. They're like the worst pink. So basic. I know we handle the real controversy here on
I
this
am going
channel.
to refer the witness now to State's Exhibit number 35.
Exhibit
And Officer
35.
Bagley, when you see that, go ahead and let me know.
Oh, there's no Exhibit 35 on their list. They must have done an amended list.
Do you recognize what that is, officer?
I don't have it yet.
Oh, okay.
Showing the whole courtroom before it's in evidence.
So we don't have this in electronic form? We do, okay. Well, I'll refer you to the
Awkward.
exhibit that's to your left and behind you. Do you see that?
I do.
And it's marked as State's Exhibit 35 with a yellow sticker, is that correct?
Yes, I can see that on top left of the photo.
Well, for the record, if we can publish that on the witness's screen.
Thank you, Mr. Gernander. I was just going to mention that we
It's
shouldn't
not an
display it
evidence.
until it's been admitted in. So
Do you see State's Exhibit 35 in your monitor?
Yes, I do.
Okay, can you,
Interns getting
do you
fired.
recognize that?
Yes, I do.
And what is that?
This is an aerial view of the campus and the northeast area, just north of the campus neighborhoods of Utah Valley University in Orem.
Okay. And how can you personally tell that this is a photograph of the campus and the neighborhood to the northeast of campus?
I can tell because I recognize all the buildings, the roads that are around it, the streets, the roundabouts, the neighborhood to the north or towards the top of the building or picture also.
Now, I've asked you about several buildings and landmarks on campus. Are you able to see the courtyard on this exhibit?
Yes, you are.
And just for the record, can you describe where this is located on the exhibit?
So right in the center towards the bottom, there's a white triangle roof. That's white. That would be the Sorensen building. It's the patch of grass that's just directly south of towards the bottom of that on the picture. So it's kind of centered, but more towards the bottom, right in the middle.
On this exhibit, are you able to see the Fugal building?
Yes, I am.
And in relationship to this courtyard, where is that located?
That's going to be south of the courtyard with the white roof.
What about the Woodbury Business Building?
Woodbury Business Building is going to be to the east, and it's going to have a red brick path top.
Okay. Can you see the Hall of Flags on this?
Yes, you can.
And where is that located in relationship to the courtyard again?
It's directly west of the courtyard.
And the Losee Center. Can you see the Losee Center?
Yes, you can see the Losee
Where's
Center.
that at?
It's going to be kind of northeast of the courtyard. The two patches of gray that's almost in the center of the picture, just to the slight right of the center.
Okay. I've asked you previously about the LDS Institute building. Can you see that on this exhibit?
Yes, you can.
And where is that located in relationship to the Losee Center?
It's directly north of the Losee Center. It's got a white roof and it's almost directly in the center of the photo.
Okay. And as we've talked about a parking structure that's nearby the Institute building, do you see that?
Yes, it's just to the west or left side of the picture of the Institute building.
Okay. Is this a fair and accurate depiction of Utah Valley University's campus and the surrounding neighborhood to the north and east on September 10th, 2025?
Yes.
State offers State's Exhibit 35.
Your Honor, renew the standing objection and object on the grounds that there's no indication on this photograph of when it was taken in terms of relation to the actual incident at issue here.
Thank you, Ms. Nestor. Mr. Granado.
Same response, Judge, but I would just add one more case for the court's benefit. This is State v. Wager or Wager, W-A-G-E-R. This is a Utah Court of Appeals case from 2016. The citation is 372 Pacific 3rd, 91. And the significance of this case, Your Honor, at issue there was a photograph of the defendant there who was smoking methamphetamine allegedly in his bathroom. The witness that was testifying, that laying the foundation at trial, was not present when the photograph was taken. Could not tell the date on which it was taken, but he had been in the bathroom before, was familiar with the defendant's bathroom and familiar with the defendant. He testified to that personal knowledge, and the court found that was sufficient foundation. So that case, in addition to the other case, the Purcell case, in my previous arguments, and I'll submit it to the court.
Ms. Nestor, anything else you wish to add?
No, Your Honor.
All right. Given the testimony of the witness who's testified he's familiar with this location, he went in detail describing the various neighborhoods and location. He mentioned the roundabout and identified the buildings in State's Exhibit 35. And it was noted that it is a fair and accurate representation of this campus as of September 10th, 2025. The court is going to overrule the objection, and State's Exhibit 35 is admitted into evidence and may be published.
Thank you, Judge. The state moves to publish it. And if granted, may I approach the exhibit?
You may.
Now he can turn it. Now he can turn it around. Now it's been admitted. Now it can be published.
Officer, I've asked you about a number of the buildings located on campus. I'm just going to ask you a couple of questions about those and to help orient the court to what the judge is looking at, and then ask you about some of the streets in the neighborhood, okay?
Okay.
For the court's benefit, can you point out where the LDS Institute building is?
Yes, I can.
And I'm going to approach the witness again if you could describe where it's at on that Exhibit 35.
Okay. Okay, can you hear me?
Yes.
Okay. So you want the LDS Institute building? is what you're
Yes,
asking?
please.
That is this white roof right here is the Institute building.
Is that in basically the center of the exhibit?
It's almost exactly in the center of the exhibit.
Okay, and where is the Losee Center located on that?
If you were to go down towards the bottom of the photo, there's two different grades of gravel on this roof. This would be the Losee building right here,
So below the Institute building and to the right slightly.
slightly to the right.
Can you point out for the court's benefit where the courtyard is?
The courtyard is going to be to the west or left side of the picture. There's some grass in between two buildings that have a white roofs. There would be a grass area right there with some steps. That is going to be the courtyard area, and that's going to be down towards the center bottom of the photo.
So that's to the left and down.
Yes.
Okay. You mentioned the parking structure. Where's the parking structure next to the Institute building?
There's two Institute buildings right here in the center with the white roof. The parking structure is going to be just to the left of the Institute or west side. There's a road in between it called the Heat Plant Road, which is the road that goes between those two.
And can you point out for the court's benefit how one would enter that or exit that parking structure by way of vehicle or walking?
By entering, you can enter and exit right here on the north side of the parking structure. There's an entrance and exit right here. That's
For a
into level
vehicle?
1
For a vehicle?
for vehicles.
And I guess someone could walk in there as well.
Yes, if they were to park into this LDS Institute parking lot over here on the north side of that, there's a tunnel that goes underneath the road that still comes out into the parking structure itself. And then they can exit out here on the second level onto Heat Plant Road, which is that road between the LDS Institute building and the parking structure is the heat plant. They can exit there and go back towards Campus Drive. So you could walk out either up here on the northeast side of the parking structure and cross over to the LDS Institute, or you can come out here to the southeast side and you can exit there and walk down to the courtyard or behind the LDS Institute building towards the Losee Center.
Okay, thank you. You mentioned Campus Drive. Where's Campus Drive located on that?
Campus Drive starts right up here towards the top left of the picture. It's almost like a T. And it's the curved road that comes all the way down in front of the Institute building and the parking structure. And it goes all the way around campus, comes back down to the bottom of the picture where the roundabout is, and that would be Campus Drive.
Okay. Are you familiar with where 800 South is in Orem?
Yes.
Is that depicted on this exhibit?
It is.
Where's that at?
It's at the top of this photo. It's going to be the long straight road. That's right here at the top of the photo.
Okay. What about 850 South? Are you familiar with that street?
I am. 850 South is going to be towards the right of the photo, top right of it. There's going to be a street that goes east to west. It looks like a horseshoe, kind of. It's going to be the road that goes east to west. In the middle of that horseshoe would be 850.
Okay, so 850 is parallel to 800 South.
Yes.
And just below on this photograph.
Yes,
Okay. Are you familiar with 600 West?
I am.
And where's that street in relationship to 850 South?
That would be on the far right side of the horseshoe. So towards the right side of the picture. And it's going to be the right side of that horseshoe,
And that runs north and south?
north and south.
Okay. What about 720 West? Are you familiar with that street?
Yes, I am.
And where's that at?
That's going to be to the left side of the horseshoe. That runs north and south. And it comes down towards the bottom.
Okay. And finally, 925 South. Is
925
that
south
depicted?
is going to be on the bottom of the horseshoe that connects those other two wests.
Okay. So just in summary, will you describe the horseshoe and what streets make up that horseshoe?
So the horseshoe comes up off of 800 South, and directly south of that, you'll have 850 South, which is going to be running east to west. On the left side is 725 West of the horseshoe, and it comes down into 925 South, which wraps back around to 600 West on the far right side of the horseshoe, on the right side of the picture.
Okay. Thank you, officer. You can be seated.
Weird road naming conventions, but this was all foundational for surveillance footage that they recovered. This is going to be the Ring camera videos.
Okay. I'm going to take you back to September 10th, 2025. You mentioned you were on campus. You had a particular assignment.
Mr. Gernando, I'm sorry. We're just going to pull down the exhibits.
Okay.
Thank you. You may continue.
Would you like me to take this exhibit down, Judge?
Are you referring to it in your line of questioning right now?
Not right now, I'm not.
Okay, let's go ahead and take it down.
So you were securing the Hall of Flags walkway, correct?
Yes,
On the south end.
yes.
What was happening that morning, that day at campus at UVU?
I came in to do a shift for a special event where we had a guest speaker come in and was going to talk to the students and people around the neighborhood.
Do you know who the guest speaker was?
I do.
And who was that?
It was Charlie Kirk.
Did you see Mr. Kirk that day?
I did.
When did you first see him?
When he arrived on campus, just behind the west side of the Hall of Flags, I saw him pull up.
And can someone access the courtyard through that area?
Yes, they can.
How so?
Where he pulled up underneath the Hall of Flags is a opening to where you could drive a car underneath. So there's access right there. You could walk or drive underneath the Hall of Flags.
And you saw him arrive?
Yes.
Okay. Can you describe what you were seeing? What did you observe?
On that day, I observed Charlie going back, doing some meet and greet with some people, getting some photos taken. He then came underneath the Hall of Flags and went to his tent, and he was there answering questions and talking to individuals that would ask him questions.
The tent you're referring to, is that the tent that we see when it was set up in the courtyard,
Yeah, that white square tent.
the white top?
Yes, he was
Okay.
under that.
Fast forward to about 12:20 or so, so a little bit after noon, the noon hour. What happened? What did you see? What did you hear?
I heard an individual talking to Charlie, and I happened to kind of glance over the edge of the railing about that time. I could see the right side of Charlie's shoulder, so not his whole body, because he was underneath the tent, so I could only see probably the right side of his body. He was answering a question, kid asked him a question, and then I heard a shot fired.
Do you know what time that was?
Yes,
What time was that?
12:23.
What did you see?
At that moment, I saw him lean to the left, so
When you say him, you
Charlie.
Charlie?
Charlie Kirk. So I saw him go to the left because I could no longer see the right side of his body. So he went further underneath the tent to the north side of the tent, so left.
Okay. Can you describe the reaction of others that were there?
Yeah, so then everybody started getting up and starting to run in more of a chaos kind of situation.
Before you continue, can you describe a little bit? So you mentioned Mr. Kirk was answering questions, talking to individuals.
Yes,
Were there others present?
yes.
Any idea about approximately how many?
So,
How would you describe it in your terms?
In my terms, I'd say when I was up there looking down, I'd say there were several thousand people because you had it on the grass that was jam-packed, in the amphitheater sitting on the grass. You had people standing on the back up along the cement. You had people that were on the second level, the Sorensen, and over by the Woodbury building. There's another level there where a lot of people were standing and watching. So it was pretty packed, several thousand people.
You mentioned you heard something. What did you hear again?
I heard a gunshot.
Okay. And can you describe you described Mr. Kirk's reaction? Was that simultaneous to hearing the gunshot?
Yes, it was.
When he fell to the left?
Yes,
Did you see the reaction from the crowd?
yes.
What was that?
Everybody kind of got up. They all said, a lot of people were screaming, standing up and starting to run in all different directions away from the center of the tent.
Okay. You're a police officer helping to secure the area, correct?
Yes.
What did you do?
At that moment, I recognized it as gunfire. I left my post, which was right there on the south end of the Hall of Flags. I proceeded to right where the Fugle and the Hall of Flags meet. There's some outside stairs that I was starting to run down. As I was trying to get down to the bottom of the stairs, people were running up, people were laying down on the steps. I'm trying to jump over people to get to the bottom of the stairs so I can help stop an individual that's probably shooting.
What happened next?
By the time I got to the bottom of the stairs, I was informed on the radio that we had a shooter in custody. So I thought at that moment, I was like, oh, that was kind of fast. Obviously, it was close range probably because we had an individual in custody. Another officer came on, said we had an individual in custody. So I decided to, since the threat is gone, now I can assess for anybody that's injured and start looking for any medical needs that's needed at that moment. I started canvassing the area. As I canvassed the area, I was looking for anybody that was injured. I saw a kid on the ground that was on about the second or third tier in the grass next to a wheelchair, and he was almost convulsing. I thought he'd maybe been shot. Talked to the dad as I was running over there. He said that he was just having a seizure, that he was fine, he was not injured. So then at that moment, I observed that there was no other injuries that I could see at that moment.
Okay. Was your attention drawn to anything else at that time?
Yeah, so after we got some people kind of cleared away a little bit, I thought I needed to start preserving the scene because we had a crime scene. And with some of my experience and training to that effect I decided now we need to contain the scene and help preserve as much evidence as we can. So I started pushing people off the grass out of the courtyard area because I knew that's where the crime scene was. So as we started pushing those guys out, my Chief Long, that was right next to me, I looked down and saw an empty pistol holder that was sitting just on top of the grass. And at that moment, things had died down just a split second. I realized that the shot I heard was more of a rifle shot and not a pistol shot.
And what causes you to say that?
Just from being around firearms through all my trainings, the difference is, a handgun is more of a short bang pop sound. With a rifle, you have more of a longer, violent bang or crackle sound. It's more of a violent kind of sound. It's longer. So that's why I recognized it.
Okay. Is a rifle sound louder typically?
Yes.
Okay. Going back to
So
when
a
you
short
heard
bang pop
this gunshot, could you
versus a
tell
larger crackle.
where it came from? From direction?
Yes, I knew it came from the east of me.
From the east of you. Okay. So you see this realization comes to your mind. What did you do next?
At that moment when I saw the holster, the empty holster, I turned to my chief and I said, that was a rifle shot. And he said, I agree. And I looked up at that moment, right in the line of sight, I could see the Losee building had a direct line of sight. So I proceeded to go look at that and see what was going on up there.
Okay. Can you just briefly describe your route to the Losee Center?
So from the courtyard, you can go into the Sorensen Center. And like I said there earlier, there was on level 1, there's some elevators or there's stairs. I ran up 4 flights of stairs.
We all do.
Got to the 4th level of the Losee building and proceeded to the south of the Losee building. There's some stairs, which is at breezeway between the computer science building and the Losee building. There's some stairs that go up to the top of that. And so I went to the top of that.
Is that the stairway that you previously described?
Yes, on the outside of the Losee building.
Okay. And it's a public stairway.
Yeah.
Okay. Did you make it to the rooftop?
I did.
Do you know about what time you got there?
I got it there 12:44.
Okay. What did you do when you got on top?
When I got on top, I hopped over the guardrail. I noticed that there was an object which was sitting right about 10 or 15 feet in from the other side of the guardrail in the gravel. That looked out of place to me.
And in relationship to where you hopped over the guardrail, what direction was that object?
To the west of the guardrail.
Okay. And did you recognize the object?
I did.
And what was it?
It was a red and black screwdriver.
Okay. Did you touch that object?
I did not.
Okay. I am going to refer the witness on your screen, Officer Baggerly, to State's Exhibit 3.1. Let me know when you see that.
Yes, I see it.
Do you recognize what that is?
I do.
And what is that?
That's a picture of the screwdriver that I saw that day on top of the rooftop of the Losee building.
Okay. And that's how it appeared on the roof that day?
Yes.
Is that a fair and accurate portrayal of the screwdriver you observed and found that day?
Yes.
Your Honor, the state offers State's Exhibit 3.1.
Ms. Nestor?
Your Honor, we renew, excuse me, we renew our standing objection and object on the grounds that there's no foundation laid as to when the photo was taken or by whom. Thank you.
Same response, Judge. My previous arguments.
And did you state that this was a fair and accurate representation as of September
Yeah, he
10th,
did.
2025?
I had said that day. I'll ask it again
All right.
to the officer. Officer Bagley, you saw this screwdriver you're describing on September 10th, 2025. Is that correct?
Yes.
Is State's Exhibit 3.1 a fair and accurate depiction of that screwdriver that day, September 10th, 2025?
Yes.
All right.
State moves to admit.
I will go ahead and admit, State's Exhibit 3.1 is admitted based off of the firsthand knowledge of this, what this image purports to be, and it is a fair and accurate representation as this item on that date of September 10th, 2025, and this exhibit may be published.
Your Honor, before we continue to publish it and ask a few more questions, right now might be a good time to take a break,
All right.
if that's okay with the court.
All right, let's come back at, it's 10:43. Let's go ahead and come back, well, 10:44. Let's come back at 11 o'clock and then we'll resume direct examination. Court is in a brief recess.
Taking our morning break now, good 15 minutes. That'll give us some time to see what y'all have been thinking about this. What'd you think of the snap crackle pop? This was not the best moment of the testimony so far, but it's kind of funny sometimes just for me, watching police officers, use their words, try to use their words to describe some of this stuff. I don't question that there are audible differences between a rifle shot and a handgun shot. Go to any range, preferably an outdoor range, nice outdoor range, anywhere in the country, and you can listen to both. And yes, there is a difference between those. Is it going to be, immediately discernible to anybody and everybody? No, probably not. Is it like a definitive thing with rules? No, probably not. And that's probably also why it's hard for him to describe it really well. But the whole, just one is a short bang pop and the other is a loud crack. There we have it. I mean, there we have it. It was not a short bang pop. It was a longer, violent crackling sound from a rifle. To me, it's almost like the rifle is like a sharper. It's like a sharper sound. The handgun is more of a boom. And the rifle's more of a crack. I mean, I guess that's pretty much what he just said, isn't it? I don't know. I don't know how you do that. I don't know how you do that testimony well. Well, look. Everybody who was kind of forced, whether they wanted to or not, to see that video of Charlie being killed on September the 10th. Yeah, heard a gunshot. Okay. Don't need to be gaslit about whether there was a gunshot or not. We know there was a gunshot. We heard it for ourselves. Don't need to be told that it's actually like really an explosion or something. Like, no, it's a gunshot. We all heard it. This guy heard it. Everybody there heard it. It is now a matter of record on the case from the testimony. They heard a gunshot. So let that be established. Of course, we'll see. We'll see what, if any, extensive cross-examination we get from the defense on that point. But I'm just kind of here to tell you guys that if any of y'all are expecting that defense is going to be challenging whether there was a gunshot fired, don't get your hopes up. Don't think this is the way the defense is going to be dealing with the case. We have had all kinds of new people joining as new members, turning the chat green. Thank you guys so much. Welcome to the channel. Appreciate all of your support. Defense Russ, Andrea, can you please reach out to me, victims in Kentucky? I responded on Twitter. Go check the chat and reach out. Amy Abadi, we won't be able to see all the exhibits until after the trial is over, right? I remember that from the Jodi Arias trial, I think. This is one of those things that's going to differ from court to court, but this is very common, yes, that we don't get to see it immediately, but we will get to see it after the trial is over. This is a lot to get into, but there's just a whole lot of different sources for legal sources for the public's right to access court records, the extent to which it implies and the discretion the court has to temporarily limit things and so forth. And every jurisdiction handles it a little bit differently. Don't want to get too far down that rabbit hole. I've written about it on Substack for any of you who are interested in that. It's I talked about it. It came up most recently when it came up most recently with crazy Alice Evans's bullshit, but yeah, that's just because she was trying to block my access to court exhibits in the Ninth Circuit, which happens to be one of the most protected, in terms of the right of public access. But other jurisdictions don't look at it that way. They don't necessarily see it as a First Amendment issue. They see it as more of a common law right that we've had, and so not necessarily so protected. So it's kind of all over the place. I wrote about it. If you are interested in this, go through and find the piece that I did on Eugene Volok's litigation that he's doing. I think it's in Tennessee. I think it's in Tennessee because they have a rule that says basically they only provide court records to residents of the state. Well, if there's a First Amendment right, you really don't get to do that. And even the scope of the common law right, it's not real clear. But so I got into kind of what some of those distinctions were, looking at that case and like, whether he's got a good argument and what's going to happen with it and stuff. That one, by the way, is just sort of the judge called for more briefing. She wants more briefing, and it's just been kind of sitting, waiting for something to happen since then. So this can differ a lot. It depends on where you are and kind of what the thought process is. But this is not uncommon at all, because this is not the trial, guys. This is not the trial. This is just, is there enough to justify requiring him to enter a plea to a formal charge and then face a trial in the future? This is a process that's intended to be a backstop against just unfettered prosecutorial discretion to charge people with whatever they want, whenever they want. It's like, no, we're going to have some kind of review of that decision. Sometimes courts, different states, the federal government uses the grand jury process to do that. You have an independent investigation with a body of people randomly selected from the community to decide, yeah, we think there's probable cause here. And they would then return an indictment. So that's one way that the backstop can work. But another one is like this. You have a hearing where the judge vets what the prosecutor was relying on to make the charging decision and decides, yeah, that was reasonable, or no, it's not. So that's all we're accomplishing with this hearing here, is just, is there enough to justify a charge going forward? It is not the full trial. And so it's not a good thing to be basing firm decisions about guilt or innocence on, because number one, we're hearing largely one side of it. We're hearing the state side. We're not expected to like put on a full-throated defense of the case at this point in the process anyway. Although, having said that, obvious challenges to issues with the state's evidence are going to raise. Look at them. They're already making a record of objections that have no validity whatsoever. And they're continuing to assert them. Okay, guys, if there are good objections, we can infer they will be raising them. But it's still just a limited picture. So if we get the exhibits and we see, oh, this one says XYZ, that's all I need to hear. It's not how decisions about guilt or innocence are supposed to be formed. So that's why it is not uncommon for our access to this part of the evidence to be delayed, but certainly not denied for all eternity. Miss Magamandy, I believe their death penalty is a firing squad. They have the firing squad as an option. I believe, I'd have to double check exactly how it works. It's still an alternative to lethal injection, and they adopted it because there have been challenges that states that still have the death penalty and still execute people, they have run into challenges with getting the chemicals to do that. It's, I believe it's sodium pentobarbital is like the main active one, but there's a whole, there's a cocktail that involves sedatives and things like that. And so the companies that manufacture these aren't particularly enthusiastic about them being part of human executions. And so they have often resisted providing those to states for execution purposes. So it's been hard for states to get the chemicals. And so if they can't do it, then Utah now has this law that says they can use the firing squad as an alternative method. Has not, as far as I know, been recently vetted by the U.S. Supreme Court under the 8th Amendment, whether that satisfies cruel and unusual punishment standards. So kind of anticipate that would potentially be a thing if it were to come up, but that is like a gazillion years down the road. It wouldn't happen until execution is imminent and stuff like that anyway. John Coman, why don't they have privacy screens over the monitors? That would make all of this much easier. There's going to be a lot of this kind of process of muddling through, figuring out what is working and what doesn't work. They're going to have to try it and assess. And as they figure things out, they've figured out, yes, we can very easily see that screen on the lectern. So their solution has been, well, just power it off. That might work. It might not. There might be situations where there's only a digital thing and the prosecutor needs to be able to see it while he's questioning about it. So they're going to have to figure out. These are just common logistical types of issues that tend to be a problem. But I remain like astonished that we're here in a death penalty trial. Okay, some of the most competent and qualified attorneys anywhere. Okay, we've got Mr. Grunander running the show here. He's the chief deputy prosecutor for Utah County. He's been a prosecutor for decades. He's prosecuted death penalty cases before. We have the defense team, extremely well qualified. Michael Burt alone has been doing this since like the 1970s. Done so many different cases. It just amuses me that with all of this legal experience in a courtroom, we still run into confusion about the order of publishing an exhibit to the audience and admitting it into evidence. It's not rocket science. It really isn't. The rule is, once an exhibit is admitted, it's admitted. It is part of the record. It's part of the evidence, and it can be published to the court, to the audience. But if it's not, it doesn't. So you just admit it, and then you ask for it to be published. You don't show it to everybody before it's admitted into evidence. It's very straightforward. This was like an ongoing thing in the Karen Reed trial as well. Just this constantly people trying to show things that are not in evidence. Trials are not always easy. There is so much technical stuff that goes along with running a trial. But like, this is a really super basic one. Somebody's going to have a word with the intern. No, they're not really going to fire the intern for bringing up that poster board and showing it to the whole audience before it's in evidence. She's not really going to get fired. But she might get explained, just so you know, the order of things. It's got to be admitted before it can be published. I saw this come up, and so I just wanted to address it. Law Junkie 33, my question is this: with all these court proceedings, when is the actual trial going to be? What does proceeding all mean right now if it's not the trial itself? Is it justified to have a trial at all? Is there enough here to warrant having a trial at all? That's what we're here to decide. Because we don't just defer blindly to the prosecutor saying, well, I think so. He's got to back it up. So this is put up or shut up time for the prosecutor's charging decision. But it is not the full adjudication of guilt or innocence. There's going to be nothing dealing with any potential defense that Tyler Robinson might have. Like, this is not the place to litigate that. So we're unlikely to hear anything along those lines. We may hear criticisms of the state's evidence, but that's probably going to be about it. The trial itself, I have already put the over-under on early 2028, and frankly, I continue to think that's probably fairly optimistic. But we are talking about, it's not going to be this year. It is very unlikely to be next year as well, just with the scope of everything that they have to review and the investigation that they have to do and everything that has to get done for this case to be ready to go to trial. Mara W. 8658. Interesting that her objections have no citation unless the prior standing objection has one. This indicates to me it's just an appeal preservation objection, if anything, odd strategy. That is all that it is. So the standing objection was a document that they filed over the weekend, and this is just relating back to the argument that they made that Judge Graff already denied, where they said this process in Utah where you get to use reliable hearsay to establish probable cause, we think this falls short of the federal constitutional standard, that this is unconstitutional under a variety of provisions of the U.S. Constitution. The Utah Supreme Court has previously disagreed, at least as to the right of confrontation, said it is not violated because of the nature of what the preliminary hearing is. But other objections hadn't been, other constitutional arguments hadn't specifically been ruled on by Utah. Judge Graff said, no, I don't think that those apply to prohibit this process. So that's what their standing objection is they're just renewing that. Photographs are technically hearsay, or can be. It's not really a statement, but it is a document. It's a depiction. It's a representation of something from out of court being offered to prove the truth of it. So I think they were just doing that in an abundance of caution to make sure that 10 years down the road, if we're in like a post-conviction proceeding, we're in a federal habeas action in federal court, that there isn't an argument that they waived this issue because they didn't object to it at the preliminary hearing. They have to object to preserve their rights to argue it later on. And so that's exactly what they're doing. Rage Bronson, everyone hit that thumbs up. Thanks for the coverage, Andrea. Take my money. Thanks, Rage. Appreciate it. Welcome, everyone. Hope you're enjoying it so far. It is going to be a long day. This is hardly the riveting stuff, but that's just the nature of court. Not everything is, thrilling. There's a lot of preliminary stuff and kind of background stuff that needs to be taken care of before you get into the things that people are really most interested in. Kyle Cowden, barring subsonic ammo and suppression, handguns are a pop. Rifles are louder and sharper, followed by an almost immediate crack as it goes supersonic. What a great description. What a great description. It's unfortunate that Officer Bagley here hadn't had the guidance of this description before his own. It just came out a little Rice Krispie, didn't it? A little snap, crackle, pop. But we understood. I mean, I understood, I think. Sounds like you understood kind of what he was trying to say as well. I've definitely heard it enough at the range myself to be able to, tell, okay, that's people over at the rifle range. This is people over at the handgun range. This is people over in the cowboy action section, whatever. You can tell, but it does take a little experience. Amy Abadi, how is Erica going to make it through any of this if she couldn't even listen to that description and had to leave? They're going to accommodate her with what she wants to be present for and what she doesn't. I don't know what's going to be too much for her. That's really going to be up for her. This is not an easy thing for anybody to sit through. And so that's kind of her call. Same with the rest of Charlie's family. They are going to be treated with a lot of respect in this courtroom, and the judge is going to be cognizant of what a extremely painful and traumatic process this is for them, which is the big reason why there is a lot of victims' rights protections under Utah law. These proceedings are, not fun for the people who suffered as a result of them. So whatever accommodation she wants, she's highly likely to get it. To Truth for Liberty, UVU student description, slingshot sound, snap, crack. Perhaps. I mean, a slingshot has that elastic. I don't know. What the hell does a slingshot even sound like? What does it even sound like? I don't know. Maybe. That was a little bit hard to say. Ginger Puff is out here gifting the memberships. Thank you so much, Ginger Puff. Turn in the chat green. We love to see it. And Redius Maximus, joining us here on the channel. Welcome. Do appreciate it. The Jay Witt podcast. Thank you for sharing your expertise to us pre-K law students. AB, great show. Well, it's my pleasure. This is what I like to do. I spent awful lot of years, doing this kind of thing myself. And so it's just a little bit, I think, easier for me to understand the process from the perspective of the people that are engaging in it, because I've done it before myself. Now, that said, now I have to qualify, because no, we don't do preliminary hearings in Washington. We don't do them. Like, for those of you who think this preliminary hearing process isn't good, or like we need grand juries or just, anything like that. Washington, we don't do any of it. Okay. You can be charged with a capital offense, which no longer carries the death penalty in Washington, but it did up until about a decade ago. And this was true for those cases up to that point. Any serious felony, any of it, it's charged on the prosecutor's affidavit. Prosecutor submits an affidavit, and the affidavit tells the judge, here's the basic investigative facts. Sometimes they'll just attach a police report and say, this is my sworn affidavit this is what I anticipate I'm going to be able to prove. And that's it. Judge reads it. It's like, yep, probable cause. Nope, no probable cause. That's it. So we have no backstop to any of this in the state of Washington. But, having said that, no, I haven't done a preliminary hearing specifically, but we spent a lot of time in court questioning witnesses and all kinds of different hearings and trials and so forth. And so, yes, there's a lot of technical stuff to it. It's part of my goal here to demystify a lot of that as much as I can. For example, this whole hearing, this whole issue that's going on with the objection about the photograph, this is foundational. This is going to authenticity. And so it's one of the prerequisites to admit evidence into court, that you have to make a showing, at least a basic showing, that the thing is what you say it is. That it's not a fake. It's not something that's been altered. It's not something that's made up. It's legitimate. And so there's all kinds of different ways that can be established. A possible way is you call in the photographer who says, yeah, I was here at that date and time, and here's what I was shooting. And
that pursuant to the Utah Constitution, Article 1, Section 28, where victims and victims' representatives are entitled to be treated with dignity and respect, that if they choose to leave the courtroom, they can come back whenever they wish. They're not prohibited to coming back solely at the break. So I just wanted to clarify that in case there was any question about that. In addition, I want to talk about the exhibits as it relates to their admission and publication of the exhibit. So whenever there is an objection to an exhibit, I would ask that the attorneys are clear specifically what they're objecting to. There's basically three levels of objections that could be objected to. First, the admittance of the exhibit itself. Second is the publication of the exhibit to the gallery. And third is the publication which is electronically captured by the media. So counsel, I'll leave it to you in regards to what you object to or what you wish to respond to. If no objection to the publication media capture of the exhibit is specifically raised, the court will presume there's no objection. So being that the monitor was introduced today by the court, I wanted to offer that guidance to the parties in regards to your objections. With that, let's go ahead and return to the witnesses. I do note for the record that the counsel is present and all the parties are present, and let's go ahead and proceed. Mr. Grunander.
Thank you, Your Honor. We left off Officer Bagley with just having admitted State's Exhibit 3.1. I believe the court also granted our motion to publish 3.1. So we would ask the court to publish that to the gallery, 3.1.
Ms. Nestor, any thoughts?
No, Your Honor.
All right, we'll go ahead and publish Exhibit 3.1.
so it's on their screen in the courtroom, but not ours. Photograph of the screwdriver on the roof.
Looks like it's just taking a second to come up on the screen.
The one eternal constant is tech difficulties.
Let's
in
go
court.
ahead and unplug and replug in the monitor to see if that brings it back to life, to display.
I haven't been doing
All
my
right, looks like it's-
banners.
Noticing a flicker on my screen here.
Mine's up.
Oops. Oh, shoot. What just happened? Give me a sec.
Yes.
Okay, he's back. My bad.
All right, Mr. Grunander.
Thank you, Judge. Officer Bagley, so you testified that this is the screwdriver as you saw it on September 10th, 2025, correct?
Yes.
I'm going to, and this was on top of which roof?
Losee building.
And in relationship to the entrance, the stairway, and when you hopped over the rail to get there,
There's
where
about
was
10
it located?
About 10 or 15 feet in.
Okay. If I could, Your Honor, bring up State's Exhibit Number 2 that was previously admitted.
All right.
I would like to have Officer Bagley come down from the witness stand and point on that exhibit approximately where this screwdriver was located and describe it for the record.
All right, you may step down. And if you have a microphone for him as well.
I think there was one up there. Oh, here we go.
Not a Bellini. No Bellinis.
So if you can describe where you saw that
This is
screwdriver,
Utah.
point to that.
Yeah, so this is the Losee building right here with the light gray. Here's the guardrail in the center of the picture with the red brick. Just over that, about 10, 15 feet in, about right there.
About right there. Okay. Now on this exhibit, Exhibit 3.1, there's an evidence tag, yellow number 5. Was that present when you found the screwdriver?
No.
Okay. So that was left there by an evidence tech.
Yes.
Okay. Thank you. You can take your seat again. Officer, I'm going to direct your attention to your monitor again and have you look at State's Exhibit 3.2. And if you'll let me know when you see that.
Okay, I see it.
Okay. And can you tell us what that is?
Yes, that's the picture of the top of the Losee building looking west.
Okay. And how do you know that that is, in fact, the top of Losee Center, looking west?
I can see the landmarks of several buildings, that the Fugel building's on the top left of it. You've got on the right is a white roof, which is the Sorensen building on the right side of the picture. This is also the gravel area on top of the Losee building.
Okay. Can you see the courtyard from this exhibit?
Yes, a little bit.
What about the tent that was set up that Mr. Kirk was underneath?
Yes,
Okay. What about the Hall of Flags?
yes.
Did you mention that this was facing west? What direction are we looking?
We're looking west towards Utah Lake.
Okay. Officer, is this a fair and accurate depiction of what you observed on September 10th, 2025 on top of the Losee building?
Yes.
State offers State's Exhibit 3.2, Judge.
Ms. Nestor?
Your Honor, I think that we renew our standing objection. There is an evidence tag here, which begs the question that it's not a fair and accurate representation of how he saw it. And we also don't have any indication about when this picture was taken or by whom. So we object to its admission.
I see. Thank you. Mr. Grunander?
Officer, one more question, Judge. Officer Bagley, apart from the evidence tag, do you see an evidence tag on that photograph?
Yes, I do.
Was that present when you were on top of the Losee Center and observed this?
That was not.
Okay, otherwise, is it fair and accurate?
Yes.
State moves to admit.
Anything further?
No, Your Honor.
All right, thank you. Given that follow-up question, noting that the evidence tag, it appears to be number 2 on State's Exhibit 3.2 was not present, but otherwise it is a fair and accurate representation as stated by the witness to State's Exhibit 3.2. The court will admit it into evidence, and it may be published at the discretion of, or the request of counsel.
Your Honor, the state would move to publish it.
All right.
Officer Bagley, will you describe what it is that we're looking at here?
Yes, on the top of the photo, you got the mountain range on the back. That's going to be looking west. You also have Utah Lake, which is towards the top of it. As you come down towards the center, on the top, you've got a pond, which is the ponds over at Utah Valley University. If you come down from that, from where the water meets that red bricked part, more towards the center is the Hall of Flags. And just below that, where you can see the grass and the white tent, is where Charlie Kirk was sitting looking west, and we're on top of the Losee building.
And is this depicting a particular corner of the Losee rooftop?
Yes, it is.
And this is the top rooftop?
Yes.
Is it the same level where we observed the atrium that's to the north?
The atrium's up just a little bit higher, so this is level, at the top level of 4.
Level 4, okay. And what area of the rooftop are we looking at here?
You're looking
As far
on
as the gravel?
southwest side of the Losee building.
Southwest side, okay. Is there a line of sight down into the courtyard
Yes, there is.
in that area? Okay. What else do you observe on this exhibit that's significant to you, officer?
There was some disturbance in the gravel right where, and around the area where in the area where the yellow marker is there was some disturbance that caught my eye there.
Okay. And does this photograph do it justice?
No.
And how so?
You can't really see the impression I saw at the time of when I was up there on that day. I saw a distinct impression in the gravel, and this does not show that.
Okay, so you could see more with the naked eye?
Yes.
Okay. I'm going to refer the witness to State's Exhibit 4 on your monitor there. And let me know when you can see that.
Okay, I can see it.
And do you recognize that exhibit?
I do.
And what is that?
This is a nighttime view of that same photo. That was just same view, looking west, and I can see the disturbance in the gravel.
And what tells you that this is the same photograph as the last one, as Exhibit 3.2?
You can see the Hall of Flags. That's direct, almost the top of the photo. In the middle, you got the Hall of Flags. You can see the tent in the grass area, the direct line of sight with the Sorensen building, and I'm on top of the gravel of the Losee building, southwest side.
Is there also an LDS temple that's depicted in that photograph?
There is. It's going to be on the top left of the photo. It's lit up.
Okay. Do you know who took this photo?
I do.
And who took this photo?
Melissa Richards.
And who is Melissa Richards?
She's the lead senior forensic for the state of Utah
Okay.
examiner.
And how do you know that she took this photograph?
I spoke to her.
Okay.
Hearsay.
Let's renew the objection to hearsay that's in our standing objection.
Thank you. Mr. Grunander, do you want to respond to the objection about hearsay?
Yes, Judge. Under Rule 1102, hearsay is admissible to establish the foundation for or the authenticity of any exhibit. That's found in 1102 sub B sub 3. I would also point out for the court that under Rule 1101, which is the applicability of the rules, in subsection C1, The determination of questions of fact preliminary to admissibility of evidence when it's determined under Rule 104, which are preliminary questions, the rules of evidence do not apply. 104 speaks directly to laying foundation for an exhibit. So even at trial, hearsay is admissible to establish the foundation of an exhibit. I would also just point the court to State v. Griffin. This is a 2016 Utah Supreme Court case. The citation is 384 Pacific 3rd 186, which stands for hearsay evidence is admissible to establish the foundation of an exhibit even at trial. And we're at a preliminary hearing today, Judge.
All right. Anything further, Ms. Nestor, before I issue a ruling?
No, Your Honor.
All right. I'm going to overrule the objection to hearsay. I note the standing objection by defense. I also note Rule 1102, and I also look to Article 1, Section 12 of the Utah Constitution, which states nothing in this Constitution shall preclude the use of reliable hearsay evidence as defined by statute or rule in whole or in part at any preliminary examination to determine probable cause or at any pretrial proceeding with respect to release of defendant if appropriate discovery is allowed as defined by statute or rule. For those reasons, I'm going to overrule the objection, and as it relates to reliable hearsay, in this instance, you may proceed.
Officer Bagley, did you ask Ms. Richards if this was a fair and accurate depiction of this scene on the Losee building on the night of September 10th, 2025?
Yes,
And what did she tell you?
she said it was.
Okay. Your Honor, the state offers State's Exhibit 4.
Ms. Nestor?
Just object to relying on what Ms. Richards told him in terms of creating the foundation and refer back to our standing objection.
The state will submit it.
All right. Well, as I look at State's Exhibit 4, and again, I'm just looking at it before me, it said it was a fair and accurate representation. There's a notation, I mean, in the previous exhibits, there's a marker, exhibit marker, and I see 2, but it also appears to be other artifacts on this image that I haven't heard any testimony about, and so.
I will follow up, Judge.
All right.
Officer Bagley, do you see an evidence tag in that exhibit?
Yes, I do in number 2.
A number 2, and that's yellow and black.
Yes.
Do you see other evidence markers that are red in color?
Yes, they are, to me, they're orange, but they're triangular shaped.
Okay. Were those markers, the evidence tag 2, as well as the orange or red markers, present when you observed that scene that day?
No.
Okay. Were they present, however, when Ms. Richards took this photograph?
Yes.
And she indicated to you that that is a fair and accurate representation of what she observed that night?
Yes.
State would move to admit Exhibit 4, Judge.
Ms. Nestor?
Objections, Your Honor.
Thank you, Ms. Nestor. I'm going to go ahead and overrule the objection, noting that the marker, evidence marker, as well as the red or orange markers, I can't tell which color it is, was not present originally. And with those included information, State's Exhibit 4 is admitted into evidence and may be published.
Thank you. State would move to publish that.
All right.
And I would ask for the witness to come down to explain the exhibit.
All right, officer, if you'd like to step down, use the microphone, and as previously noted, describe, when you're describing something on the image, where it is located on the image for the benefit of our recording.
So, officer, will you describe for the court what it is that you're looking at?
So what I'm looking at is, I'm on top of the Losee building, which is where the gravel is on towards the bottom center. I'm looking west towards the tent, which is in the upper center, that you got a white tent. You can see the grass down there in the amphitheater. You got the Hall of Flags that's more towards the top center, and behind that you got I-15. But what I'm looking at is in the disturbance of the gravel is what I saw that day.
Okay, and what can you describe for the record that disturbance?
To me, when I got up there and I could see this disturbance of gravel, to me, it looks like a sniper pad, a person that has been laying in a prone position, and you've got markings of elbows, knees, and feet to where somebody was in the line of sight of where Charlie's tent was.
Thank you. And if we could, again, take the, if we could publish State's Exhibit number 2. You recognize that, right, officer?
Yes, I do.
Where on the Losee rooftop did you observe this disturbance in the gravel?
If you go to the
Can you
center
point
of the
to that?
picture, if you go to the center of the picture in the darker gray part of it, on the left side, so the south side of the Losee building, it would be right in the line of sight of the Charlie Kirk tent that's straight in front of it,
Okay,
or the southwest side of the roof.
thank you. You can take your seat. And finally, I would direct the witness's attention to State's Exhibit number 5 on the monitor. Let me know when that's there.
It is.
It is
Yes.
there. Do you recognize that exhibit?
I do.
And what is that?
This is going to be a picture of the side profile of that last photo we looked at with some red or orange markers and a number 2 with also a tape that's there on top of the Losee building.
What was that tape that you said?
There's a measuring tape, it looks like.
Okay. Are you able to tell which direction the photographer was facing?
Yes,
And what direction is that?
it's facing south.
This is a nighttime photograph, correct?
Yes,
Do you know who took this picture?
I do.
And who took the picture?
It was Mauser Richards.
The same individual that you spoke about before?
Yes,
Did you ask her whether this is a fair and accurate depiction of what she observed that
Yes.
night?
yes.
What did she say?
She said it was.
With respect to what you observed that day, apart from the evidence tag, the yellow tag, as well as the orange or red markers, is this a fair and accurate depiction of what you observed?
Yes.
What's different about what you observed as far as what's on the photograph, the previous exhibit, compared to this?
You can see more of the length of an individual. So you can see that more, there's 2 elbows, 2 knee areas, plus also towards the far right of the photo is also a marker where like somebody laid a gun down.
Okay.
It's like a prone position.
Your Honor, pursuant to Rule 1102, as well as other authority that's been cited today, the state offers State's Exhibit 5 into evidence.
Your Honor, we renew all the same objections we made to Exhibit 4.
Thank you. Given the foundation that has been laid and that the witness has testified that this is a fair and accurate representation of the scene, noting the tape as well as the markers in that, State's Exhibit 5 is admitted into evidence and may be published.
State moves to publish Exhibit 5, Judge.
All right.
Before turning to what you did next on that day, taking you back to the daytime of September 10th, 2025, did you secure the rooftop of the Losee building that day?
Yes, I did.
And how did you do that?
I put yellow police crime scene tape around the portion where, so nobody else would disturb that area.
And when you say that area, what areas are you talking about?
I'm talking about the roof where it was the southwest side of the roof where I found the disturbed gravel, where it looked like somebody had been proned out in the line of sight of the tent. So right there.
Did you secure the area as far as any of the entrance area up onto the rooftop with police tape?
Yeah, so then where that natural guardrail is, that was the other barrier where they were advised not to go any further from there other than police officers.
Okay. If we could go back to State's Exhibit number 2.
Well, certainly police officers have never contaminated a crime scene ever.
If we were to zoom in on this photograph, are you able to see the police tape that you put up on the rooftop of the Losee Center, officer?
Yes, you would be able to.
Kimberly, if we can zoom in. Officer, I'm going to have you come down and describe for the court where you put that police tape up to secure that scene, the rooftop area. On the southwest corner of the rooftop.
So this is the top of the Losee building. You got your two different grays. The southwest is towards the top, center of the picture. You can see some yellow tape that spans from over here on the far right side of the picture by these black pipes, goes around a silver vent, comes back down around to the corner of that silver to keep everybody out of that area where that prone position was at.
Okay. On that photograph, are you able to see where you put the tape up as far as the access way to that roof near the stairway?
So it was right here, actually, this natural barrier where you have to climb over the guardrail. So this is the elder barrier that I had set up.
And you put police tape on that?
Yeah.
Okay. Did you eventually leave that area?
I did.
Do you recall about what time you left that area?
Oh, I have it in my notes. It would be, when I left that area, it was almost 1 o'clock, about 1:03, 1:01.
Okay. Before leaving, did you leave the scene with anyone?
I did not leave the scene. Or did I leave the scene to somebody? Yes, I
Just
did.
to someone else?
Yes.
And who was that?
It was a county deputy, a female.
Did you provide instructions to her?
I did.
And what were those instructions?
I advised her not to let anybody inside the crime scene
Okay.
without being a police officer or an investigator.
Okay. Thank you. You can take your seat again. Officer, upon seeing this disturbance in the gravel, you've described what it looked like to you?
Yes.
Someone lying down in a prone position, correct?
Yes.
What did you do next?
So when I got to the top of the Losee building during that day, I noticed a screwdriver, kept going to the edge, found that prone position. At that moment, I realized, because it was direct line of sight, plus the disturbance in the gravel, where I could see somebody laid down in a prone position or a sniper position, and asked dispatch to get on the then I realized that we probably didn't have our shooter in custody. From that moment, I asked dispatch to get on the camera system and to see if anybody was on top of the Losee building during the time of the incident.
Were you advised of anything?
I was. Dispatch came back and advised me that there was a male individual on top of the roof that was there at the time of the shooting.
Did they describe what his movements were?
They did. They stated that he ran to the edge, dropped down, crawled, got in a prone position.
I'm going to stop you right there. Ran to the edge. What direction and what edge?
Running west and southwest of the Losee building. So ran towards the tent of where Charlie Kirk was, so they could get a line of sight. And then the individual stood up after the shooting and ran northeast on the top of the Losee building.
Okay. You mentioned that this individual on the video dropped off the edge. Did you get that?
I haven't
far?
mentioned that.
Oh, what happened? What else was described to you?
Then, well, at that moment, so I knew that there was possibly a shooter on the run.
Your Honor, can we just have a continuing objection to all of the hearsay that's being testified to here?
And Judge, my response to that was I'm not actually offering this for the truth of the matter asserted at this point, simply for the effect on the hearer. So I'm not offering what's been described in the video as substantive evidence.
All right, Ms. Nestor, with that clarification, any thoughts?
I'll just stand on the objection. I don't think, I mean, he's clearly offering it for the truth because he's asking him to describe the route of the individual, and it's based on what other people told him. So if he wants to circle back to it after he's put the video in, I mean, we could do that, but right now I still think it's inappropriate hearsay, Your Honor.
All right. Anything further, Mr. Remember?
I'll submit it to the court.
All right, so as the magistrate, as this is not to a jury, it's to myself as a magistrate, I am not accepting that statement for the truth of the matter asserted, simply for what has been stated. So I'm specifically making that finding as I'm receiving this evidence, and I'm not accepting it for the truth of the matter asserted, only as represented by Mr. Grunander. And with that, the objection is overruled. Mr. Grunander, you may proceed.
Thank you, Judge. So you mentioned you were provided with information that an individual was running north on the Losee rooftop, correct?
Yes.
What else was described to you?
At that moment, I knew I had responding units coming into the scene. I advised other officers that I needed the Losee building secured, searched, because I didn't know exactly what way that, other than he ran north. That moment, I went down to the police department, which is just down the stairwell, and looked at the video myself. And
Where is the police department located?
it's in the Gunther Trade Building, just directly to the south of the Losee building.
Okay.
So where I described those outside stairs, the building to the left of that or south would be the Gunther Trade Building.
Okay. On what level is the police department?
It's level 3.
Level 3, okay. Upon arriving at the police department, what did you do next then?
I then look at the footage to verify for myself exactly what expired on that moment, where I could see an individual run to the edge, get up, and then run off, and then drop off the northeast side of the building, of the Losee building.
Okay. Having viewed that, what did you do next?
At that moment, I realized I had more crimes, a bigger crime scene that I needed to contain and preserve for evidence. At that moment, I went and grabbed some more crime scene tape, and I responded to the northeast side of the building and secured an area where I saw impressions of the shoe print inside the grass, and also up above on that northeast side of the building, I could see on the cement where someone had scuffed there and then dropped down to the shoe imprint and then finished going northeast.
Okay. If I can take the witness back to State's Exhibit 2. You mentioned seeing an individual drop down. Could you come down and point that area out to the court?
Yes. Okay, this is the Losee building again on the top right center of the photo. Southwest side is where the individual was laying down prone in the line of sight, came behind the aquarium or atrium, came behind that on the west side of it, came up to the north side of the Losee building on the east on this white square piece on the far right of the picture. And then he dropped off on the east side of the Losee building into the grass down here below.
So the northeast corner.
Yes, northeast corner.
You mentioned you observed something on the grass.
I did. I saw a shoe imprint that was embedded pretty deep right there next to where he dropped off.
And this is all footage that you personally observed on the
Yes.
surveillance video?
Yes.
Okay. When you got to the scene, describe in as best detail as you can what you saw on the grass then.
So when I got to the scene, I could see that there was a shoe imprint there. When I looked up onto the cement from the roof, I could see some scratching or rub marks from the top of the roof that was not there. So I could see that looked abnormal. I then decided to put crime scene tape around the whole area in case there was more evidence that needed to be preserved.
On that exhibit number 2, do you see where you placed the crime scene tape?
Yes, I do.
And where is that? Can you describe that to the court?
It's going to be on the far right in the center of the picture. You can see the yellow tape. I came around trees, came up further out of pictures, some more trees. I came down all the way down to the back side of the LDS Institute building where there's a sidewalk to block everybody out of coming up that way.
Okay. Did you at one point leave the scene?
I did.
Did you release the scene to anyone?
Yes, I did.
And who was that?
There was 2 Payson police officers that were standing there.
Okay. Were they in uniform?
They were.
Did you provide them with any instructions?
I advised them not to let anybody inside the crime scene other than law enforcement or investigators.
Okay. You can take your seat again, Officer Bagley. You've talked about the disturbance in the gravel that was observed on the Losee building.
Yes,
Did you walk through that disturbance in the gravel?
I did not.
Did you otherwise touch it in any way?
No,
With respect to the shoe print that you observed on the grass on the northeast lawn area below the Losee building, did you walk through that?
I did not.
Did you otherwise disturb that?
No.
Did anyone else?
Officer Bagley, what did you do next?
From that moment, I then released the scene. I went down to the Fugo building and knew that where the Instant Command Center was at, so I could relay information that I'd found to responding units and people in charge.
If I can have just a moment, Judge.
You may.
State will pass the witness, Judge.
All right.
All right,
Ms.
time for
Nestor?
defense cross-exam, if any. Oh, there will be. And Kathy's going to do it. Well, this will be charming.
Ms. Nestor, before you begin, what time would you like to break for lunch? I don't want to interrupt a line of questioning, and so I just want to make sure that we're just taking a look at the clock and when you feel is a good time to break, roughly in that 12:10 range.
I will aim for that, Your Honor. That shouldn't be a problem.
Okay, thank you. You may proceed.
May it please the court.
Yes.
Good afternoon, or morning still.
Morning.
Officer Bagley, my name is Kathy Nestor. I'm one of the attorneys representing Mr. Robinson today, and I do have some questions for you.
Okay.
So you mentioned that you checked in around 11 a.m. on the day of the shooting. Is that right?
Yes.
Did you know in advance there was going to be this event on campus?
I did. I signed up for an overtime shift, so yes. For
You
the special
signed-
event, I signed up for the overtime shift.
Got it. And so did you attend any type of debrief or briefing or meeting to prepare for the security of this event?
I did not, because that morning when I got there, we had individuals on top of the Hall of Flags. So when I walked in, I just checked on, was going to get my uniform on. The chief Long got a text or an email or phone call stating that there's people on top of the Hall of Flags throwing stuff down to the tent. Therefore, he sent the two officers that were on duty down to secure the area. I got dressed and then came back and then went to the Hall of Flags to secure that area.
So you never attended any kind of, I'll just use the word debrief or meeting to talk about what the officers on scene were going to do that day to keep everybody safe?
No, not that morning.
Do you know if there was such a meeting?
I don't know, because when I got there, it was starting to, people were throwing stuff down on the tent.
And do you know how many UVU
That's not very
officers you guys employ normally?
Employee, there was 15.
And do you know how many were assigned to cover that event that day?
That were assigned to cover it. There was 6 of us that were, there was a patrol one and then 5 others that were there with the chief.
Did you all have an idea there were going to be thousands and thousands of people there? Or was that a surprise to you?
Had an idea.
And you only had 5 officers?
6, yes.
6, I'm sorry, counting you, I was
Yes.
thinking. And of those 6 officers, are you all armed? Do you carry weapons?
Yes.
What type of weapons do you carry?
Glock, pistols.
And was there any use on campus of, I think they're called magnetometers, but the machines you walk through at
Security.
TSA and the airport where it checks to see if you're carrying anything metal, what we all had to go through to get in the courtroom. Were there any machines like that set up or being used on campus that day?
No.
And as far as you know, were there any drones that were flying above campus that day?
Not that I know of.
And did anyone ever talk to you about covering anything near or on top of or in the Losee building? Were you ever assigned that area before the shooting?
No,
Do you know who was?
I don't.
And when you got up to the roof that afternoon, was anybody around that was law enforcement?
No,
Nobody on the roof?
no,
Nobody on the stairway?
no,
Nobody on the walkway?
no.
Okay. And in the state of Utah, is a campus a gun-free zone? Are students allowed to have guns on campus?
It's an open carry state, so yes.
And did you see anybody that was armed that day other than law enforcement?
I did not see.
Were you aware of whether Mr. Kirk had his own security team present there with him?
Yes.
Did you communicate with any of those people?
I saw one individual that was on top of the hall flags right next to me, yes.
Okay, and that was before the shooting.
Yes, and then I saw several down in the crowds and down by him, yes.
And were you aware of whether that person was armed either?
I was aware he was armed.
Okay. Was there any other law enforcement agency besides Mr. Kirk's private security team and your 6 officers, including you, that were covering that event that day? In other words, did you have any Provo police or Orem police or anyone that you knew of, or federal agencies?
I don't know.
You never saw any that day?
No, not until the response came in.
And you did mention, I think I heard you just a few minutes ago testify, you turned over the scene on the roof to a woman who was a deputy sheriff, right?
Yes,
And that you turned over the scene where the individual dropped off to, I believe you said, was it Orem Police?
Payson.
Payson Police, thank you. Those people weren't there till after the shooting, right? They were part of just a response of everybody in the area?
Correct.
Okay. Did you receive any type of briefing materials, written materials prior to the event that talked about who would be covering what or anything like that?
No, not that morning. Like I said, it started getting hectic, so we were trying to get down there to secure the area and push people away from the top of the tent.
Now, when this event was over, you prepared a report, is that right?
I did.
And in the report, it covers a lot of what you testified to with Mr. Grunander, doesn't it?
Yes.
And I think you said you attended, what, 600 hours of post-training?
It's around 600 hours, yes.
And I'm sure somewhere in that training, you were taught the importance of your police report
Yes.
and how it will be relied on years later to recreate events like it's being done right now. And so you know it's really important to be as accurate as possible in your report.
Yep.
Can we put up Bagley 1? Can we switch it over to the defense table, please? Thank you so much. And show it only to the witness. This is.
All right.
Do you see that report in front of you?
I do.
And is that the report that you prepared, or did you prepare this report?
I didn't, I did a supplement on it. I didn't prepare the report. So like, because the incident was a big agency assist, so obviously it says, it has all the responding officers to that effect.
Oh, we need to go to the page. Thank you for pointing that out. Can we please move to page 3 or 5 maybe? Let me look and see.
Know your exhibit, Kathy. It's okay. She wants to impeach him on something in his report, or else bring out something that he wrote down that didn't already come out in the testimony. This
All
is
right, now,
classic
Let me
cross
ask the
technique.
question again. Sorry, we just had the cover sheet up. Is that your report?
Yes, this is.
All right, and did you prepare that?
I did.
When did you prepare this report?
It looks like it was done the next day, either that day or the next day, because I wanted to make sure that I had it done, where everything was fresh on my mind.
And do you have a copy of it in front of you?
I do, as a matter of fact.
May I just step in and just make sure that it's the same one? May I approach, Your Honor?
You may.
Make sure it's not his secret report. They sneak their little report up there and then read from it and refer to it instead of being formally refreshed on the record.
And this is, we got to ask this now. Did you use AI to help you prepare your report?
I did not.
Okay, good. When you prepared your report, you referenced when you first heard the shot, don't you?
Yes.
And what is the time that you say that you heard the shot?
12:23.
Right. And when you wrote that report, you did not state in your report the direction you heard that shot come from, did you?
No, apparently not.
And take your time and look at the whole report and see if there's anywhere in there where you ever mentioned that it came from the east or to your right.
I don't see a direction.
Okay. And you also, I believe, in your report, you also don't state whether or not, you don't mention anything about thinking it came from the Losee building or anything like that, right?
Later on, when I recognized when I saw the empty holsters, I think I actually said that in there, where I see the empty holster, that I realized the line of sight.
Okay, so let's talk about that holster for a minute. So you heard the shot, and you only heard one shot, correct?
Yes,
And then you came down from the walkway above the tent, right?
yes,
And you came down to really the grassy area that we've all been looking at, the courtyard.
yes,
And there was kind of chaos, people running around,
yep,
yes? And while you were down there, you saw what you said was an empty holster.
yeah. As I was clearing people out and making sure that the evidence was preserved, about towards the top, after a little bit, I saw an empty holster sitting there.
And when you say towards the top, can you be specific and tell us where you were?
So on the south side in the courtyard, there's some tiers of seating where the grass is different levels, and it was towards the top, maybe just right before the cement is where everybody's standing. So there's different levels, is towards the top on the grass.
And when you saw the holster, can you describe to me what it looked like?
An empty concealed holster
For what type of
for a
weapon?
pistol.
Okay. And did it have any markings on it?
I didn't even, no, not that I noticed.
And what
Like
happened to that
Appendix
holster?
carry
no idea.
thing, or?
Did you ever take custody of it?
Nope,
Did you ever tell anyone else to take custody of it?
nope,
You just left it on the grass?
I did.
Was it ever fingerprinted to your knowledge?
I have no idea.
Okay. At some point, there were drones in the air, is that right? Did you become aware of that?
Yes, I was made aware of that.
Right. Do you know who put the drones in the air?
Sergeant Cam Nelson with the Provo Police Department.
Right. So it wasn't UVU?
No,
Did you guys even have drone capability? Did you have a drone on campus that you used?
no,
All right. So someone would have had to bring one after the shooting onto campus because you wouldn't have had one there.
true.
Right. You mentioned that as you were coming down into the grassy area from the top above the tent, you come down the Hall of Flags, you come into the grassy area. You mentioned that you heard, I guess on your radio, that they had a suspect in custody.
Yes.
Right. And so how long do you think between the shot being fired, did you hear that?
I was in, like I said, trying to get down the stairs, jumping over people, trying not to step on people as people were fighting up. Within 30 seconds, maybe.
Right. So they pretty much instantly had someone in custody.
Yes, and that's why I was quite surprised.
Were you aware of where the person was taken into custody?
Right down by where Charlie Kirk was sitting by his tent, somewhere down there.
So in the courtyard area, the person would have been in the courtyard area at the time of the shooting.
Yes.
Was that person in or near or around the holster in any way?
No.
You don't know?
No, he wasn't. Where the
you
holster was up on the top level up there, and it was where when the incident happened, when Charlie got shot, within seconds, the other officer that was down by him said that he was in custody with the prisoner of the shooter. So it had been
So
within right there.
you didn't, at that time, it was your understanding the person they took into custody was close by Mr. Kirk, is that right?
Yep.
But it didn't occur to you that, well, that's not where I heard the shot come from. They must have the wrong person. I should talk to somebody.
During the chaos moment, no. They said they had a person in custody. I figured those guys saw something I didn't see. They took the person in custody, and I thought that was him.
Okay. This would be a good stopping place because I'm about to start another section.
Okay.
So maybe we could go 5 minutes early for lunch.
Absolutely. All right. Thank you.
Thank you, officer.
We're going to go ahead and break for lunch. We'll come back at 1 o'clock. I do want to note for the camera operator, if you would just be cognizant and turn off the microphone during breaks and when we break for recess, that would be helpful. Does either party need the benefit of the record before we break for lunch?
Not the state, no.
All right. We are in recess.
All right.
1 hour for lunch. Well, so far nothing particularly revolutionary, but this holster is new. I don't recall ever hearing that before. There was a empty holster found at the top of kind of what they're describing as the amphitheater area. Not a lot of detail about this holster. Holsters aren't usually going to be like specific to a particular gun or particular brand, but they'll hold like a certain size of a certain type. So like, you know, a 9mm automatic generally is going to fit. A 38mm or 38 caliber snub nose is going to fit in, another one. And then, I'm assuming if it's sitting loose on the grass, that it's not something like a shoulder holster that's going to be strapped to your body. It's going to be more like a clip holster that sits on the inside of your waistband or sits on your waist or something like that. He did say concealed carry. So not something that was being openly carried. Inside the waistband seems like probably a fairly logical assumption, but I would just be curious. Be curious. If they didn't collect it, then I guess we'll never know what kind of gun fits into this holster. He didn't say it didn't get collected, but there's a reason why she's asking about it. And he obviously didn't know anything that happened to it. So not ideal, I would think. Gun holster. Not collected. May or may not be significant, but it definitely points to one of the key problems that always comes up. Very, very common in criminal cases. Situations like this where there is a kind of fog of war sort of thing going on. It's a dynamic situation. It's changing. You're responding both to, we need to address an immediate threat to the security of everybody present, at the same time, trying to preserve evidence and information and stuff that we would need to recreate what happened and, get the evidence and prosecute and so forth. So a lot of stuff going on in that type of situation. Real strong tendency for the tunnel vision to set in. It's always a challenge. And in many ways, I think that the fact that that didn't just focus on George Zinn, that's who they're talking about, the suspect that was originally taken into custody. That was George Zinn. He is apparently a fairly well-known crank in Utah. He would show up at events and political meetings and things like that all the time and heckle people. Kind of fortunate that the tunnel vision wasn't like George Zinn. That's it. We're done. Nothing else to see here. And he continued to look at the Losee Center and find all this, find this stuff within a very short period of time after the shooting took place, because you need that for your provenance to show these didn't get formed hours later when some investigator was looking for possible angles of sight or whatever and got on the roof of the Losee Center and laid down in the prone position and then left the markings. You need to be able to attribute those markings to a suspect. So the timing here is pretty fortuitous in that sense. But still, we're going to have aspects of the tunnel vision, the in the moment, kind of evaluating what's important and what requires focus and follow up and what doesn't. And once you've already got it in your mind that you know what happened, then that's, what tends to be focused on. And anything that isn't consistent with that gets kind of filtered out. And I think that's the explanation, assuming this empty holster never got collected, never got followed up on, is because of the tunnel vision. They'd already decided it's not relevant. It's not relevant because it didn't belong to George Zinn. It wasn't in the same location as he was. And it's not a rifle shot, which he testified, he and the chief were both like, yeah, that's a rifle shot. Don't think it was a handgun. But the problem is when they're wrong about the assumption, the initial assumption. I don't know that there's a lot you can do about this. This is kind of like I said, this is human reaction, and this is what we are programmed to do. We are programmed to filter and process information, to prioritize what matters and what doesn't, form snap judgments. It's all pretty fundamental to the human condition. It's what makes us the thinking animal. But it just isn't good. Nevertheless, when that kind of thing, the filter is a little too strong, sometimes it can leave stuff by the wayside, and maybe it matters, maybe it doesn't. Not sure there's a whole lot here in this case, other than here we are seeing the defense have something that they can point to. Oh, you had tunnel vision and there was a gun holster sitting right there after there was a gunshot that killed Charlie Kirk, and you didn't even collect it. You just saw it and left. The chief was there with him. Maybe the chief took care of it. Who knows? Who knows? But interesting new piece of information. Also, don't think I had heard about the shoe prints in the grass at the northeast corner of the Losee Center, below where the individual dropped off the roof. Don't know if that was documented. Assume it was, but might not be a safe assumption. Again, it's hard to say in this particular context, where we are really getting just a very broad overview of the case and the evidence. We are not getting the detailed description of everything that was done and everybody who was there and every part that they played in the process that we're likely to get at trial. In trial, despite this kind of record being laid by Mr. Grunander, oh, hey, when we get to trial, we're going to be able to use hearsay to establish the foundation for various exhibits. That might be, nevertheless, he's less likely to do it anyway. They will bring in Melissa Richards to testify about the photographs that she took and to identify them and tell us what she saw and confirm that they reflect what she saw at the time that she saw it. And it's just because of the different process and the different burden of proof. You're presenting it to a jury. Jury might have different questions than a judge does. Jury might be more skeptical of certain things. Jury might not be willing to give law enforcement the benefit of the doubt. None of these things are bad things or problems or whatever. They're just factors that influence the decisions you make about how to present your case, knowing that a jury is going to have to find this beyond a reasonable doubt at the trial. So we're likely to get a lot more of those types of details at trial, and maybe some of these questions will be answered. there's always a lot of strategy that goes on in a hearing like this, because cases are cards that you hold and that you play. And the defense has a major structural advantage in that respect, because the defendant doesn't have an obligation to testify or to say anything at all. Of course, got a Fifth Amendment privilege against self-incrimination. Doesn't have to say anything at all, but he's also got a right to testify on his own behalf. So a lot of the defense strategy is built around holding your cards as close to the vest as you can. You don't want to give anything away. It's an advantage that you have that, you know, it's not that you get to ambush the other side. It's not really that straightforward. But you don't have to lay out everything that you're working with and what your theory is. So part of what is happening at this hearing is a little bit of tipping of the cards, right? The prosecution is now on notice that the defense has pointed out there's an issue with the holster. So they can anticipate, you know, defense has this card. They might be playing this at trial too. What's a jury going to think about this? How do we want to handle it? They have foreknowledge of a potential issue. Lots of questions, of course, about the security. Was there a security meeting beforehand? You know, seems like it wasn't necessarily very extensive, wasn't necessarily very resourced. He had to go to the top of the Hall of Flags because there were people up there throwing stuff onto the tent. This does not give me a good feeling at all. At all. Like, the tent is there, the facilities are there. Okay, they've been installed, set up, you know, whatever you want to call it. This is 11 o'clock. This is an hour and 20 minutes before the shooting. I would think, like, all the cameras in place, all the sound equipment is in place, like all of the other things that go into this kind of an event. All of that was like just open, where people could be on the roof of the center and, like, I don't know, drop stuff down on it. This is not, this isn't good. This is just not the kind of tight security that you might hope for, expect. For somebody not just high profile, but also controversial. Somebody who's a bit of a lightning rod. It's kind of the whole point. That was the whole point of the prove me wrong. Is inviting people with different opinions, and not everybody is really able to do that. Have those kinds of conversations, entertain competing ideas and so forth. Not everybody is able to do that peacefully and calmly, as we've seen. So that to me is just, oy, like this should have been a red flag. It really should have, from the very beginning. People on top of the Hall of Flags with just access right there. Unrestricted until this cop got there and shoot him off. Who knows what they could have done before then? Who knows what other people could have done before then? If it's that loose on top of the Hall of Flags, why would I think it's tight anywhere else? It's just, it's a shame. It's a shame. It just seems like a lot of minimization of the potential risks of something like this. And I don't know, it's just a shame that something has to happen, I guess, to really emphasize. Guess you shouldn't have taken that for granted, but kind of seems like that's what happened. They just didn't think it would happen. Kind of loosey-goosey about the details. And of course, there is going to be circumspection by the people involved about all this. Why? Because there's potential liability on the part, say, primarily of UVU, because it's their premises. They're the ones who own the property. They're the ones who authorized this event to take place. They're the ones who are the primary target for a claim that you permitted an unreasonably unsafe condition here on this campus. So UVU is not going to want to, get into a lot of detail about what they did security-wise and when, because they're already anticipating, if we haven't already been sued, I don't think they have. I haven't seen anything. Maybe attendees or something. I haven't seen anything that I remember, but they're anticipating it. They're anticipating a negligence claim that because of their security failings, that culminated in Charlie Kirk's death. Not saying that claim is a winner, has merit, nothing at all, just that for a lawyer, it's really easy to anticipate that. And so UVU is going to have plenty of lawyers who are going to anticipate that, who are very likely counseling UVU witnesses. Just try to say as little as you possibly can about all that. Don't need to give any evidence, any information that could potentially open the door to a liability problem. But yeah, I gotta say, its description is really not covering the security apparatus in any kind of glory here. Well, so not a whole lot this morning. As far as our highlights, we've got, just been Christopher Bagley all morning. UVU Police Department, main takeaways from him. I heard a gunshot. It was a rifle. It was not a handgun. Why? Because it was a crack, not a bang. He saw the screwdriver on the roof of the Losee Center. He saw the impression on the roof that he is referred to as the sniper pad. He refers to that as a sniper pad based on his description of it, showing impressions from elbows, knees, and feet. Which would be, I guess, yeah, like the pointy parts where your body would be lying in the prone position. And then also the shoe impression on the grass on the northeast corner where the video showed the shooter coming down off the building, or at least the man coming down off the building in that area. Nothing real revolutionary so far, but just getting some of those details filled in. I did see a comment going through the chat. Sometimes I catch them, sometimes I don't. But I did see one coming through about how, just noticing how the screwdriver wasn't mentioned in any of the initial probable cause stuff. And that's right. It's not. The screwdriver isn't in there. And I suspect, I don't know, but I suspect that the reason why it wasn't mentioned is because they weren't yet sure at that point if it had any connection with the shooting or not. It's a screwdriver in and of itself. It's not incriminating. It's not a murder weapon or anything like that. It is something, some maintenance guy could have been up there and it fell out of his bag or something like that. I mean, these things could happen. And so the connection with it, we know now. We know from Kash Patel, and we know from some of the other filings that have been made public in the case that have talked about this, that the state claims Tyler's DNA is on the screwdriver. And that's the connection. But they wouldn't have had that at the time Tyler was arrested. They would have developed that after the fact, because you have to get Tyler's DNA. And now, granted, today you can do this type of testing pretty quickly. Doesn't take days to run a profile and compare it to a sample. But nevertheless, it's like they wouldn't have started any of that until after they had Tyler in custody. If he's not cooperating, then you get a warrant for his DNA, you swab him, send it all off to the lab, go through the testing. It's all post-arrest. So that's my suspicion for why the screwdriver is not in any of that charging information in the charging document, is because they weren't able to substantiate the suspicion that it had something to do with the shooting until after they were able to develop the DNA evidence. I was talking about something when they came on in court, and now I don't remember what it was. Oh, it was the authentication for the photographs. The authentication for the photographs, and kind of what's going on with these objections that are being raised. Yeah, I mean they've kind of summarized it here in court. I did pull up 2 at least of the cases. I think it's just the 2. Now he gave us a 3rd, but I haven't pulled it up yet. The cases that Mr. Grunander came prepared for us with, Purcell and Wager. Looks like it's Wager, W-A-G-E-R. And these cases are kind of confirming what are pretty well understood standards for the admission of evidence by trial lawyers. So any evidence, this is where I was, any evidence that has to be, that's being offered for admission into court is predicated on some at least minimal showing that this thing is legit. It is what you say it is. You don't get to just like walk in with a piece of paper and wave it and say, I have this piece of paper, I'm offering it into evidence. Admit it. No, it has to be relevant. It has to be authentic. There has to be some basis to like know what it is and what it has to do with the case. But the standard for authenticity is really not very high. It basically just requires somebody to testify it is what I say it is. And so there's different ways you can do that. You can have the photographer come in and say, yeah, I took it. It's what I saw. I haven't altered it. I haven't photoshopped it. Maybe if I cropped it or like zoomed into one part of it or something like that, I'll explain the process that I used to generate it. You can do it that way, but it's not required. Authenticity for a photograph is established by somebody. I mean, it can be established by somebody who saw what the photograph is depicting, comparing their memory of what they remember to what is there on the photograph and saying, yeah, those things line up. That's what I remember. It's accurately depicting what I remember. And so, for example, you can use things like, oh, you want to establish where something took place? You can pull pictures off of Google Maps, for example, as long as you have somebody who can look at it and say, yeah, that's an accurate description, accurate depiction of this place. I'm familiar with the place. I know the roads. I know the buildings. This is what they look like. It's not misleading, hasn't been altered. That's enough. That's enough to get the foundation in for a photograph. So clearly they are using the more minimal method here for this hearing, given its purposes, given you have the judge that is the decision maker. When we get to the jury trial, it might be a different situation. Might see a lot more detail about some of those things. Amy Abadi. Sorry, I meant when they leave during the actual trial. Sorry, I already we got in the middle of your comments here. I believe this was about Erica Kirk leaving the courtroom. I did see on Twitter, apparently she did at one point. Judge told us right after the break, she's gonna get accommodated. They're not going to force her to sit in there for all or nothing. They are going to allow her to come and go. And that is because, as the victim representative, she doesn't have the same status as everybody else who's a member of the public, everybody who's the press that's present. She has special rights under the Utah Constitution as the victim representative. So she is going to be treated differently. And that will carry over through the trial as well. Hypothetically, let's entertain a hypothetical, because now we're talking years down the road and something that may happen or may never happen. But let's just say hypothetically, she's leaving and coming back a lot, Yes, I suppose there could come a point where the judge might be like, look, this is maybe a little disruptive to the jury. If the jury is like, you know, getting distracted, paying attention to what Erica is doing, then they might revisit it. Barring that, they're going to accommodate her, and that will carry out through the trial as well. Amy Abadi, do you think any of the exhibits will be denied by the judge? Well, good question. Let's go ahead. Let's just go ahead and pull the, take us off of KSL for a second there. Let's go ahead and pull up that exhibit list. What do we have so far? Oops, yikes. We've got the drone images 1, 2, and 3 are already in. 3.1, 3.2, 4, 5. These are all already in. These are all photographs. A lot of what is coming is video. And so here we see, for example, okay, video 6. Exhibit number 6, it's accompanied by this 6.1 written statement, 1102 of A. Wright. Exhibit 6, video of mother with children in the crowd. This statement by A. Wright is almost certainly going to be a statement by the photographer, saying what it is and what they photographed, and that it's not AI generated, and it was, you know, taken when they were there personally present at the event and so forth. If that's what it is, that's going to establish the foundation for this photo or for this video, then he's going to allow it in. Same thing with this 1102 statement for the video of the shooting from behind the questioner, video of the shooting from behind Charlie Kirk. Comes with a written statement from the TPUSA authenticating the footage from their cameras. Video 9, shooting from behind the booth, doesn't have the accompanying written statement. Don't know why not. Maybe they won't offer it. I don't know. We're going to have to see how that gets handled. Barring any other kind of witness who's going to say, like, this is the position I was in and I saw this, and this video accurately depicts it, this one might potentially have a foundation problem just because there's no statement associated with it. Not really expecting any of these witnesses testifying to be percipient witnesses, people who were there testifying about what they saw and heard. I think this particular Officer Bagley that we have right now is the main one that's going to give us that kind of perspective. Switch my banner here while I'm thinking about it. But that one could potentially, you know, be an issue for authenticity. So we'll see about that. A lot of the photos, same thing. It's just going to be somebody testifying. It's accurately showing what I saw. So this is likely to be law enforcement witnesses. Medical examiner report. How are they going to get that in? Likely from whoever the lead detective is. They call them case agent. These agents with the State Bureau of Investigation in Utah. Utah State is the lead agency for the investigation. This is a state crime, a state prosecution. They have had a lot of agency assistance. 28 law enforcement agencies and organizations that have provided discoverable materials related to the investigation. But Utah State Bureau of Investigation is the lead. So probably they have a lead case agent. Can't even say that with a straight face. It's a lead investigator. Everybody knows it's a lead investigator, and nobody cares about your word games, Sergeant Buchanan. Nobody cares. Anyway, you Karen Reed folks know why. That's a bit of a hot button issue. I would expect the medical examiner report is going to come in from somebody like the lead investigator who, again, under these reliable hearsay rules, he's got the ability to talk about information that he's received from other people involved in the investigation. And so I received this report from the medical examiner. Yeah, that's going to likely qualify for admission. Variety of, we've got UVU and then doorbell surveillance footage, as well as another 1102 statement. The UVU surveillance we may get authenticated through Mr. Bagley, since he testified. He was already, he has seen it. He's familiar with the system and so forth. So we might get to this from him. The doorbell cameras, though, that will also remain to be seen, how that is authenticated. The written statement of Mike Mitchell. Mike Mitchell is almost certainly the retired Washington County Deputy Sheriff who assisted with Tyler Robinson's surrender. We have a video at the Sheriff's Office on September 11th, 2025. That will need to be authenticated. We'll have to see how that's done. The recorded statement of Lance Twiggs. This is likely to be self-authenticating, meaning it's certified and signed, but actually possibly not. So somebody will likely need to testify, you know, about the process of obtaining this statement from Mr. Twiggs, and then that will be admissible. The text messages, the Discord chats, the photograph of the note. So these are all what we know so far anyway. These are all things that law enforcement documented immediately when it came to their attention. And so this is very normal, very standard. They're talking to a witness. The witness is like, hey, I have all this information on my phone. Police are instantly going to be like, great, let me photograph that. Let me video that while you're scrolling through it. So they can preserve it as the witness is presenting it to them. Now, it is not the best evidence of any of what they are being shown. The best evidence is the digital record that exists on that device. And so they will get the device and they will extract the device and they will obtain that original digital file. But not until, you know, later, not until later in the process. And we do know that they did that in this case because we've got search warrants. We've seen the search warrants for the devices, many devices, but that includes Tyler's phone as well as Lance's phone. Because once again, they didn't have any of that when they made their initial charging decision, the initial arrest and charging decision. It's only going to come after they talk to Lance, after they get his phone, after they go through the extraction process, after they review what's in the extraction and document everything. They're not going to have all that right off the bat. But what they do have is those initial preservation things that the law enforcement did. Photograph the things on the phone, screenshot, show the videos, whatever, anything they can do to get a record right now, because things can happen with phones. People can delete things, yes, is the obvious one. People can have a remote kill switch on the phone, you know, destroy it, but also just, you know, not malevolent, malicious things, like people can drop their phone in the bathtub, like it does happen. And then what? Then where are you if you haven't preserved it? Nobody was intending to destroy it. Nevertheless, it no longer exists. You got a problem with your case. So that's why I'm expecting these particular items here are going to be the photographs, the initial things that were preserved by law enforcement. One, because this is what they relied on for the charging decision, right? Not the extraction that would have occurred later down the road, and it would have been for the purpose of corroborating and you know, again, like obtaining the raw data for these particular materials. But that wasn't, they didn't have it when they decided they were going to charge him. This is what they had. So that's part of the reason why they're presenting it. Another reason is just to avoid issues with the defense as far as notice, discovery, opportunity to prepare, and things like that. This is a very big case. There's a massive volume of information that has been produced. There's a lot for the defense to go through. They've already gone on record saying they weren't going to be able to review all of the discovery before the preliminary hearing last time. That was their justification for a continuance. Judge Graff bought it, gave them the continuance. So there's a lot of stuff to go through. And when you're talking about going through like phone extractions and things like that, yeah, these can be extremely voluminous. I mean, obviously there's a lot of information on your phone, and that's not even just the stuff you know about. There's like a massive amount of stuff that you don't even know about because it's relating to the internal processes of the phone, the things the phone is doing while you're interacting with it, or even sometimes while you're not. And all of this stuff is creating records and helping the digital forensics people understand what the phone is doing. Once they know what the phone is doing, they know whether the phone is acting in a way that is predictable and normal and what you expect in these types of circumstances, or if there is something hinky here, something looks funny. Strange artifact here with a timestamp of 2:27 a.m. What could that possibly mean? That's the kind of thing that they're looking for. So if the prosecution is relying on extraction, digital extraction evidence, one, they're going to have to call an expert for that. It's just, one more thing, one more expense, one more preparation, stuff like that. But they also, I think, run the risk of the defense objecting that there's so much of all of this. We can't possibly be prepared to meaningfully review and, all of the extractions from all of these devices, get our expert reviewing it prepared to counter whatever the state's expert says. It's kind of escalating to a little bit more of a trial level of evidence testing, which is absolutely going to happen when and if we get to the trial. That's how it's going to be. But because this relates to the charging decision, you can just avoid that entire headache and that entire risk by look, this is what we had that we relied on for the arrest. That's what we're going to use. And at the same time, by the way, they have already turned over all of the extractions to the defense. That happened a couple months ago. So the defense has had all of the original raw digital files from the phone, from the computers, from the cloud, from all the different things that they pulled that digital data from. So they are in a position to go and check some of this stuff, right? They have his phone extraction. And so they've been given a photograph of a Discord chat. It's going to have a date and time stamp on it. Yeah, they're going to have the extraction. They can go into the extraction and compare and see if it's there. And so if it isn't, we're going to hear about it. If it's not there, guys, we're going to hear about it. The FBI press release photographs, that might come in through this guy because they were just screenshots from the video surveillance footage. So probably whoever authenticates the video surveillance is going to authenticate these as well. Photos of the rounds from the rifle. Again, these are likely to be the investigators. Photo of the round from the apartment, the burnt note from the apartment, the targets, basically everything recovered from the apartment, likely to be the officers who took it. And then the expert reports. And that once again will be like the autopsy report. I'd expect that to come in through the lead detective with the Utah State Bureau of Investigation, but we will have to see. So based on that, that was a long look at the evidence list, just so that we can talk about whether any of the exhibits will be denied by the judge or not. And so those are the reasons I think probably most of them are going to come in. I mean, that's the gist of the objection is foundation. The foundation, to me, looking at it, looks pretty easy to establish for most of them. A couple of them might have some questions, video of, somebody in the crowd or whatever. It might need a little bit more to verify it, but basically until we see what the state's kind of proffer is on what's going on with all that, just going to have that ready. So when it comes up, I see it. yeah, assuming the state can meet that proffer, then I don't think it's going to be difficult. I don't think it's going to be a problem. And yes, all of them will come in. To Truth for Liberty. I know the hearing has been a little dry, which can make you thirsty. Does anyone here want a Hawaiian punch? There's got to be a joke here. That's whoosh. I'm not getting this one. Is there like a Charlie Kirk Hawaiian punch thing? Did he like Hawaiian punch? Is it it's not an LDS thing. I know that. Guys, there is, for those of you who are unaware, there is the word of wisdom is handed down by the LDS Church, and there is a part of the Book of Mormon, Doctrine and Covenants, 89 verses 8 and 9, which forbids the use of tobacco and hot drinks. Tobacco and hot drinks. And then as well, the word of wisdom advocates against using substances that can harm you or enslave you to addiction. And so based on that, there is an official word of wisdom about beverages that is issued by the Church of Jesus Christ of Latter-day Saints. Breaks them up into some categories. Some drinks are perfectly fine. Others, really clearly not okay. Some in the middle. You got to use some moderation. Not necessarily harmful to you per se, but overdo it, and that could violate the Doctrine and Covenants. And so that's probably where the Hawaiian punch would lie, I would suspect, because it's a lot of sugar. A lot of sugar, not inherently bad for you, actually quite necessary for human metabolism. But yeah, if that's all you drank, probably wouldn't be so healthy. So somewhere in the middle of that. Anyway, I'm not a big fan of Hawaiian punch myself. Now, the Gatorade fruit punch, I'm a sucker. Love it. That red Gatorade. That's yeah, I'll get that one every time. Of course, in moderation when you need your electrolytes. But just Hawaiian punch per se, can't say that's necessarily what I would be running through. Now, I of course have my silver needle white tea. Made myself a couple little things of it before we got started here, so I don't have to worry about getting dry. Although I will pause briefly during our lunch break here to go refill. Kyle Cowden, re-slingshot student DR, heard the actual bullet followed by the report. Okay, so that is definitely a clarification, and that does make some sense as well, because the bullet itself is going to make noise going through the air, like you're going to hear it whiz by. But that's going to be a separate sound from the explosive sound that is emanating from the rifle where the explosive action is taking place to fire the bullet, and so forth. So good explanation there as well, Kyle. You must be a gun guy. You must be a gun guy. You can tear me apart if I say something stupid about in the waistband holsters. I'm not a gun ignoramus, nor am I a gun expert. So, all right, we have, just a straight super chat here from Deborah Lee ND. Thank you so much for that, Deborah. Appreciate that. To Truth for Liberty. How does reasonable doubt play into determining probable cause apart from the credibility of a witness? It doesn't. Probable cause has nothing to do with reasonable doubt. These are basically just different levels of certainty. This goes back to one of my favorite things. I mentioned it at the top of the show here, epistemic humility. Our legal system is structured around a premise of epistemic humility, which is just basically, you're not as smart as you think you are. So you need to be cautious about what you know or what you think you know. How cautious do you need to be? That depends on what's at stake. And so we're right now at the preliminary hearing stage. It's important to be cautious, but we're also not going to be like sending anybody to prison based on what's happening at this hearing right here today. The standard, therefore, is very low. It's just, is there enough here to reasonably think he committed this crime? That's it. Doesn't have to be a probability, doesn't have to be a 51%, doesn't have to be a more likely than not even. It's just, after we see all this evidence, reasonable to think it might be him. That's all you have to do. So the level of epistemic certainty required is quite low. But as we're getting further along in the process, and now, yeah, not only is somebody's liberty at stake with what you think you know, but their life, okay? Death penalty case. You're going to put somebody potentially in front of a firing squad and let go at them with, dozen pieces of lead or whatever. It's not really how it works, but anyway, it doesn't matter. You're going to take somebody's life. You better be extremely freaking certain. And so that's why the trial standard is beyond a reasonable doubt. It's not no doubt at all, right? They don't have to rule out stupid, implausible explanations. You don't have to accept that just because, for example, there is a holster to a pistol that was left, maybe. Nobody seemed to really care about collecting this holster that was up there at the top of the amphitheater. These are the types of things that the defense looks for to generate reasonable doubt about, right? Because they want people to think there's a plausible alternative explanation for what we see, what happened, what the evidence is beyond the state's theory. The state's theory is pointing the finger directly at my client, and they're saying, here's how the evidence adds up to my client being guilty. And so the defense is always looking for things that could potentially undermine that or could potentially suggest, okay, well, maybe you do have some evidence against my client, but there's potentially other evidence that you haven't ruled out that might implicate other people. And if you can't rule out that somebody else did it, then that means you can't say beyond a reasonable doubt that my client did. So that's what cases are built around. The issue, though, is that your alternative explanation really does have to be plausible for the jury to consider it. The jury's not idiots. The jury isn't going to be like, oh, the aliens could have done it. How is the prosecution going to disprove that aliens did it? You're not going to disprove that aliens did it. What you are going to do is prove that the evidence that you do have is consistent with your theory. And the alien theory doesn't account for the existence of the evidence that you have. If aliens came down and killed Charlie Kirk, we would have to explain how that is consistent with the guy on the roof of the Losee Center and the .30 caliber bullet fragments found in Charlie's body during his autopsy, and et cetera, the Discord chats, all of that stuff. All of the evidence has to be accounted for in your alternative theory if this reasonable doubt approach is likely to work. So that's kind of where we're at. Hopefully that explains the difference a little bit. They really don't relate to each other than they are just different levels of certainty. And so they call for different levels of epistemic humility. At this point, because we are just charging and we are just alleging you did this, Mr. Robinson, you can be less certain. You can be just pretty sure. But when it comes time to test the evidence to decide if he did it and should lose his life for it, you need to be a lot more certain than that. To Truth for Liberty, part from at Easy Eye 8513. Once the officer acknowledged a suspect was arrested, up close location, the discarded holster should have become important. Well, they're trying to get out ahead of it already, right? Two ways that they said it didn't really matter, right? Distancing, it didn't matter. It was totally okay that we had our tunnel vision. Didn't harm us this time. We know it didn't matter because number one, he said it was a rifle shot, not a handgun. So handgun holster wouldn't have mattered. Handgun wouldn't have mattered. Handgun wasn't the shot that I heard. That was part of it. Not saying any of this is like good or strong or valid or whatever. I'm just saying this is the justification. And then second, to the extent that they thought they had the shooter in custody anyway, because they went and grabbed George Zen. George Zen had jumped up, I did it, or whatever, you know, he did the distraction thing. George Zen wasn't near that holster. He was up close near to Charlie Kirk. The holster was up towards the top level of the amphitheater. That's how he described it. So it wasn't connected with the noise that he heard, wasn't connected with the person that he had in custody. That's how they're going to distance themselves from it. And yeah, you know, like I said, still got a lot to see in this case. A lot of reasons to think that the belief that he was shot with a rifle and not with a firearm is going to be substantiated. Again, the bullet fragments are going to be a big piece of that. Bullet fragments recovered during the autopsy. But it's just a real warning, a cautionary, like you kind of got lucky, guys. You got lucky that maybe your tunnel vision didn't bite you this time, but really wasn't a good thing to just walk past and not pay a lot of attention to, because you could have been wrong and you got lucky. You got lucky. But that's kind of maybe all it is. I don't know. We'll see. Not a good thing. Definitely not a good thing. But there's also going to be lots of stuff like that too. By the way, I don't want to like catastrophize or make it sound like this is, you know, big mishandling or something like that. It's just not ideal. But very few investigations are ideal, particularly ones that are happening in the moment as events are unfolding like this one. Because like I said, there's just too much going on and there are priorities that conflict. I mean, your number one priority during an active shooting incident like this is safety. You get everybody safe. And if that means that you have to walk in areas that you would prefer otherwise not to because there could be evidence there that you could contaminate, it doesn't matter. You do it anyway because the safety takes the priority. And then only after the scene is secured, you're assured that there isn't an ongoing risk to people present, then okay, you can shift your priority to now it's time to preserve the evidence that's available. So it's not a perfect world. And there's always going to be, you know, decisions like that they aren't ideal because humans are not perfect. The question is just going to be, how significant is it in the grand scheme of things in light of the totality of the evidence, which in this case, they're going to suggest it's small because we already knew it wasn't a pistol. We already knew it was a rifle. It was small. But then also just, yeah, how reasonable is their explanation? Does it make sense? Does it sound like they're kind of making crappy excuses that you don't really buy? Like, you know, I don't know, oh, the Sally Port just always records things backwards and nobody knew, you know? You get to evaluate the credibility of the explanation, at least the jury does. Judge is a little bit more limited in this preliminary hearing context, but the jury certainly would be able to listen to this explanation and think to themselves, okay, is that plausible or not? And if you don't think it's plausible, then you don't necessarily have to give that explanation a lot of weight. The jury gets to decide all those things. But if you think it is, that's all you need. You're satisfied. Okay, they figured it was a rifle. That's why they didn't. Would have been nice if they had, but is it the game-changing piece of evidence? Why or why not? It's going to all fit into the totality of what gets presented. I hate bringing up chats like this because you're very sweet and I have to, but it just make me awkward. I love pussycat. Side note, you look beautiful. Hashtag hottest cat mom. You're too kind. You're going to make me blush. The cats have, I heard somebody was making some noise earlier, but nobody has come in to visit me yet. So I imagine that will be just a matter of time. And we had a new member. I Love Pussycats is now a YouTube member. Welcome to the channel. Really appreciate all that support. All right, guys. So we are reaching the point where I am going to hit the pause. I'm not ending the stream or anything like that. I am just going to take myself off camera briefly so that I can do my rounds, check my trees, brew myself some more tea for the afternoon session. Do feel free to hang out and chat amongst yourselves, because I will be back. But give me a couple moments to prepare for the afternoon session, and bear with me as I step away. Thanks, guys. I am back and court is back. Let me get it up.
I do want to circle back before I start my new section on I just want to specify two things. First of all, we talked about that you had no briefing or no materials about security on campus for this particular event. Did you ever have any operational or tactical plan that you were given for that event?
For this event, no.
Okay. And you also mentioned that you've done SWAT in the past.
Yes.
Were you a sniper?
I worked well with them, but I was not a sniper.
Okay. So when okay, just strike that. Also, we talked about the holster that was found. Are you aware if there were any other guns confiscated on the scene that day?
I'm not.
You don't know one way or the other?
I don't know.
All right, now I want to go through with you your timeline. You mentioned that you started at the Hall of Flags, right? And then you came down. It took you a minute to kind of navigate the stairs with the crowd and the chaos and everything. And then you were in the grassy area of the courtyard for a bit. Is that right?
Yeah, so about 30 seconds to get down the stairs, and then I went right down to where the tent was.
And that's where you found the holster.
No, the holster was up higher. So I went down by the tent, so it's lower level. So as I came down towards where Charlie Kirk was shot, I went down towards the tent to assess, to see what was going on down there, because I didn't know exactly what. I heard the gunshot, didn't know exactly what was going on. 'Cause
I'm
was
sorry,
above the
I
tent.
missed that you went down to the tent. So let me ask you about that. So what did you do when you got down to the tent?
When I got down to the tent, Charlie was gone. They put him in an SUV and left. At that moment, there were still some people running around, so I decided to preserve the scene as much as I could with trying to escort people out, and that's why I went back in and started pushing people off the grass area to conserve any ammunition or any casings or anything to that effect that would be around. I wanted to make sure people were off and there was as much evidence preserved as possible.
So just to be clear, by the time you got to the tent, Mr. Kirk had already been removed and taken from the scene. Is that right?
Yes.
Okay. So in your professional opinion, what was the perimeter of the crime scene?
What do you mean by the parameter?
The perimeter, like how far did this crime scene stretch? Like where did you want people to move off of?
Oh, well, at first I wanted them all off the grass because, like I said, I thought we had a suspect in custody. So to me, it would be a close encounter. So I was trying to push everybody off the grass in case there were shell casings or to that effect that got on the grass. So after I pushed them off to that part and getting up to the top where I saw that empty holster, when I saw that empty holster is when things started slowing down for me a little bit. All the chaos and stuff that's when I realized that it was a rifle shot, not a handgun shot.
Okay. And that's when you saw the Losee building and it occurred to you should go check it out.
Yes, it was right in my line of sight.
And correct me if I'm wrong, but the whole time that this is going on, you had an active body camera on your, I guess your collar, is that right?
I was right here on my
Your
chest, yes.
Okay, and it was on.
Yes,
And it appears to me from reviewing your body camera that there was another individual who was with you that went to the Losee building who was in civilian clothing but appeared to have a gun. Who was
Yes.
that?
I don't know who he was exactly. He had a badge on, and I had somebody with me to back me up as I ran up the stairs to make sure I had somebody with me.
So you don't know what agency he's from or where he's from?
No,
And it looked like he had a pistol.
yes.
Is that right?
A handgun, yes.
Or a handgun.
Yeah,
And so the two of you go to the Losee building.
yes.
When you reviewed the videotape at the police department later, did you check to see if anyone had been on the Losee building after the shooting, after this individual had jumped off that you've already talked about? Was there anybody else on the roof? Did you check and see in that gap of time?
In that gap of time, no. So once I put up the barrier, I only walked up to about that point, then I went down and reviewed the video from that moment on.
So are you able to say for one way or the other if anyone else had been on that roof in between when the person jumped off the building and when you came on the roof? Are you able to say one way or the other?
There was people up there looking for an individual that ran that way, because when I first got told the individual ran heading north, we didn't know where the shooter was, so we started climbing up and looking, clearing the building. And it wasn't until I went to the PD and actually saw him jump off of the building that I knew he was off the building.
Let me rephrase that because I think I either asked it badly or you misunderstood.
He didn't
me. So
answer it well.
Let me go back again. So from the time that the individual that you spotted on the video jumped off the roof, right? The individual that you thought was in the prone position.
Okay.
Between that and when you got on the roof, did you ever check to see if anybody else had been on the roof in that period of time?
Yeah, and I didn't see anybody.
So you
I
did
didn't notice
watch,
anybody.
you didn't, did you look on the video to see that entire, okay, that's what I'm asking. So you did not review the video to see if there was someone between you, that individual jumping off and you coming on, if anybody had been on or disturbed
No.
that scene in any way? Okay. But once you put the tape up, then we're confident from that point on the scene was preserved, right? By the way, where did you get that tape?
Officers responded on the scene that he was down on the bottom and threw it up to me, so
Okay. So you didn't have it on you?
no,
And you didn't leave the scene to go get it?
no,
Someone threw it up?
yes.
Great. All right. While you were on the roof, did you encounter any spent casings?
As a matter of fact, no, that's why when I saw the prone position where a person would be laying down a sniper, being around guns and snipers all the time, I was looking for a spent shell casing. I couldn't see one. I was looking over the edge, looking all over the place, making sure the gravel wasn't disturbed, and I couldn't find a shell casing at that moment.
And that would be, the reason you would be looking for that was because some types of guns, when they shoot, eject a casing automatically, right? Some
Yes.
do, some don't.
Yes,
All right. And then you also didn't find any unshot bullets?
no,
Okay. Are you aware of there being a bullet found on another roof? in the
I'm not. aware.
Vicinity? Were you aware of another bullet being found on the scene, not on the roof of the Losee building?
No,
All right, your body cam footage that I reviewed appears to end while you're still on the roof. Do you know why that is?
I think the battery went dead. It was just right at that moment.
Okay. And do you know, did you ever turn it back on that day or go get it, I don't know, what do you have to do, charge it or stick a new battery in it? I don't even know.
Usually dock it, but no, I didn't go back. It was too chaotic running around.
So that 27-minute and 35-second body cam that starts when you're at the Hall of Flags and ends while you're still on the roof, but haven't put the crime tape up yet, that's the only body cam you have that day?
Yes,
All right. You mentioned when you went to the police department, you watched the video where you saw an individual up on the roof,
Yes.
right? And that individual was in the vicinity where you saw the disturbance in the gravel.
Yes,
And when you looked at that video, were you able to identify the individual's face?
I know.
Were you able to identify any markings on their clothing?
I know.
Were you able to identify their height?
No.
When we looked at the picture of the, I think you called it the sniper perch, so I'm going to use your words. It looked like there was a measuring tape laid out next to it. Were you present when they measured like the distance, like how tall that person would have been?
I was not.
So you don't know what that is?
I don't.
Were you able to tell the person's weight from the video that you saw?
I can tell he wasn't heavy set. So
Okay.
More of a skinnier person.
Could you identify what shoes they were wearing?
I could not.
Could you identify anything about a hat or what was on their head?
Not at the moment, no, I couldn't.
Okay. And did you see a gun in the video?
I saw a long black object in the left hand as he was running across the roof.
And in fact, did you describe that in your report as a bag?
I don't know. I have no idea. I don't know why.
All right, let's pull that report back up, please. Oh, never mind. I don't think you mentioned what you saw. So in your report, let's pull that back up, please, page 5 on the Bagley one. So looking at the second page, you're actually going to have to go to page 6, I think. You talk about what you saw in the video where they jumped off the roof. And again, I'm going to remind you of our conversation we had before about you understand how important these reports are.
Yep.
And do you mention anywhere in this report that you saw a gun?
I did not. I just had an object.
Did you mention that you saw that object? Is that on here?
Nope.
Okay, so you left that out. Now, have you looked at that over and over again?
The video? No,
Yeah.
I've only seen it twice.
Oh, really?
Yep.
When's the last time you saw it?
It's been months.
Okay. The last time you saw it, were you able to tell what that object was in his hand?
Yes.
Now-
Well, not tell what it is. I could see there's an object in that left hand. Yes.
And could you, knowing what you know about the case today, do you have an idea about what that object was?
It looks like a rifle or something to that effect. A long object.
It looks like a rifle?
Like a long object, like skinny and long. You can see it's like almost like it's covered over something.
So you saw the cover, which was the towel, right?
Yes, and the shape of it is long.
Okay.
You know.
So you can see a towel, but you can't see an actual
I don't know if it
gun.
was a towel or a blanket. I don't know
He
what
said
it
it's a
was.
rifle shape, Kathy.
But you can't see an
You
actual
dug
gun.
yourself a hole.
No,
video.
like an object, like a form of a gun, like a long.
This isn't going to get
object.
better for you. He's just going to keep repeating it.
All right. At the end of that day, what time did you leave the campus?
I was probably like 9 o'clock that night, maybe somewhere around there.
And did you come back the next morning and work some more?
I came back the next morning, yes.
And you worked all day the next day?
On and off.
When you left at 9 p.m., did you or anyone else know who the shooter was on that day?
I know, not that I know of.
And when you came back the next morning and worked that afternoon, all that day, did you or anybody on that campus know who the shooter was?
Not that I know of.
Okay. So nothing that you found that day or anyone else to your knowledge on campus was able to identify who the shooter was?
And that day, no.
Right.
Well, during the time I was there, no, that I knew of.
I also want to talk to you about that giant picture that was showed to you. Do you know,
Exhibit 35, I think.
yes, it's Exhibit 35. Do you know who took that picture, where it came from?
I do not.
Do you know how old it is?
I have no idea.
Okay. And the pictures you were shown exhibits 1, 2, and 3 that you got up and kind of talked about and showed all the buildings and everything. Do you have any knowledge about where those pictures came from? Or
I
who
guess
took
they were
them?
drone footage, just taken from a drone.
Do you know who was operating the drone? Like
Sergeant Cam Nielsen from Provo Police Department.
Provo Police Department. Had you seen those pictures before today?
Before today, yes.
When did you see them?
A couple weeks ago.
And that was just in preparation for testifying?
Yes.
Prior to that, had you ever seen those pictures? Can I have the court's indulgence for just a moment, Your Honor?
You may, Ms.
Just one
Nestor.
moment. One last thing I want to clarify. We heard you testify that Ms. Richards, or I don't know if she's Deputy Richards,
She's a state employee for the forensic lab.
so Ms.
Melissa.
Richards.
Melissa.
She is the one who took those nighttime pictures of the stuff on the roof.
Yes.
And you testified that she told you that that was what they looked like that day?
Yes.
When did you meet with her?
I talked to her on the phone. It was several weeks ago in preparation for the trial.
So prior to a couple weeks ago, you never discussed those pictures with
Yeah,
her?
because I'd never seen them.
Oh, so a couple weeks ago is the first time you saw them?
Yeah.
All right. And did you write any kind of supplement to your report, to add on to your report, other than what we've gone through today, that one report you wrote? Have you ever written another one?
I have not.
Okay. That's all I have. Thank you, Your Honor. I tender the witness.
Thank you, Ms. Nestor. Mr. Grunander, redirect.
Just one question, I believe, Judge.
All right.
Officer Bagley, if we could pull up State's Exhibit 1.
All right, let's do that.
You've talked about this handgun holster that you observed
Yes.
on the grass in the courtyard.
Yes.
I'm going to ask you if you would approach the monitor when it comes up and point out as best you can where you observed that holster, okay? Oh, here we are.
Now they are going to
So
let
again,
him
the
show
question
it.
is where was that holster lying when you observed it?
So again, this is the picture of the courtyard area facing north. On the south end down here, you got different tiers of grass. On this top tier back here in this area, which is more the center, bottom left of the photo. So it's going to be, the waterfall's on the left side, so more towards the top of it. On the south side by the Fugal building, that top tier of grass is about where it was at.
In the middle area of that,
Yes.
by the Fugal building? Okay,
And that's where I could see straight up where the line of sight was.
okay. Thank you. Nothing further, Judge.
All right, may this witness be excused.
Yes, Your Honor.
Yes.
Thank you. Thank you, officer.
So they must have had a little chat about the camera being able to go to the screen. But the media lawyers had something to say.
Just for the benefit of those in attendance, you may have noticed that I drink some water. Please, if you have water and what's been previously approved, don't hesitate. You can drink, just don't spill it. And let's go to the state. Ready to proceed with your next witness?
Thank you, Judge. The state calls David Hull.
All right. Would you like to come forward and be sworn in?
You do solemnly swear that the testimony you shall give in the case now pending before the court will be the truth, the whole truth, and nothing but the truth, so help you God.
All right, if you'd like to be seated right here at the witness, in the witness seat, and once you're situated, there's a bottle of water to your left. And if you wouldn't mind, after you're seated, bringing that microphone closer to you so it picks up your voice. All right, counsel?
Thank you,
whenever
Judge.
you're ready.
Is he not the nicest judge?
Good afternoon.
He's so nice.
Would you please state your full name and spell your last?
David Hull, Hull.
And are you employed?
I am, yes.
Who are you employed by?
I'm employed by the Department of Public Safety.
And how long have you worked for the Department of Public Safety?
I'm in my 12th year.
Are you a peace officer?
I am, yes.
Are you post-certified?
I am, yes.
When did you receive your certification?
2015.
And since that time, has your certification remained intact? In other words, has it lapsed or been taken away or anything like that?
No, it's been continuous.
I think you said you're in your 12th year. Did you already say that? Your 12th year with the DPS? Have you worked for any other law enforcement agency besides the DPS?
No, just the state of Utah.
What is your current assignment with the Department of Public Safety?
Currently positioned as an investigative sergeant at Peace Officer Standards and Training.
Was that your assignment in September of 2025?
No, it was not.
What was your assignment then?
I was under the State Bureau of Investigations, Major Crimes Division as an investigator.
Okay. Is SBI an acronym or an acronym that's commonly used to describe the State Bureau of Investigation?
It is, yes.
I can refer to it as the SBI and we're all on the same page, right?
Yep.
Okay. How long were you with the SBI?
A little over 7 years.
And what exactly did you do? What was your assignment with the SBI?
I spent just under a year in the Alcohol Bureau.
One more time.
And the undercover unit, and then the remainder of that time was with major crimes.
Major crimes. What did that entail?
Predominantly investigating crimes that are considered to be major in nature. Predominantly violent crime, including homicide, sexual assault, in some cases fraud cases. Kind of covered a whole gambit of things, but predominantly violent crime.
And throughout your career with the DPS, have you done any training related to murder investigations specifically?
Yes, I have.
And could you just briefly describe what that specific training entailed?
I've done internal and external courses around lead homicide investigation, officer-involved critical incidents, child deaths and unexplained deaths in children, aquatic homicide, and then just continuing investigations related to homicide itself.
And throughout your career with DPS, have you either played a role in or led a homicide investigation?
I have, yes.
How many do you think?
Either directly or indirectly, I've probably been involved in approximately 40 or so.
And is that throughout the state of Utah?
Yes, we assist throughout the state of Utah.
Were you working September 10th of 2025?
I was, yes.
And did you work shifts? Did you work a certain shift that day, or how does it work at the SBI?
Kind of work 24/7, 365, but predominantly Monday through Thursday, office hours.
Okay. On that date, were you asked to respond to the campus of Utah Valley University?
I was, yeah. I was at the office in Taylorsville, and I was asked to respond down to
Asking
Utah
the
Valley
important
University.
questions.
Okay, and what did you understand was going on at UVU that day?
I didn't know much. I had been told that there was some kind of an event and an individual had been shot.
Did you have a name?
Someone had told me that Charlie Kirk had been shot.
At that point in time, were you familiar with Charlie Kirk?
I was not, no.
Did you end up responding? So when you found out that there was an event, that it was Charlie Kirk that had been shot, that was while you're still up in Taylorsville at your office?
Yes, we hadn't been asked to respond at that point. Another agent in the office showed me a video of the shooting, and I went back to work because we hadn't been asked to respond at that point.
At some point, though, were you asked to respond or directed to respond to Utah
Yes.
Valley?
Yes, we were. We were asked
Okay.
to make our way down to the university to provide any kind of assistance that was needed.
Okay, and do you recall who directed you to come down to Utah Valley?
I believe it was Lieutenant Jensen.
And is that something, responding to a scene like this, on a report like that, is that something that's done frequently within the SBI?
Yeah, SBI functions as a supplementary investigative division for really anybody in the state who needs it, whether it's a smaller local agency that just needs additional resources. We often respond with the crime lab to help process crime scenes. But it would be normal for us to be called out to assist another agency.
Okay, so we understand correctly, when you were first directed to come down to Utah Valley, you were just coming down to give whatever help you could provide.
Correct.
Okay. That eventually changed.
Yes, yeah.
Okay.
My assumption was we were responding to assist process a crime scene, essentially.
Prior to September 10th, 2025, how familiar were you with the Utah Valley University campus?
Not very. I think I maybe had been there once before.
How about from September 10th onward? Did you become more familiar with the campus?
Became a lot more familiar with the campus, yes.
And in what way or how?
Both in walking the campus and looking at the incident scene, in viewing surveillance video of the campus and the surrounding areas, and just my general involvement in the investigation. I became a lot more familiar with the buildings, the amphitheater and the surrounding area, and the campus itself.
All right, and we'll come back to that here in a moment. Who else responded to UVU from the SBI?
Originally, I thought it was just myself and a couple of others. I remember Sergeant Falmina, Sergeant Bricker, Sergeant L. Schultz, Sergeant Clark, Agent Brian Davis, and a number of other agents were arriving or were on scene when I arrived there.
Do you recall if other law enforcement agencies responded that same day?
Yes, there was a large law enforcement presence. Federal entities, I believe the FBI, the DEA, ATF, I think some U.S. Marshals. There was obviously our state presence, and then there was county and city and local agencies on scene also.
So had all these folks responded
Everybody.
by the time you got here?
Everybody was
or
there.
Had they responded prior to, or?
Some could have been on scene prior to, some were arriving while I was arriving, others arrived later. I know there were several forensic units from various entities, including the State Crime Lab and other agencies.
And did you interact with all these different agencies? You personally?
Throughout the course of the following few days, probably the majority of them, yes.
I think you related that originally the SBI was directed to come down just to see if you could help. Is that fair to say?
Yeah, that was all I knew when I left the office, was that go down and see what services, what can you do to help.
And I asked you earlier if that role changed, and I believe you said it did.
Mm-hmm.
So let's talk about that. How did your role change from what you initially came down to do to whatever it evolved into?
Having been on scene for a little while, there were some conversations and discussions that took place. And I was informed by my lieutenant that myself and Agent Davis would be taking lead on the investigation on behalf of the State Bureau of Investigations.
So the SBI was going to be
You got the
lead
short straw.
investigative agency,
Correct.
and you were going to be the lead case agent,
Yes, sir.
along with Agent
Davis.
Davis.
Yep.
Okay. What does it mean to be the lead investigator or the lead case agent?
Depends on the situation, but predominantly you're responsible for kind of directing the investigation, coordinating information that is coming in. Typically, scenes are fairly chaotic initially, so you're trying to process as much information as possible and make as much use of the available resources that you have. Kind of an organizational role would probably be a good way to describe it.
Okay, so you played an active role in organizing.
In coordination with the administrations of all of the agencies that were on scene, yeah, we were trying to coordinate efforts and get to pertinent information as quickly as possible.
Do you recall whether assignments were made, at least with the SBI agents that responded with you?
Yeah, we have a core group within major crimes that were assigned specific tasks.
Okay. And do they include the agents that you mentioned just a minute ago?
Yes, I believe so.
So each one of those agents with the SBI were given a specific assignment?
Yes, with the information we had, the agents were assigned to do specific things.
And do you remember specifically what assignments were given to whom?
Yes, Sergeant Falmina was asked to coordinate with the State Crime Lab and the responding crime scene techs to manage and process any identified crime scenes. Sergeant Mark Bricker was put in touch with UVU's surveillance and operations team to start working through any available footage or information that we had that had been recorded. Sergeant Clark was tasked with the area canvas around the campus area, looking for information or any available information from the immediate area around campus. Sergeant L. Schultz was working with the SIAC and other administration to try and manage the flow of information that had started to occur.
Okay. You said that initially when you showed up, things were a bit chaotic.
Yes.
Did that have something to do with all the different agencies that had responded?
Yes, and I think initially there was still some uncertainty as to whether we were working with an active shooter or an active crime scene. The campus is spread over a large area, and so getting that deemed to be safe is quite a process and involved a lot of people.
Gotcha. Do you know if the campus was deemed safe eventually?
Eventually, my understanding is the campus was locked down and secured, and we were able to start getting people in to start processing crime scenes and doing additional things.
Okay. You said it sounds like that chaos eventually subsided. You got organized and assignments were made. What was the first thing that you did as lead investigator?
It kind of became organized chaos, but we did have a plan, and our priority was determining whether we had an ability or a way to be able to identify who had been involved in the shooting. Okay. That was our primary focus at that time.
Did that include collecting information that was becoming available?
Yes, we were getting a large volume of information from the general public, phone tips, people sending videos. Analysts were scrolling through social media and social sites as people were posting information onto the internet. So there was a lot of information coming in, a lot of things that needed to be processed through and worked.
Okay, were videos coming in?
Yes, cell phone videos were coming in. If you imagine there's 3,000 people at an event and everybody has a cell phone, there was a lot of information that people were willing to share with us.
Right. Do you know whether you or someone else with the SBI collected or received a video from an Amanda Wright?
Yes, yeah, I know a cell phone video was collected from Amanda Wright.
Okay. And do you know
Amber
who?
Wright.
I'm sorry?
Amber Wright?
Oh, I'm sorry, Amber. Well, you tell me, Amanda or Amber?
Amber.
Okay, I apologize for
Oh, that's funny.
that wrong first name. Do you know
It's a common
who
mistake.
or how that video was collected?
Yeah,
Just
I
ask
spoke with Ms.
Amanda
Wright
Heard.
directly on the phone to arrange a time to go and collect that video. Unfortunately, she wasn't available that day, but Agent Davis was able to go meet with her directly and collect the video.
Do you recall what date you actually spoke to Miss Wright?
If I can refresh my recollection,
Well-
I specifically,
Sure, let me ask you this before you do that.
Yes, sir.
So you have in front of you what, your police report?
I have some notes and a timeline from my
Okay.
investigation that was part of discovery.
And referencing that timeline or those notes, will they help you recall the date that you called Miss Wright?
They will, yes.
Okay. Why don't you go ahead and refer to that? Don't read from it out loud. Just take a minute. Let me know when you've come across that information and once you've refreshed your memory.
Your Honor, when he's done, may I take a look at the materials as well, please?
You may.
Doing
Ms.
proper
Wright was
refreshing now?
contacted on April 7th.
Okay. Did you want?
All right. Ms. Nestor, if you'd like to come forward, you may.
Your Honor.
These are my times and dates. Spreadsheet. Yep.
April 7th seems like a little bit of a wait. 7 months. You waited 7 months after the shooting to go get the video. Maybe it doesn't matter. Not everything's perfect. But that's not exactly ideal.
Mr. Sturgill, when you go back, if you wouldn't mind shifting the lectrum to my right.
You're right.
Yes, it just appears when the camera's focused on you, just the way it's positioned, you're in front of the witness, and we just want to make sure that. It won't go far.
Yeah, it's only going to go that far, Judge.
All right,
Is that going to be far enough?
I think that is sufficient. So, all right, thank you. I appreciate your
Yeah,
help
I
with
did
that.
just check from the, are we still connected?
Judge/stage manager
Okay.
keeping us on
All right,
track
let's
here.
Make sure that Mr. Sturgill is picked up.
You didn't block out your
You may
scene,
proceed.
guys.
Thank you.
And if I can make,
So-
if I can make a correction to that, I think.
Well, let me ask you this first.
So he needs to ask you a
Yeah,
question.
okay.
So, Mr. Sturgill.
So you've had a moment to look at your
Yes,
notes?
sir.
Did that help you
Yep.
remember the date that you contacted Ms. Wright?
It did, yes.
Okay. Why don't you go ahead and tell us what date you contacted Ms. Wright?
I contacted her, I think it was April 6th specifically, but Agent Davis met with her on April 7th.
Okay. Well, that was going to be my next question. So you actually talked to her was it on the phone?
It was, yes.
And did you arrange a time for either you or Agent Davis to go get the video from Ms. Wright? Is
Yes,
that how it happened?
yes,
And then you didn't go, it was Agent Davis that went?
correct.
Okay, gotcha. And what, if anything, has been done with that video in preparation for today?
My understanding is that some edits were made by your office in order to protect some of the participants in the video.
Okay. But let me ask you this. Did you or Agent Davis visit with Ms. Wright again?
Yes, that was in April, and that was where my correction was. The video was originally provided to Agent Mortensen.
Okay.
So I misspoke.
Okay, let's go back and let's make sure this is very clear.
Sure.
Okay.
Yes.
So, someone with the SBI collected a video
Yes.
from
When?
Amber Wright.
Yes, Agent Mortensen contacted Ms. Wright on October 8th, and a video was provided to him electronically on October 11th.
Okay.
Okay.
And now I'll ask the next
A
question.
little more reasonable.
What, if anything, has been done either by you or another agent with that same video in preparation for today's hearing?
We contacted Ms. Wright to arrange a meeting so that Ms. Wright could review the video and that we could verify firsthand with her that the video was what she had taken on September 10th at the event at UVU.
Okay. And who had that follow-up visit with Ms. Wright?
That was Agent Davis. I was not able to attend.
Okay. And you know that happened because you spoke to Agent Davis?
I spoke to Agent Davis, and he provided me with a written statement that Ms. Wright had completed
Okay.
at 11:02.
And so you have seen that written statement?
I have, yes.
Okay. And you've read through it?
I have.
Does that, do you recall whether that statement was on a form or a piece of scratch paper? What do you recall?
My recollection is that it was on an official, I believe, a State Bureau 1102 statement, which is a written form that is filled out by a witness that contains the 1102 warning.
And by that, do you mean the advisory, the statement that's written on that piece of paper is going to be used at a preliminary hearing?
Yes,
It includes that advisory.
yes,
Does it also include a warning that if someone provides a false statement, in this case, Ms. Wright, that it could be punishable by a Class A misdemeanor?
it does, yes.
All right. And what do you recall is the essence of that written statement from Ms. Wright? I mean, what does it basically say?
Object, Your Honor. At this point, we want to assert our standing objection to the constitutionality of allowing in Ms. Wright's statement when she is not here present in court to be cross-examined. We
done that a
did
million
include
times
those
already.
constitutional arguments in our standing objection. Also, this does fall under the type of document that should be safeguarded under Rule 4-202.02, Parent 8, Parent F as in Frank, and/or should be classified as protected under subsection 5O as in orange, because the disclosure could jeopardize the life, safety, or property of the witness. It's also technically of victims. I mean, if she's present under the current theory and the information, she's technically could be classified as a victim of the event.
Yes, she is a
So
victim.
it also should be protected under that. So we would object to it being read in public. It would not be admissible at trial in the current format that it is due to its hearsay nature. We do think it would negatively impact our client's right to a fair trial. And furthermore, I believe the witness herself has requested that, particularly because the video contains images of minor children, which I know the state has made an effort to redact, but nevertheless, the reference to the minors, I think, would still fall under the protection. And so for all those reasons, we would object to that coming out in public and being discussed in the public forum and being published in any way. And we object to it coming in.
All right, and so if you wouldn't mind just restating the rule that you're relying upon, so I can fully look at your objection.
It's the UCJA, the Utah, Code of Judicial Administration. I just blanked. The Utah Code of Judicial Administration for Rule 4-202.02, parenthetical 8, parenthetical F as in Frank, and or parenthetical 5 and parenthetical capital O.
All right, thank you. I'm
Yes,
just
sir.
Kathy,
getting there. I want to review this before I
Kathy,
hear from
it's
Mr.
4R. 4R. Photograph, film, or video of a crime victim. That's the one you're looking for. Private, under the rule. She cited 5-0,
I've
which
reviewed that,
is
Mr. Sturgill.
the
Let
disclosure
me
would
address, I guess, a couple of
jeopardize
things.
life,
Ms.
safety,
Nestor
or
actually brought
property.
up, I think, both the 1102 statement that we intend to introduce and sort of referred to the video. So let me address each of those one at a time. With regards to the 1102 statement that was prepared by Ms. Wright, Judge, it was gathered in compliance with the Utah Rules of Evidence 1102, specifically subsection B8. It's a statement that was gathered by an SBI agent. It was prepared with knowledge of the advisory that it was going to be used at the preliminary hearing, and it also included the warning that if a false statement is given, it's going to be a Class A misdemeanor. Judge, I don't know what additional foundation you'd like. Well, that's kind of where I was going, Judge, is I was trying to lay a little bit more foundation just to introduce that statement alone. I haven't got yet to the video. But with regards to the 1102 statement, it has been collected in compliance with Rule 1102. As I stated, B3 or B8. And as we all know, Rule 1102 allows reliable hearsay, as does the state constitution, Article 1, Section 12.
So what exhibit will this be? I want to look at it not for the purposes of, as a magistrate taking it into evidence, but see if it comports with Rule 1102 as stated, because I haven't seen it.
Sure.
And I haven't done the analysis to see if that
6.1.
objection is.
Judge, it is State's Exhibit 6.1.
I don't know what Kathy was on
Your Honor,
about.
just for the record, we just want to make a record too that it's difficult for the court to make a reliability finding when the individual is not here to be tested and cross-examined. And for those same reasons that we list in our standing objection, we just want to reiterate to the court that we think it really hampers you from making that reliability determination.
Thank you. Anything further, Mr. Sturgill?
Well, just that 1102 doesn't require that, Judge. It doesn't require that the witness be here to corroborate the statement that they've already prepared.
All right. All right, I've had a chance to review State's Exhibit 6.1, taking into note what Ms. Nestor noted, UCJA 4-202.02 and referencing the section she did.
Well, and Judge, I don't mean to interrupt, but I had not yet addressed that rule. I would simply just add to that judicial rule, it has nothing to do with admissibility. It's simply publishing it.
All right, is
And, I'm sorry.
okay, so let me just hear your full
Yeah,
argument. so
I
that
didn't
can-
realize you wanted to hear all of it. I thought you were going to rule on the 1102, but.
Well, I want to focus on the 1102. I want to keep this clean. So let's
Right.
focus on the 1102
Right.
and we'll stop
Sure.
there and I can make my ruling. And then if there's any objections, I just need to take it one step at a time to be thorough. So
Sure.
I'll hear all your arguments about the 1102 statement. I'll return to Ms. Nestor for any final thoughts, and then I'll make my ruling, and then we can move to the next
I
stage.
appreciate that, Judge. And I think I think I have addressed the 1102 question. As far as admissibility under Rule 1102, I thought that's what you wanted to rule on first, and then I would address the UCJA 4-202.02. And if you want me to do that now, I can do that, and it's just simply that it has nothing to do with admissibility. It has everything to do with publishing that. And Judge, I think if you'll look at that written statement, I believe Ms. Wright's personal information, for the most part, has been redacted. Other than that, beyond that, Judge, I'll leave it up to your discretion.
Well, as it relates to, well, let me take it one at a time. Let's start with the last statement. What I have in front of me, Plaintiff's Exhibit 6.1, has her full information in here: address, phone number, social security number.
Okay, Judge, I apologize for that. I thought we'd provided a redacted version of that. Yeah.
Her social, yeah, let's not go ahead and offer that into evidence, sir. Good Lord.
I think I've clarified what's going on here. I think we provided you with an unredacted version some time ago. The version that we have and are prepared to present today is a redacted version.
Could I have a copy of what you're intending to admit into evidence so I can consider what's before me?
Yeah. Judge, we can bring it up electronically. We don't have a hard copy of that.
All right, I want to make sure that's not coming on screen. It's just coming
Yeah.
on my screen to review it. All right. Okay, no, and that's fine. It's not, it's just from my.
I take it back. This is
I
going
can
to
look
take
it
all
on my
week.
screen because I'm trying to evaluate, so if you just want to put it back on my screen. All right, well, so what I'm doing is I'm looking at this, and just for clarity, moving forward, if there is a particular exhibit, I'll ask that you provide it instead of me relying upon it here, just so there's no misunderstanding, and I can see exactly what is being moved into evidence. I don't want to assume,
Right.
and I want to do the proper analysis. All right,
And I
so,
appreciate that, Judge, and I apologize. I understood that we were presenting redacted copies today, and
Okay.
I think there's
No,
just
that's
been a little
fine.
bit of a glitch, so I apologize for that, Judge.
all right, and Ms. Nestor, I just want to make sure that you're looking at this exhibit as opposed to what I was just looking at in regards to your
At
arguments.
least they caught
With
it
this
before they admitted it
clarification
and
in
stuck
mind,
it on the
any
screen.
Update to your argument or anything that you would like the court to consider?
The only other issue I think that exists with this that I haven't already raised is that there's clearly two different authors in the body of the document. One wrote something on the very top line, and then it looks like Ms. Wright wrote the rest of it,
Scroll down.
which we don't have any indication of who wrote that top line and when they filled that in, if it was before or after she signed the document. So I have some concerns about authenticity with respect to that as well, and that's all I have.
All right, and as I'm determining it, it does appear that the writing is different. Did you want to lay additional foundation, Mr. Sturgill,
Certainly,
or
Judge,
provide
I'd-
information for the
I'd
court?
be happy to do that. Do you have in front of you State's Exhibit 6.1?
I do, yes.
Okay. You've heard the discussion that just took place. It appears as if there's two different styles of writing on that form.
Yes.
Okay. I imagine that you have the writing that includes the personal information for Ms. Wright, and then directly below that, I think there's a line there that appears to be arguably writing prepared by someone else. Is that in fact accurate, that that is a different
That's correct.
author of that writing? What do you know about that writing on that first line just below statement of incident?
Because we were asking Ms. Wright to verify a specific video, the file name for that video was written on the statement in her presence. And then that video with that file name was then shown to Ms. Wright to verify that it was, in fact, the video that she had provided to us.
Okay. And so was it you or SBI agent Davis that prepared that?
Based on the writing, it appears to be Agent Davis's writing, but it's not my writing.
All right. But that is the routine, or is that kind of how you commonly do this?
In this case, because we were specifically asking them to verify a specific digital file that had a specific digital name, and we didn't want there to be any errors in how that name was presented, we wrote the file name on the document for the individuals.
Okay.
All right. Anything further, Ms. Nestor, with that additional information before the court makes its ruling?
Your Honor.
All right, thank you. And could you leave that on the screen for me, please? I appreciate that. And scroll down to the bottom. I just want to review it one last time. All right. And I believe this is Exhibit 6.1. Is that correct, Mr.
It is,
Sturgill?
Judge. And
Right,
I would move to admit 6.1.
Thank you. So considering the arguments made by Ms. Nestor and Mr. Sturgill, I rely upon Rule 1102 as well as the Utah Constitutional Article 1, Section 12, as I previously mentioned, that final paragraph. It states, nothing in this Constitution shall preclude the use of reliable hearsay as defined by statute or rule in whole or in part at any preliminary examination to determine probable cause or at any pretrial proceeding with respect to release of the defendant if appropriate discoveries allowed as defined by statute or rule. I have examined this and the clarification was made. The previous version of this would fall afoul of having identifiable personal information of Ms. Wright, and so that was removed, and this one with the redacted portion of the identifiable information, personal information for Ms. Wright is before me, and based off that, State's Exhibit 6.1 with redactions is admitted into evidence and may be published.
Thank you, Judge.
Well, that was like pulling teeth.
Agent Hold, that statement that was prepared by Ms. Wright, what does it state with regards to the video that you showed her that day, or I guess Agent Davis showed her that day?
It states that she's confirmed that she did review the video and that it was a true reflection of the video that she took on September 10th, 2025.
And did she identify who's in that video in her statement?
Herself and her 2 young children.
If we could just have a clarification on the court's ruling. So I understand the court overruled and published, and I accept the ruling, but I thought under the court's previous order that the media was not going to film exhibits. And they are filming the ones that are on that screen. So I guess I just need to clarify that, Your Honor. I'm sorry.
No, and I appreciate the clarification. It's important. What my ruling when we came back from break was if you're objecting specifically to the exhibit and then to the exhibit being published in the courtroom and then the exhibit being published, which can be captured by media, if that's not specifically addressed, I am going to allow it. So I didn't hear a specific objection to that. So I appreciate you bringing that up, but that's how I'm looking at every single objection, just for clarity of the record.
Thank you, Your Honor. So just to make sure I correct the record, we are objecting to the publication of this under the UCGAA rules for the reasons I said, but I respect that you've ruled on that. And in the future, I guess we'll just make particularly clear we're objecting to publication, because I do think anything that's getting on that screen is getting
That's what he
filmed.
told you to do.
Okay.
So thank you, Your Honor.
Thank you, Ms. Nestor. And Mr. Sturgill, did you want to respond? I mean, it's the genie's a little bit out of the bottle on this particular issue, but any record you wish to make.
Judge, we're simply going to seek to admit each one of these exhibits And then we're going to leave it up to your Honor's discretion whether to publish them beyond, well, to what extent you want to publish them.
All right, well, I would prefer argument on this issue from both sides. I don't, this is the burden of the state, so I don't want to exceed my lane by just assuming, so.
He's not making
I'll
your
leave it
case
to
for you,
to
sir.
make
You
the
decide.
argument, what you're requesting.
It's a very passive-aggressive prosecution here. Let you decide. Just take charge and do what you want. Good Lord, do you want us to see it or not? If you do, move to publish it. Period. It's not rocket science. This is a new prosecutor we haven't seen before, Sturgill. Not impressed so far.
Sorry about that.
So before you're moving on, Mr. Sturgill, as it relates to
yes.
this, I want to put this to bed and then we can move on. Were you requesting for it to be published on, so the three, you moved it into evidence, which I approved. It is moved into evidence, but I didn't hear anything in regards to publishing to the courtroom and then lastly publishing, which it would be captured by the camera in the background, in the back.
Judge, we believe these are public documents, and so we would ask that they be published both to the
Thank you.
audience and
Way to just come out and say it.
the public at large.
All right, well, given that we've gone past the gate on this one, it's been published.
Right.
But I think we're all on the same page in regards to how objections may be made and how the court is going to consider it, so we can move forward. All right, thank you. Mr. Sturgill.
Thank you.
It took like half an hour to deal with a witness statement that we know is coming in. We know it's coming
Have
in.
you personally watched Ms. Wright's video?
I have, yes.
Okay. And what is depicted in that video?
It's a view of Miss Wright's position in the crowd at the event on September 10th.
Okay. And absent the written statement from Ms. Wright, can you at least recognize the location that's displayed or depicted in this particular video?
Yes, it's the amphitheater at the Utah Valley University where Mr. Kirk was doing his event.
Okay. On your screen, Exhibit 6. Do you see anything on your screen yet? Just the very beginning.
It's there now.
It's there now. Do you recognize what's depicted on your screen right now?
I do, yes.
And what is that?
In the background is the Hall of Flags, and then you have the gazebo under which Mr. Kirk was presenting his event from, and then the crowd between where Miss Wright was and the stage.
Okay. But do you recognize what this is the beginning of?
Yes, this is the beginning of Miss Wright's video.
Okay. Judge, the state would move to admit what's been marked State's Exhibit 6.1.
This is 6.
Oh, I'm sorry,
not
6.
6.1.
I apologize.
And to what level?
Your
Hold on,
Honor.
hold on,
You've
Ms. Nestor. I
confused
just
him. He
want to get
doesn't
the
know what that
clarification,
means.
and then I'll certainly turn to you. So the levels of admitting into
Do you want to
evidence,
show it or not?
then the next
He's
level
not
is
gonna let
publishing
you,
it to the courtroom.
but make your
And then
record.
the next level is publishing it in a way that is captured by the media. What is your full request?
Judge, we'd ask that, first of all, it be admitted, that it be published here within the courtroom, and then that it also be published to the public at large.
All right, and I'm not quite sure what this particular video is showing. Could you lay a little bit more foundation or proffer that, what this is?
Sure. You've seen this video, Agent Hall?
Correct.
What's depicted in this video?
The crowd and the beginning of Mr. Kirk's presentation to the audience in the amphitheater at UVU on September 10th, 2025.
Okay. Does it depict Miss Wright?
I believe towards the end of the video, it scrolls back and Ms. Wright shows the people that she's with at the event and herself, yes.
Does it show Charlie being killed? That's what
Is
the
there-
judge cares about.
So is there any act of alleged violence in this particular
No, there is
clip?
not, Judge, but there is not.
Okay, I just needed that clarification. Ms.
Right.
Nestor, I'll turn to you. I just wanted to make sure I understand the full scope of this exhibit and then hear from your objection, if any.
Your Honor, with respect to admission, we object to its admission on the grounds that it's not properly authenticated, as Ms. Wright herself is not present in, for all the constitutional reasons we raised in our standing objection, we object to that. As far as its publication, we object to its publication. It definitely is something that in its current form without her here would not be admissible in any place other than a preliminary hearing. And we feel like this would really impinge on Mr. Robinson's right to a fair trial. And so we're asking it not be published, and certainly if the court does publish it, that it certainly not be filmed.
Thank you. Mr. Sturgill, any response?
Judge, Rule 901 addresses authenticating or identifying evidence to satisfy the requirement of authenticating a document, or I guess authenticating a piece of evidence. The proponent, which in this case is the state, must produce evidence sufficient to support a finding that the item is what the proponent claims it to be. And then the rule goes on to explain or provide examples of how this rule can be satisfied. And at the very top, under subsection B1, is testimony of a witness with knowledge. That goes on to say that testimony that an item is what it is claimed to be satisfies this authentication rule. Judge, you have an 1102 statement prepared by the person who actually caught these images on her camera or on her phone, and so, Judge, I think that alone sufficiently authenticates the document. And then even further than that, you have Agent Hull, who has reviewed the video himself and authenticates it, at least with regards to location.
Thank you. As it relates to admissibility of this exhibit, I believe this is State's Exhibit 6, is that?
It is, Judge.
All right.
Your Honor, I'm sorry to interrupt. Can I add one more thing just for the record? For purposes of publication question, under UCJA 4-202.02, parent 4, parent R is in Richard.
You got to 4R.
Photograph,
finally.
film, or video of a crime victim are designated as private court records. And I do think that based on what the state has previously referenced, they are perceiving that everyone in the audience is a potential victim. And so we think it shouldn't be published under that rule.
Thank you. Mr. Sturgill, on that final point.
Judge, I appreciate that argument from Ms. Nestor. And we don't necessarily disagree, but to that end, to protect who we believe is a victims in this video, I believe their faces have been blurred out.
Oh, I see. Ms. Nestor, have you?
I think it's only the minor children whose faces are blurred out, not Ms. Wright, if I'm not mistaken, unless it's been subsequently altered.
My recollection is they've all been blurred out.
All right, I need to view this again. So let's just put it on my monitor. Again, I'm just trying to make sure that in order for make a ruling on this, I need to view it. So let's put it on my monitor, play
Me
it
too.
without any sound. Okay, my understanding is the prosecution has control of this exhibit. So what I'm asking is that the sound be turned off, if there is any, and just go ahead and play it. And it's only on, well, it's on all the parties' monitors, because I want you all to view it, because that can go directly to, as you've mentioned, Ms. Nestor, whether it's possibly admissible. So let's go ahead and play that.
This really is better. Just the judge watch it by himself quietly and make the decision. Otherwise, it just kind of defeats the purpose. They're going to describe it so graphically that we might as well be watching it anyway.
All right, thank you. based off what I've watched, there was some blurring of faces, but not of all the faces. And so I'm going to rule that it is admissible.
Clarifying something for just a minute.
Sure, I'll wait until all parties are ready to proceed.
He's going to admit it, but not publish it. At least not to us, for sure.
So anything further? I just want to make
No,
sure.
Judge, you've had a chance to watch that.
I did. So I'm ruling that it is
Are you in
admissible
the
into
courtroom?
evidence. Again, taking into consideration the analysis the court's talked about in regards to 1102s and this particular piece of evidence as it relates to the 1102 video, or the 1102 statement 6.1. And I'm going to allow it to admit it into evidence. And because the faces of the alleged victims are not all obscured, there are some that are visible, it's not going to be published to in-court monitor and obviously not to be filmed by the media. So the court will receive it into evidence. The court will watch it again right now, and then we can continue to proceed.
Very good. Thank you, Judge.
So if, to the state, if you would like to play it again for me, I'm viewing it as it relates to consideration as the magistrate.
Way to take charge, Judge.
Sounds like an issue that's going to come up again. I represent the news media. Can I be heard on this issue?
News media.
Yes.
I just wanted to address it. I've tried to be quiet. I just wanted to address it now because it's going to keep coming up, it sounds like. The classification rule that Ms. Nestor is citing and that Your Honor was just reading is not about in-court exhibits. That is classification for records in the court file. So it is a fundamentally different thing when we are in a public proceeding and the state is presenting an exhibit that you are relying on, and the public is being denied the chance to see it. That is a fundamental violation of the right of access. And it's a qualified right, and I recognize that. But that's not the ruling that you just made. You're just ruling based on the Code of Judicial Administration, which doesn't have anything to do with when something is presented in a public proceeding. So while I recognize there are certain things where I understand that you were going to make an exhibit by exhibit evaluation based on certain exhibits that may, be somewhat, may cross the heavy threshold of being so prejudicial that they cannot be shown in public. That is not this. And so I just wanted to make clear that the things that are in Rule 202 are not, when it is presented in open court as an exhibit for you to rely on, the public is entitled to see what you're seeing so that they can understand what your decision-making process is. And so this one, it doesn't sound like, this sounds pretty anodyne to me. It's not even depicting the shooting. I just wanted to clarify that the classification issue about when, we're filing things with the court and we say like this, maybe we file a motion to classify. That's not the decision that you're making
Rule
today.
doesn't apply
the
to
decision you're making
exhibits.
today is the state is presenting something to you. You're watching it. You're making a decision based on it. And the people in the gallery have the right to see that. Whether you allow EMC of it is a different question. And we think that the EMC should be allowed to, for reasons that we briefed. But I do think that it at least should be published to the courtroom.
Thank you.
Thank you, Your Honor.
To the parties, do you wish to respond?
State is not. We'll submit it. Well, Judge, I'm sorry.
Oh, hold on. Okay, so
I'm sorry.
we'll go to Ms. Nestor
Go ahead.
first and then to the state.
No, Your Honor, thank you.
Mr. Sturgill.
The only other additional observation I'd make is with regards to this video and this video only, the state doesn't believe that the defense really has standing to make an argument on behalf of the victims in this case.
All right.
Fair point.
All right, based off of what's been presented in recognizing the argument from the media, I see the differentiation and how they are differentiating the rule that was cited versus what was presented. So I'm going to go ahead and rule that this may be played in the courtroom but not be captured on video. So to the camera operator, I just want to make sure that it's going to be playing on that, but I don't want it captured. I appreciate the patience of the parties as we were going through the many layers.
So we're back
that
to
need be
relying
addressed
on our in-court
on
reporters.
exhibits such as these. So we'll go ahead and, once that's ready to be played, let's go ahead and do that.
That's a lot of people, Utah, I'll tell you what. Everybody, you know how it works.
Thank you. And that concludes Exhibit 6.
Correct, thank you.
Mr. Sturgill, you may continue.
Agent Hull, did you or any other SBI agent collect additional video?
Yes, there were other videos collected.
What additional video did you collect?
A cell phone video from Mr. Phillips was collected.
And do you know who or how that video was collected?
Yes, Agent Schultz made contact with Mr. Phillips September 29th of 2025, and that video was provided to him. Subsequently, in preparation for the proceedings today, myself and Agent Davis met with Mr. Phillips on April 6th, and he completed an 1102 and went through the same process as Ms. Wright. The only difference being on this occasion that because he is a minor, his mother witnessed it and also signed the statement.
Okay. So you personally reviewed Mr. Phillips's video with Mr. Phillips?
Correct.
Okay. And you had him prepare a written statement?
Yes, correct.
Again, on this written statement, are there two different authors?
Yes, I believe in this instance it was myself that wrote the file name on the form.
Okay, and so you wrote, what part of the statement did you write?
Just the name of the file that we were asking Mr. Phillips to verify.
Okay. I'm going to have
Show 'em.
exhibited on your screen what's been marked States Exhibit 7.1. And this should just be for Agent Hall.
That's on my screen.
Is it on your screen? Do you recognize what that is?
I do, yes.
What is that?
The State Bureau of Investigation 1102 form completed by Mr. Phillips.
Okay, and did you gather that from Mr. Phillips?
I did, yes.
And again, does this statement include the advisory that is going to be used in lieu of his testimony at prelim?
It does.
And does it also include a warning that if he makes the author makes a false statement, that it could be punishable by being charged with a Class A misdemeanor?
It does, yes.
Okay. Anything about this exhibit look different than the day you collected it?
No.
Trust the state would seek to admit Exhibit 7.1.
Ms. Nestor?
Thank you, Your Honor. We would object to the admission on the grounds that this video does in fact show a close-up view of the shooting of Mr. Kirk and grievous injuries in very stark relief. And because of that, we are particularly concerned about our constitutional claims we have made and our standing objection in terms of our ability to get a fair trial if this is published. And I think, again, we have the same issue with the court, being in a position where you're having to make a reliability determination without the opportunity for this individual to be cross-examined. Also, I do think the fact this is a minor that completed this form does make it protected. He's also potentially a victim under the same theory that has been stated for Ms. Wright, and under the under the UCJA acts, for the same reason, the UCJA rules, for the same reason, these should be protected private court records. And private means it shouldn't be played to court, and it shouldn't be played to the public through the media. So we would object to its admission, we would object to its publication, and we would object to its filming. Thank you.
Any final response?
Judge, let me address, well, there's two things here, right? Let me address first the 1102 statement. Judge, I believe again that this statement was gathered in compliance with Rule 1102B8. Just double check. And the agent has explained that although Mr. Phillips is a minor, his mother was present. And that explains, I believe he said, the second signature on the form. With regards to publishing it, the 1102 statement, that is, Judge, we believe again, the presumption is this is a public record, and that it should be not only admitted but published here in court, and also published so that the media can record it. With regards to, well, do you want to address the 1102, and then I'll move on to the video?
All right, so we're staying focused on the 1102. Any final response, Ms. Nestor?
No, Your Honor.
All right, thank you. As it relates to the 1102 statement and to the state representative who is displaying it, could you scroll down? I can only see the top half of this. All right. And just go to the very bottom so I can look at the totality of it. This is 7.1. All right, based off of what's before me on the State's Exhibit 7.1, I find that it is admissible under Rule 1102 and to the Utah Constitution, Article 1, Section 12, to that paragraph I have referred to previously. And so it is admitted into evidence. And Mr. Sturgill, remind me, were you requesting for it to be displayed? I'm, again, focusing on 7.1.
Right.
In
On
court.
7.1, Judge, with regards to the video, we believe it's admissible. It's been authenticated properly.
Hold on. I'm not
You already
talking about the
said
video.
that.
I'm talking about 7.1.
Listen, and answer the
Publishing
freaking
it in
question.
the courtroom versus publishing it
This prosecutor is
on, to be
awful,
captured by
not
the
reading
media.
the room.
We think that the presumption is it is a court record. We believe that in its redacted form. We believe it should be published in all three areas.
All right, Ms. Nestor, any final thoughts?
No, Your Honor.
All right. I'm going to go ahead and grant the publishing of Plaintiff's Exhibit 7.1 in court, and that the media may capture that. Let's go ahead and do so.
Scroll up. Slowly scroll down.
All right. You may proceed.
That's a
Did
sworn
you admit
statement.
Exhibit 7.1?
It is admitted into evidence and it was
All
published.
right. Have you personally watched Mr. Phillips's video?
I have, yes.
Okay. And what does it depict?
It's a graphic video. Mr. Phillips was positioned towards the front of the crowd, and it does depict the moment that Mr. Kirk is shot.
And independent of the 1102 statement prepared by Mr. Phillips, you watching that video, do you recognize at least the location of this video?
I do. It's consistent with the event that Mr. Kirk was presenting at UVU on September 10th, 2025.
Okay. Just at this point, the state would move to introduce, or would move to admit what's been marked State's Exhibit number 7. We would simply ask that it be admitted. We would ask, however, that it not be published beyond that.
Ms. Nestor.
Due to the graphic nature and the sensitive nature of the video.
All right.
So as to the admission, the same issues that we raised as to the 1102, we would raise as to the difficulty of authenticating when the individual is not here present, and all the same concerns that we raised about the 1102 itself, Your Honor.
Thank you. All right. Considering the,
I'm sorry, may I add one more? I apologize.
You may.
And also under Rule 403, we think it's more prejudicial than probative, and we would raise it for that reason as well.
any final response, Mr. Sturgill?
No, Your Honor.
All right. And this is Exhibit 7, is that
7.
correct?
Correct, Exhibit 7, Judge.
All right, I will admit Exhibit 7 into evidence based off the foundation that's laid. The 1102 is tied directly to this, and so for admission purposes, it is admitted. I am not going to authorize publication in the courtroom or obviously through media, but I will have it played on my screen. And so I view it, and I just want to make sure, and please, counsel, given the graphic nature of it, please guard your screens because I believe we all should be viewing this. This is evidence, and I want to make sure that you all are seeing what I see to
This
ensure
camera
that
guy
that
gets the
is
assignment.
accurate and it's a fair representation of the exhibit that you are familiar with. So whatever you need to do, I'll give you a moment, and if you could just give me a thumbs up if you're ready to proceed. Again, I want to act in a way that is dignified in respecting the rights of all persons. And for those reasons, I just want to make sure we are safeguarding to ensure this is not captured. All right. To defense, ready to proceed? Yes, Your Honor. All right. To the state? Yes, sir. All right. Go ahead and let's play Exhibit 7. Is there sound? There is. All right, let's make sure that, thank you.
Guess they're muting it. Very meta, watching the judge watch the video.
Thank you. That concludes playing of Exhibit 7. You may proceed.
Thank you, Judge. Agent Holt, any more video? That you collected, or either you or another agent with the SBA?
Yes, we were able to collect video. TPUSA had a videographer, Visual Impulse, who was taking coverage of the event, and they provided video to us that they had captured on September 10th of 2025.
And do you know who or how that video was collected from Visual Impulse?
Yeah, Mr. Farnsworth originally provided, I believe, a flash drive to Lieutenant
right, you
O'Brien
get
with
it.
one of the local agencies. And a short time after that, on September
Matrix
10th, he
levels.
provided downloadable versions, electronic versions to Agent Mortensen. And an 1102 was collected from him on May 6th of 2026.
So an 1102 was prepared by someone with Visual Impulse?
Yes, Terrell Farnsworth was the individual that prepared it, and in preparation for this, I spoke to him personally regarding that statement.
And do you know what his association is with Visual Impulse?
I believe he's the owner-operator or the director of the company.
And then who collected that 1102 statement from Mr. Farnsworth?
It was Agent Mortensen who collected it.
Okay, and you know that because Agent Mortensen told you, or?
He
something?
provided it to me, and then, as I mentioned, I subsequently spoke to Terrell Farnsworth personally regarding his statement.
Okay. You had a chance to look at Mr. Farnsworth's 1102 statement?
I have, yes.
Okay. And again, does that statement include an advisory that any statement that he provided would be used at preliminary hearing in lieu of his live testimony?
Yes.
Did it also include a warning that a false statement would potentially be punished by a Class A misdemeanor?
It did, yes.
Okay. I'm going to have exhibited on your screen what's been marked State's Exhibit 8.1. Let me know when that comes up.
That's come up.
I think it's a single page, is it not?
I believe it is.
Go to the top screen. Go to the top screen down slowly.
You guys keep this going. This is great.
Yes.
You do recognize that?
I do, yes.
Okay, and again, that is what?
It's the 1102 statement that was provided to me, completed by Mr. Farnsworth from Visual Impulse, who is the videographer for TPUSA for the events that they do.
Okay. Judge, the state would move to admit State's Exhibit 8.1.
Ms. Nestor?
Thank you, Your Honor. At this point, we renew our objection. This is hearsay. This statement is hearsay. We have constitutional concerns for the reasons we raised in our standing objection. We also would like to cross-examine Mr. Farnsworth about whether or not and to what extent these videos may have been altered in any way. It is clear that clips were being made out of the larger videos because he sent, even his own statement says he sent larger videos, and this is just a small portion of them. So obviously someone made clips, and we don't know who, and we don't know how, we don't know what they did. And for those reasons and the reasons in our standing objection, we would object to the admissibility of it. And as well, I don't have a redacted version of 8.1, but I assume there is one. There is personal information on this one. Do you have a redact? Okay, I don't have that one. All right. And we would object to publication just on our concerns for fair trial, the same issues. Yeah, gotcha. Yeah, I think so. Thank you. And for all those reasons, we would object to its admissibility, its publication, and its ability to be filmed by the media, Your Honor.
Ms. Nestor, I just wanted to check, did you get a copy of the redacted?
I was just handed it.
Okay, I just wanted to make sure that
right.
you had copies.
Thank you, Your Honor.
So, okay, thank you. Mr. Sturgill, would you like to respond?
Sure, Judge, thank you. With regards to the admissibility of the statement, Judge, I think the foundation has been laid that this statement was collected in compliance with Utah Rule of Evidence 1102, subsection B8. It constitutes reliable hearsay. It's a statement that's been made by a declarant that's written, and it's under oath, or not under oath, but pursuant to a notification of the declarant that a false statement made is punishable. I think there's been foundation to support that. In addition, Judge, Article 1, Section 12 of the Utah Constitution makes it very clear that the state at preliminary hearing can rely upon reliable hearsay.
All right. Anything further before I make my ruling? Thank you. All right, applying the same analysis from the previous exhibits as it relates to the written statement under Rule 1102, and also under the Utah Constitution, Article 1, Section 12, in that last paragraph, I will overrule the objection and admit State's Exhibit 8.1. Let me hold off on that final phrase. If you could scroll down to the state representative and just stop right there. Thank you. I just want to make sure I fully review it before I make that ruling. And if you could continue scrolling down. And just go ahead and scroll down to the end. I don't believe there's anything else, but I want to make sure. Thank you. So I do rule that, overrule the objection, and State's Exhibit 8.1 is admitted into evidence and may be published. Well,
Judge, let me speak with regards to that. With regards to the 1102 statement prepared by Mr. Farnsworth in its redacted form, We believe that the presumption is this is a public record and that it should be published both here in court and made available to the public by virtue of the camera.
Ms. Nestor.
I just stand on the objection I made before, Your Honor.
Thank you. All right. Looking at the same analysis, it is admissible under Rule 1102 as well as Article 1, Section 12 of the Utah Constitution. And being that the person's identifying information is redacted and not viewable, I'm going to overrule the objection, the standing objection, and have it published both in court and maybe published by the media.
Aren't you guys
So let's
thrilled we
just
get to
it
see these written
situated.
statements
And what
saying,
I'll
yeah,
have you do
that's my
to the
video?
representative of the state, pause on the screen and then in 10 seconds scroll down to the full text portion, and then 10 seconds later just slowly scroll to the remainder of the document. Thank you. All right,
Yes,
you
we
can
know people are
continue.
going to write down the Google Drive link.
Judge?
Well, hold on, she's still
Oh.
going through it. She's going to show
You
the
were
whole
talking to me.
document. Well, I should have clarified. Thank you. All right, and that concludes State's Exhibit 8.1, the publication of that document. Mr. Sturgill.
Judge, thank you. I appreciate that. Agent Hull, have you personally, so the video that's referenced in Mr. Farnsworth's 1102 statement, have you watched that visual impulse video?
Yes.
And what is depicted in that video?
It's a view from the cameras that Visual Impulse had established at the event, actually looking out from the stage into the crowd. It too is graphic in nature and shows the moment that Mr. Kirk is shot.
Okay. Does it also show Mr. Kirk throwing hats out into the crowd? Do you recall?
If my recollection serves, Mr. Kirk used to do that at the beginning of his events, and I believe the video does show him engaging with the crowd prior to becoming seated on the stage.
Okay. Judge, at this point, the state would seek to admit what's been marked State's Exhibit 8. With regards to publication, Judge, it's our position that it not be published here in the courtroom and that it not be published so that the cameras can display it.
Thank you, Mr. Sturgill. Turning to Ms. Nestor.
Your Honor, we would just renew our objections to authentication for admissibility purposes under
Shut up,
901 for the reason that I mentioned in the 1102, which is, you know, someone prepared
We're
these
not on
clips.
that.
We don't know who. We don't have that person here to cross-examine.
He's literally
in
on your
terms of
side on this
what-
issue.
What, if anything, was edited? And for
Shut
that
up and
reason,
take
we
the
think it
gift.
can't be authenticated and we object to its admissibility and our standing objection for constitutional grounds.
I don't
Thank
think she's
you.
paying attention to what's happening.
Just one moment here.
Is the media going to
Mr.
pipe
Judge,
up
you can
about
respond.
publication?
Yes, please.
Just with regards to authentication, again, the state must produce evidence sufficient to support a finding the item is what the proponent claims it to be. And again, under subsection B1, it's sufficient to provide testimony from someone that has firsthand knowledge or observed, has firsthand knowledge regarding the authenticity of that video. You heard Agent Hull testify that he spoke to the owner of, and the director of Visual Impulse, I believe it was testified to, that they contract with TPUSA to film their events. This particular video, the state is going to, or seeks to introduce as Exhibit 8, was shown to Mr. Farnsworth. And that is the video that Mr. Farnsworth authenticates. He says that this is video that was captured by Visual Impulse cameras. And so with regards to authentication, I think the state has sufficiently provided the court with evidence to authenticate it.
And this is State's Exhibit 8. All right. I'm going to overrule the objection and admit State's Exhibit 8 as it relates to publication, citing to Article 1, Section 28, 1A, that this is Declaration of Rights of Crime Victims, and it states to be treated with fairness, respect, and dignity. And to those 2 points of respect and dignity, the court is not publishing this in the courtroom, nor is it being published, obviously, online. But the court will watch it in court. And again, to the parties, if you could protect your screens however you choose to, and then I'll check to see when we're ready, and then we'll have it played. So
Camera guy is
turning
not
to
risking
defense,
the stream. We
is
appreciate
more time
that.
needed to? Okay, thank you. Turning to the state, to your screens. All right, all right. I see a head nod, yes. And let's go ahead and play this video only on the monitors, and if there's sound associated with it, the sound to be played as well. You may proceed.
That was quite a reaction. Very graphic, I guess.
And that concludes State's Exhibit 8. Mr. Sturgill, you may proceed.
Thank you, Judge. So any additional video that was collected by either you or another member of the SBA?
Yes, the campus itself, UVU, is very well equipped with cameras throughout, and they were willing to work with us to provide video from those cameras, and so that was collected as part of the investigation also.
With regards to the UVU surveillance video, do you know if video was collected from there behind where Mr. Kirk was seated at the time that he was shot?
Yes, I'm aware that under the Hall of Flags there is I'll refer to it as a breezeway, but a way for people to move from one side into the amphitheater walking underneath the Hall of Flags, and I know there was a camera situated in that location.
Okay. And do you know, with regards to that camera view, well, let me ask you this. So that particular camera view, there was surveillance that was provided to you or another agent from UVU?
Correct.
Okay. And do you recall who provided that video to you initially and who collected it?
Initially, I don't know specifically for that video, but I know that whole process was overseen by Mr. Olson, who's responsible for that system.
Okay. Do you have a first name for Mr. Olson?
Curtis Olson.
I'm sorry?
Curtis Olson.
Okay. And do you know what Mr. Olson or Curtis Olson's position is at UVU?
I believe he's a director.
Right. Is it his job to basically gather and forward any video that's captured by UVU?
He has a long title, but I think it's Director of Infrastructure, but he is responsible for that system.
Okay. With regards to this particular video, the video from underneath the Hall of Flags, what, if anything, have you done with that video in preparation for today's hearing?
I went specifically to meet Mr. Olson, have him review the video that we had. And again, like with the others, I had him complete an 1102 statement for us, describing his role and verifying the videos. I did that actually on July 2nd of this year.
July 2nd of this year?
Correct.
Okay. Give me just one moment.
Actually, I'm going to correct myself on that if I can refer back to my notes.
Okay, please, yes, your notes, you have there with you again?
Yes,
And referencing them will help you refresh your memory?
it will, yes.
Okay, so don't read from it out loud, just look at it and let us know when you've refreshed your memory.
Apologies, July 2nd seemed a little bit too soon. It was June 24th when I met with Mr. Olson.
Okay, and you personally met with Mr. Olson?
I did, yes.
Okay, and did you personally review this particular video, or I guess the Hall of Flags video with Mr. Olson?
Yes,
And he prepared a written statement?
he did, yes.
And on that statement, was that a bureau-provided statement form?
It was, yes.
Okay, and on that statement, do you recall whether it includes an advisory that his written statement would be used in lieu of his live testimony?
It did, yes.
Does it also include a warning that if he provided a false statement on that form, that he could be punished with a Class A misdemeanor?
It did, yes.
Okay. Is there something displayed on your screen right now?
There is, yes. It
Okay,
says
it should
Exhibit
be-
12.3.
Yeah, it should be what's been marked as State's Exhibit 12.3. Do you recognize what that is?
Yes, it's the State Bureau of Investigations 1102 statement completed by Mr. Olson.
Does it appear to be in the same condition as when you collected it?
It does, yes.
As the state would seek to admit what's been marked State's Exhibit 12.3.
Ms. Nestor.
Yeah, we know.
Thank you, Your Honor. We would again renew our concern about hearsay and our constitutional concerns about that raised in our standing objection. Also, the concern is that the individual basically states they verified the recordings, but doesn't say how, doesn't say whether they viewed it, doesn't say whether someone else viewed it and told them, whether someone else viewed it and told someone else who told someone else who told them. There's just no explanation, and we don't think it's sufficient to meet your reliability analysis. And we object to admission, and we also object to publication. This is for all the same reasons, Your Honor.
To the state.
Judge, again, the state's position is that this written statement was collected in compliance with Rule 1102, subsection B8. It is a statement collected with both the advisory and the admonition. From what we've heard from Sergeant Hull, this individual, Curtis Olson, is the person it's his job basically to handle this type of information and turn it over to law enforcement.
All right, I'll have, if the state representative can scroll through so I can review it in its entirety and just stop when the majority of that handwritten statement's visible. Thank you. Let me review that. And if you could scroll down to the bottom of the page. Thank you. All right, under the same analysis for 1102, under Rule 1102, as well as Article 1, Section 28 of the Utah Constitution, I'm sorry, that's the wrong one. Under Article 1, Section 12 of the Utah Constitution, that final paragraph, the court overrules the objection and admits State's Exhibit 12.3 as it relates to publication. Mr. Sturgill.
Judge, with regards to publication, and this particular exhibit, it's the state's position that the presumption is that it's a public record, and we would ask that it be published both here in the courtroom and that the cameras be allowed to capture it and publish it as well.
All right, Ms. Nestor.
Nothing additional, Your Honor.
All right, I note the standing objection from defense, and given in the court's previous analysis for other 1102s, the court is going to publish it both in the courtroom and so it can be captured by the media. What we'll do is the same thing. We'll start at the top, pause for 10 seconds, and go to this middle section, and we'll pause about 20 seconds because there is a little bit, it is more dense. And then we'll scroll down to the very bottom for about 10 seconds, and then that will conclude that. So it's now on screen, and let's go from there. All right, you can scroll down.
I don't know about y'all, but I can't read that.
Okay, if you'd like to scroll to the very bottom. Thank you. That concludes publication of this exhibit. Mr. Sturgill.
Well, in Mr. Olson's 1102 statement, he references more than one video, does he not?
He does, yes.
Okay. So you, with regards to the Hall of Flags video, have you seen that particular video?
I have, yes.
Okay. And that video, what does it depict?
It's a view kind of looking what would be east, under the breezeway towards the back of the stage where Mr. Kirk was situated. It shows some movement behind the stage area, and I believe through the gaps you can see some of the crowd in the amphitheater.
I think I've neglected to do this twice before, so I'm going to do it right this time. Would you please bring up Exhibit 9?
Color me
Without
skeptical.
question play. Tell me when you see something on your screen.
It's on my screen.
Okay. Do you recognize what's depicted in that still image?
I do, yes.
What is that?
It's the area underneath the Hall of Flags that I referred to as the breezeway.
Okay. And is this the beginning of the video that Mr.?
It is, yes.
Okay, that Mr. Olson provided you?
Yes, yes.
Judge, the state would seek, the state asks or seeks to admit Exhibit 9. With regards to publication, this is another video that, due to its sensitive, the nature and the graphic nature of the video, we'd ask that it not be published here in the courtroom, nor published in any way that the media camera could capture it. And following your reasoning, Judge, out of deference to the victims and the victims' rights, and to have this type of information protected.
Ms. Nestor.
Thank you, Your Honor. We would object on our standing objection grounds, constitutional issues in terms of the concern about Mr. Robinson's right to a fair trial. We agree it should not be published. We object to its admissibility.
Thank you. Based off my analysis that I apply independently to this exhibit, but it tracks with the previous exhibits, I find that it is admissible, and I will admit it into evidence. This is State's Exhibit, I believe, 9. Mr. Sturgill?
Yes, Mr.
Play.
Sturgill, because you
No,
didn't
hold on.
identify
Sorry.
your
This is
exhibit
State's
when you
Exhibit
showed
9?
Right, correct.
All right.
So
As
you
it
didn't
relates to
actually do it right.
publication in the courtroom or by the media, again, citing to the Utah Constitution, Article 1, Section 28, 1A, it states to be treated with fairness, respect, and dignity, and to be free from harassment and abuse throughout the criminal justice process. I find that this does apply. And in respect and dignity and the human experience, I am going to not publish it in the courtroom, nor will it be broadcast, but the court will watch it in open court. And I note it is about, how long is this video?
3 minutes, Your Honor.
All right. Again, to the parties, if you could just indicate if your screen is obscure. Thank you, Ms. Nestor. And to the state, are your screens secure so they're not viewable? All right. Thank you. Seeing Mr. McBride nod his head, we can go ahead to the state representative. Go ahead and play State's Exhibit 9. And if there's sound, if you could activate sound. I'm not sure if there is.
It's the most important evidence that there
Alright, so
is,
there
and
i-
even the media guy.
All right, let's
Is it
go ahead and
gonna be like,
replay
"So,
it. Just wanted to
Judge?"
clarify, there is no audio, so let's go ahead and restart it.
He's like, Judge, why don't
Thank you.
you publish the snuff films to the world? Even the media guy is not going to ask. Hi, sweetie. Guys, we're nowhere near 3 minutes yet. If you boxed, you would know that, like by instinct. We got at least a minute left. Maybe more like 30 seconds.
State's Exhibit 9 has concluded. Mr. Sturgill.
Thank you, Judge. I'm going to ask you just a few questions with respect to that video and the very end of that video, which is State's Exhibit number 9. Throughout that video, you can see a banner. Do you recall seeing a banner that's hanging basically in the middle of that video?
Yeah, I believe that's the rear of the gazebo.
Okay, the rear of the gazebo?
Yeah.
And what gazebo are you talking about?
It's like a pop-up tent that Mr. Kirk was sat underneath while he was addressing the crowd.
Okay, so just really quick, just to be clear, where in relation to that banner that you see depicted in Exhibit 9 is Mr. Kirk?
Approximately dead center.
Okay.
He's on a stage, so he's slightly raised in relation to the bottom of that banner. Mm-hmm. And then he's seated in the middle of the stage, so approximately in the center.
And how many, if you know, what's the distance between the banner and then where Mr. Kirk is seated in front of that banner, if I'm understanding you correctly?
I don't know specifically. If I had to estimate, I would say 3 to 5 feet.
Okay, so close to that banner.
Yes.
Okay, I also believe towards the end of that exhibit, well, let me ask you this. If you know, what happened to Mr. Kirk immediately after he was shot?
My recollection is that Mr. Kirk's detail, his own security team, removed him from the scene whilst administering first aid, and they conducted what would be called a hasty transport to Timpanogos Hospital.
Okay, before you go any further, that Mr. Kirk being picked up by his own security, is that portrayed in the video? In Exhibit 9, I'm sorry?
It's kind of on the left side. You can see Mr. Kirk come around the left side of the back of that, the pop-up tent. And then you can see Mr. Kirk being carried down the left side of the video under that breezeway.
Okay. And then you said that he was, that there was a quick transport, is that the language you used?
A hasty transport.
Hasty transport, what does that mean?
Just they were trying to get him to medical care as quickly as possible. So I believe he was thrown into one of the team's vehicles and then transported to the hospital, as opposed to waiting for an ambulance.
And I think you already stated, but let's just be clear. Do you know which hospital he was transported to?
I believe it's referred to as Timpanogos Regional.
Okay. And do you know if he was treated there at the hospital?
He was, yes.
Okay. Do you know whether or not he was pronounced dead there at the Timpanogos Hospital?
He was, yes.
Okay. And how do you know that?
The medical examiner had an investigator that responded to the scene. And I spoke with him, and he informed me that he was at the hospital when Mr. Kirk was pronounced deceased.
Okay. And that the medical investigator that you spoke to, do you know the name of that person?
Bullock, I believe, Officer Bullock, but if I can refresh my recollection specifically.
If it'll help, if you have it in your notes, it will help you refresh your memory, go ahead and look at that. Again, don't read from it out loud.
It is Officer Bullock, yes.
Okay. And he is a peace officer?
He functions as a law enforcement officer, and he works also for the medical examiner as a death investigator.
Okay. Do you know whether Mr. Kirk was autopsied by the Utah Medical Examiner's Office?
Yes, an autopsy was conducted by the medical examiner's office.
Do you know when and by whom?
Yes, it was late into the evening of September 10th, or it may even have gone through into the morning of September 11th.
Okay. And do you know who
I'm going to
conducted that
refresh my
autopsy?
recollection because of the pronunciation, if you don't mind.
If it'll help you refresh your memory, that'd be great. Again, don't read it out loud, look at it, let me know when you've done that, and then we'll go from there.
Dr. Guajado, I believe is how it's pronounced.
Okay. You want to spell that last name?
Yes, Guajado.
Your Honor, if this is not
Guajardo.
personal knowledge, we object to the hearsay if someone told him all of this. I don't believe this individual was present at the autopsy, so we object to any testimony about the autopsy or what he was told about it.
Mr. Sturgill.
Well, Judge, if I could, I'll just simply lay foundation for the report itself. And I think this is all information that's included on the report.
All right, so as it hasn't been moved into evidence just yet, I'm not making a ruling.
I appreciate
If you
that.
wish to lay more foundation, that's certainly your choice.
So you are aware that the medical examiner's office did conduct an autopsy?
I am, yes.
Okay. And did you receive a report from the medical examiner's office?
I did, yes.
Okay. Detailing the autopsy that was performed?
Yes. Prior to receiving the report, myself and Agent Davis visited with the doctor.
Okay. You visited personally with the doctor that conducted the autopsy?
That's correct.
Okay. And then subsequent to that, and did you discuss the autopsy with the doctor at that point in time when you were meeting with him personally?
Yes, Agent Davis and I had a fairly in-depth conversation, yes.
And where did that conversation take place?
At the medical examiner's office.
Okay. Do you recall the date and time that personal visit took place?
I don't recall.
Okay. Was it
It
within
was soon after, within a few days of the incident.
of the autopsy?
Yes.
Okay. And subsequent to that visit, did you receive a report from that doctor that you visited with?
We did, yes.
Okay. And that's the Dr. Guajardo that you're struggling to pronounce his name, is that fair
Yeah, I
to say?
apologize, but yes, that's who it
Okay.
is.
And the report that was sent to you, do you recall when you received that report?
I don't recall the specific date.
Okay. Have you reviewed that report?
Yes.
Have you again, you stated earlier that this is not the first murder investigation that you've worked,
Correct.
okay? This is, I take it, this is not the first medical examiner's report you've received,
Correct.
okay? Do the reports typically look the same?
Yes, they're in a standard format that the medical examiner uses.
Okay, and this report that you received
Yes.
from who you believe was the doctor you spoke to
Yes.
that conducted the medical exam, was there anything peculiar about that particular report that stood out to you?
No, it appeared to be a standard form as used by the medical examiner when they send us reports.
Okay. On your monitor, Exhibit 11, I'm going to have displayed what's been marked State's Exhibit number 11, Judge, for identification.
Right.
And I believe there's 9 pages. So let me know when you see that on your screen.
It's on the screen.
All right. What I'd like you to do is just look at this as it scrolls down through the 9 pages and wait till we get to the very end. And if you need us to pause or stop or slow down, let us know. I want you to be able to look at all 9 pages.
Make sure it's all accurate, because we're going to want to see it too.
Did you get a look at that?
Yes, sir.
Okay. Do you recognize what that is?
Yes.
What is that?
That's the medical examiner's report of examination for Mr. Kirk.
Yeah, do you recall, you don't recall exactly when you received that?
I don't unfortunately remember the specific date when I received it.
Do you remember how you received it?
Then provided to us electronically.
Okay. Via email?
Sometimes via email, also on disk, compact disk.
Okay. And does there appear to be anything in the exhibit before you? Has that report changed at all? Or does it accurately depict what you received initially from the doctor?
It accurately depicts it.
Does the state would seek to admit Exhibit 11?
Ms. Nestor.
Your Honor, this is an expert report without the expert being present, being offered by an individual who's not an expert in this field. If they're presenting him as an expert in this field based on the limited questions about his experience in seeing
Kathy.
previous medical exam
Autopsy
records, I'd like to
report is
forbear him on
specifically
his
in Rule 1102.
qualifications to opine about it. This is hearsay.
Coming in.
It's highly technical. It should be presented only through an expert. It could never come in trial in any other way. We submit that it is hearsay. And to the extent they're going to ask this individual about any opinions about it, that would be improper. He's not qualified to do that. And furthermore, we just think that this is clearly falling under our constitutional concerns about the absence of our ability to be effective, to cross-examine, to question we can't even question the expert's experience or CV or anything that we would normally do to determine if this should even be accepted or considered by the court. And so we strenuously object to its admission and for all those reasons to its publication as well. There's some really personal things in there that should never be published that deal with Mr. Kirk's medical condition. History is the condition of his body. It shouldn't be published, Your Honor.
Thank you. To the state.
Judge Red, this is clearly reliable hearsay admissible under Rule 1102 of the Utah Rules of Evidence. I would direct you specifically to subsection B5.
Medical and
For
autopsy
purposes
reports
of-
and
I'm quoting
records.
the rule, for purposes of criminal preliminary examinations only, reliable hearsay includes, and subsection 5 specifically states medical and autopsy reports and records. Again, that is supported by Article 1, Section 12 of the Utah Constitution, which states that reliable hearsay can be relied upon at preliminary examination in whole or in part.
And to the second part in regards to publication.
As far as the publication, Judge, we agree with Ms. Nestor. This is a document that does contain very sensitive information and information
Hey, stream.
that Mr. Kirk's family would appreciate it not being published. And so although we seek to admit it, we'd ask that it not be published here in the courtroom, or that it be published in any fashion or way that the public can see it by virtue of the camera.
That's unfortunate, sir.
Your Honor, I just
Media
want to
standing
point
up.
out that even though 1102 has a provision about exams, I mean, the court still has the overarching mission under 1102 to make this reliability finding, right? And it's just completely in a vacuum being offered by someone who's a police officer. So again, we would just argue that you're just not, it's hampering you from making the analysis you need to make to admit it, and we object to it.
All right, anything further from the parties?
No, Your Honor.
No, sir.
All right, so again, relying upon the analysis on Utah Constitution, Article 1, Section 12, as it relates to reliable hearsay, and then turning to Utah Rules of Evidence, Rule 1102, B5, specifically notes medical and autopsy reports and records. The court is going to overrule the objection and admit State's Exhibit, I believe it's 11.
11, yes, sir.
Citing to Utah Constitution, Article 1, Section 28, dignity, portion, respect, and dignity. It will not be published either in the courtroom or viewable on media by the camera for the reasons previously stated as it relates to the video. And so the court will receive it, and it is admitted into evidence. And that concludes that portion. Mr. Sturgill, is this a good point to stop to take our 15-minute afternoon break?
I think it'd be a great idea, Judge. I've just got one last question.
All
if I
right.
could,
You may.
with respect to the medical examiner's report. Agent Hull, in that report, does the doctor relate cause and manner of death?
He does, yes.
Okay, and in that report, what is the stated cause of death
It was stated as a murder.
and manner of death?
It was a gunshot wound to the neck.
I
me one
object, it's
second.
not stated as a murder. I believe it's stated as a homicide, which is an important distinction.
Judge, I'll go back and correct that.
All right, so so I'm going to sustain, well, first of all, let me look at the report. I need to see that section. I need to be able to draw my own conclusion. So, okay, I see, Ms. Nestor, are you referring to page 1 of this report?
I'm sorry, Your Honor. Could you repeat that? I apologize.
As it relates to your objection for the misstatements, are you looking at page 1 of the report?
Yes.
All right.
She's not wrong.
Your Honor, I also need to make an objection on the best evidence rule, too. Thank you.
So I'm going to sustain the objection as it relates to the manner of death. It does not say murder, but in regards to the best evidence rule, again, under 1102 and the Utah Constitution.
It is
that
an
permits,
evidence.
Reliable hearsay. It is, State's Exhibit 11 is admitted. Mr. Sturgill.
Agent Hull, I'm going to ask you to look at the first page of Exhibit 11.
We were all like one
Yes,
foot
is
into
that-
our
yes.
break.
Okay. So let me ask you again, and you can look at it.
Yeah.
And would you mind relating what the doctor reports as the manner of death?
Yes, I misspoke. It does say homicide.
And then
Yeah,
the
you,
immediate
you
cause
know
of
you
death?
did.
Gunshot wound of the neck.
Nothing further, Judge. Well, at this moment, I think it'd be a great idea that we take a 15-minute break.
Right, we'll go ahead and go on break. We'll come back at 3:25 and resume with this witness at that time. Court is in a brief recess.
325. She absolutely was not wrong on that one. A very important distinction between homicide and murder. Homicide is any killing of a human by another human. That can include, self-defense. It can include lawful actions. Murder is very specifically an intentional killing of another person, so it's a very specific kind of homicide. Medical examiners are not in the business of determining the full legal implications of a human killing another human. They just want to confirm that that is what in fact it is. So it's not an accident, not a natural cause. It was human caused it. But as far as the legal details, that's up to the court to decide. So she wasn't wrong about that. And she was annoyed by it, which I kind of like, because, I would be too in that situation. But also Kathy, accept it as a gift, because now you know to watch this witness for exaggeration, for coloring, for testifying about what he thinks, perhaps more than what the document itself says. So this is a gift to you. This is a piece of knowledge about this particular witness. This is now the second time we've heard him testify, because we saw him before during the motion to disqualify the prosecuting attorney's office. Now you know. Prepare accordingly. Be warned. Oh, well, this has been kind of excruciating, hasn't it? All of this going through the 1102 and the video that we don't get to watch, and what gets recorded and what does not get recorded, published, I mean. Guys, I'm just going to switch over real quick to this right here to share with you. This is what they keep talking about with 1102. This is why they get to do this way for this hearing, because it is the preliminary examination. This is not the rule for trial. This is the rule specifically for the preliminary hearings, because the Utah Constitution says they get to do this. And so this rule just clarifies what exactly it means. It's not any and all hearsay, but it's reliable hearsay. So what does that consist of? They have all of these variety of different pieces of evidence that the court rules are adopted by the Supreme Court of the state. The court has said, we think these things are reliable enough for these purposes for the preliminary hearing, that we're going to go ahead and allow it to be presented without the witness having to come in. There's a lot of reasons for why they do it that way, but the bottom line is always going to be efficiency. The medical examiner's time is best spent doing autopsies, not sitting and waiting in the lobby of the courtroom, so that, when it's his turn to be called in to testify, he can testify, and then he can do it all over again for trial. That would not be a good use of his expertise and his money and so forth. When they can just bring in the autopsy report, it's just going to be for the judge to review and say, does this seem like a reasonable basis to think that maybe Tyler Robinson shot Charlie Kirk with a gun in the neck and killed him? That's all it's for. So very specifically, the medical and autopsy reports and records are allowed. We're going to deal with this when we get to the ATF and FBI stuff. Scientific, laboratory, or forensic reports and records specifically allowed. They don't have to bring these witnesses in for this particular process. Also, they are making heavy use of this one right here, a statement of a non-testifying peace officer to a testifying peace officer. What the other cops told him, it's fine. He gets to report it. They don't have to call in each and every police officer who did anything in the case to testify about that. And then this one is the 1102. This is what is the same thing. Basically, this is anticipating the Rule 1102 exception. These written or recorded statements that are under oath, or they have a notification on them that says you can be prosecuted if you make a false statement in this particular context. There's also this catch-all. Any other hearsay with similar indicia of reliability, regardless of miscibility at trial. It's got this catch-all. They haven't used it yet, so it's not necessarily all that interesting. But it just goes to show it's fairly broad. It's not everything. It's not, anything you read online or anything that, anybody said at the scene to anybody else. It's not that broad, but it does encompass a lot of information that is typically like officially generated information that's moved through official channels, information that's otherwise, it might be hearsay, but it's admissible under the evidence rules would be at trial, because there's tons of exceptions to the hearsay rule. Yeah. So this is why they're able to do this, and it's specific to this hearing. It is not the same thing as what we are going to be looking at in the trial context, where hearsay is it's more circumscribed. There are Sixth Amendment confrontation rights that attach that Utah Supreme Court has said do not apply in the preliminary hearing stage. That's why this particular objection that the defense is reiterating isn't landing with the judge. He is bound by Utah Supreme Court authority that says, no, you don't have that right to confrontation at this process, and so that's not how it's going to work. So, let me get this banner switched here. We got about 10 minutes left, I guess, right? About 10 minutes on our recess. Yeah, this whole going and over and over the like why do you even have a standing objection if you're gonna just keep stating it and re-arguing it? It's very, very valid. But they're going to do it in the abundance of caution to paper their record every single which way, because the risk is if you don't, then a court that doesn't want to consider your issue is going to look at that one time you didn't and say, oh, you didn't raise it, so you waived it. Your standing objection wasn't specific enough. Your standing objection wasn't, clearly applicable to this particular evidence or piece of information, this objection. You got to be cautious about all of these procedural pitfalls with trial and with preserving issues for appellate review. So that's why she's doing it. And, frankly, she's also taking the opportunity to grandstand a little bit. I mean, she might as well, like, you're on TV. This is a public trial. We're hearing tons and tons and tons about the prosecution's case, so you might as well get in what you can when you can about how you think this is procedurally improper and stuff, because maybe that will resonate with some people. I don't know that many people are going to be like, oh, horror, the autopsy report entered into evidence without the doctor being there. As long as we're not asking this guy on here to give medical opinions, it's fine. He doesn't have to be an expert. You don't have to be an expert to read an autopsy report and restate the words on it. It's really, really not necessary. Gunshot wound to the neck. We knew that. That has already been established in the court record many, many times. For some reason, there still continues to be some debate about this. There we are. Medical examiner says gunshot wound. When we come back to this, we're going to move on, quite certain, to the evidence recovered during the autopsy, because that's how we're going to get to the bullet fragments. Somebody explained the joke to me. Thank you. BJ Hodge, old Hawaiian Punch commercial, 14 seconds long on YouTube. How about a nice Hawaiian punch? Sure, he punches the guy. Funny. All right. It's a good dad joke. It's a good dad joke. And a nice Hawaiian guy with a good overhand right or something. I'll have to check it out. But yes, I am a little slow on the jokes and the cultural references sometimes, guys. Sorry. It's not that I live in a box or anything like that. I don't know. We do get siloed more and more, like every day, it seems like. And so anything outside your silo, it's like it just gets harder and harder to find and kind of get exposed to things compared to, 10, 20 years ago. But yeah, also just I tend to nerd out on stuff more than the things that are kind of in the popular culture, and I'm not This is not like a humble brag or anything like that. It's just by way of explaining my ignorance. I'm over here reading Grant's memoirs from what, 1880, 1870 something, real cutting edge stuff, but that's where my attention has been lately. How she grows. Forgive me if this has already been asked or answered. Can a witness be impeached during trial if their response differs from what they said during a preliminary hearing? 100%. This preliminary hearing is prior sworn testimony. So this is always going to be available. Number one, if that witness dies, disappears, absconds, runs away to, I don't know. I don't know the non-extraditing countries off the top of my head, but they're no longer available as a witness. They can't be secured into court. Then it is available as prior sworn testimony because there has been an opportunity for cross-examination by the defense. Could be some issues with that given the limitation if it were to come up. Bottom line, yes, it's prior sworn testimony, so potentially available as an exception to the hearsay rule when the speaker is no longer available as a witness. Also, prior statement, if it's a prior inconsistent statement, yes, it can be used for impeachment. So if they get on the stand at trial and testify and their testimony is different, then yes, you get to walk up to them with that transcript and stick it under their nose and be like, don't you remember testifying at the preliminary hearing when you said this instead? And then you get to ask them about that and you get to confront them with it. Yep, and this is part of the picture of why these proceedings are a little bit more limited in Utah, because it used to be that they actually used it kind of for this purpose. I want as many statements from as many of the state's witnesses as I can get, because the more times they talk, the more opportunities there are for them to contradict themselves, maybe even in just very small and not even that important ways. But it doesn't matter if I can build up enough of those, maybe I'll get to reasonable doubt. Maybe I'll get to, you got to question the credibility of all of this or something like that. And so they used to use the preliminary hearing like that, as kind of like a discovery tool that, hey, if all of these witnesses have to come in and testify, then I'm just going to take advantage of the opportunity to ask them about everything, get them on record on everything. And then I have that available to impeach them if they change anything when we get to trial. But it was during the 90s when they were adopting all of the victims' rights laws and the constitutional amendment and so forth. They were doing a whole bunch of different amendments to rules and processes when they made it so that you could have the reliable hearsay at the preliminary hearing, and also very specifically provided that the sole purpose of the hearing now is to establish probable cause. It's not for discovery. So they cut way back on that. Because having like a mini trial, when you treat the preliminary hearing like a mini trial, then essentially what you're doing is you're saying there have to be two trials in a case. And trials are traumatic to crime victims, period. Very hard to go through. Not fun for all kinds of different reasons. Isn't just because you have to sit here in court and listen to the stuff. You have to anticipate that maybe you're going to be called to testify. You have to be reliving things in your own mind. You have to just have the anticipation of like what's going to happen. And I'm not familiar with this process and it's foreign and scary. So to minimize the impact of the legal process on victims as much as they can, which is limited because there is just frankly not a whole lot about the criminal justice system that is all that kind to victims of crime. But this is one step that they took to try to minimize that by making this just a more basic procedure, so you don't have to have a whole mini trial before you go into the full trial. So it's not for this purpose. Used to be, not so much anymore. But to the extent anybody is getting on the stand and taking an oath and testifying, yeah, they're stuck to that story now. And if they're not, if they change it when they get to trial, then their prior testimony can be brought up and they can be impeached with it. Chanley 5541, thanks for being a logical place to go in this sometimes not so logical world. We're gaslight proof here, right? That's why this is a great place to watch trials, because you know, you can say what you want, you can theorize what you want, but I can see for myself that John O'Keefe's arm was chewed up by a dog. Okay, so you don't need to gaslight me with like silly stories about taillights, you know, blue paint. It's a dog bite. Like I get it. I can see with my own eyes and make that judgment. I was forced. No, I wasn't forced to open Twitter, but I did in fact open Twitter on September the 10th when first thing like all over the feed is Charlie Kirk getting shot. So yeah, I heard the gunshot, guys. I heard it, and I saw him get shot with my own eyes. So yeah, I'm pretty comfortable with the gunshot wound on this one. Not really going to be gaslight that I heard something other than what I heard and saw something other than what I did. So if that kind of thing is comforting to you, if you like a you know, comforting grip on reality and not going to be doesn't mean we're closed-minded here or anything like that. Very happy to consider all of the evidence. But evidence, okay? And just like trying to tell me that what I saw isn't what I saw, you're gonna have a hard time getting me there. So it's one of the things that has been enjoyable, I think, about the group watch of the case is being able to kind of test our perceptions against each other. Be like, is this legit or are you gaslighting me? No, they're gaslighting you. It was a dog. It's obviously a dog that chewed up his arm, guys. 2, Truth for Liberty. Now that video was played in court, while it can be withheld until after trial, that exhibit must be released to the public after trial. Correct. Well, I'm going to have to look up very specifically. Oh, we're back in court. Back in court, guys.
I believe we were continuing with the direct examination of Mr. Hull.
I'll come back to this.
Sturgill. Mr. Sturgill, you may proceed.
Thank you, Judge. So, Agent Hull, in addition to what you've already described, what, if anything else, did you do on the 10th of September 2025?
Primary focus was to identify the individual who'd been seen on the roof with the preliminary footage. And so there was a big effort to review as much of the video that we had available to us from both the public, but predominantly from Utah Valley University, in an effort to follow that individual both forward and backwards from the time of the shooting.
Okay. So if I understood you correctly, priority was to identify the shooter.
Yes.
And to that end, you started reviewing even more UVU video than you've already described?
Correct, yes.
Okay. What, if anything else, either did you do or happened initially that helped you identify who that shooter was?
So there was hundreds of hours of video that was reviewed, but the predominant focus, again, was on tracking the individual from the roof, either after the shooting had occurred or trying to trace the steps of the individual prior to the shooting.
Okay.
And we were able to do that through a combined effort of individuals. And the focus was having people reviewing video identify people who could fit the original description of the individual that jumped off the roof.
Okay. At that point, so at this point, approximately how many hours of UVU video do you think you personally had seen or watched?
Myself, maybe 10 or 20 hours of video, being called in to look at different camera angles and different views of individuals. But there was a large team of people reviewing video.
Okay. Reviewing video?
Yeah, from UVU.
Were some of them SBI agents?
Yes, correct.
And combined, how much video do you think you watched that first day on the 10th?
It would be in the tens or hundreds of hours of video was reviewed.
Okay. Did anything else come along that helped you identify who that shooter might be?
Eventually on the evening of the 11th, we received word from Washington County that an individual in that area had reached out to law enforcement and was wanting to turn themselves in for the incident at UVU.
Okay. And did you, at that point in time, did you receive a name from Washington County?
Yes, we did.
And what was that name?
Tyler Robinson.
What, if anything, did you do with that information, the name Tyler Robinson?
That information was given to our SIAC, or our State Information and Analysis Group, and they put together what would be called a workup. So they would look at driver's license records, DMV records to determine addresses, obtain pictures of individuals, and then any associated vehicles or things like that.
So was that done with Mr. Robinson?
It was, yes.
Driver's license record was pulled.
Yes,
Did that include, if you remember, or do you know, did that include a photograph of Mr. Robinson?
it did include a photograph of Mr. Robinson, yes.
How about an address and date of birth?
There was an address and a date of birth, and I believe a DMV record with an associated vehicle.
All right, and so that DMV record did include a vehicle that was associated with Mr. Robinson?
Correct.
Okay. Do you remember what the make and model of the vehicle was that was tied to Mr. Robinson?
The Dodge Challenger
Anything else beyond that that you remember?
was silver in color, and I believe there were two registered owners of the vehicle.
Okay, and who are the registered owners?
Mr. Robinson and then his mother.
Do you recall whether or not a date of birth was included in that driver's license information that you got initially?
Mom co-signed
Yeah,
for
I
him.
believe the actual driver's license record was shared, so it would have included a date of birth.
All right.
Kind of wondered how he got the
With
Challenger.
with Tyler Robinson's personal information, were you able to expand your search at all?
Yes, once we knew a vehicle that we were looking for and we had an actual image of the individual, then we were able to use that video footage to try and track that specific individual.
Okay, and I'm sorry, let me clarify. So when I said expand your search, I'm referencing the UVU surveillance video.
Yes, we were able to.
Okay. And were you able to identify in that expanded search, did you believe you located that Challenger?
We did, yes.
Okay. Were you able to determine at what time or times Mr. Robinson visited the UVU campus on September 10th?
Yeah, we were able to establish that Mr. Robinson had been on campus approximately 4 times throughout the day, twice before the shooting, the time of the shooting, and then after the shooting later in the evening into the early hours of the 11th.
Wow.
You said that you initially tracked the shooter forward and backward
Yes.
with UVU surveillance video.
Correct.
Okay. Did you do the same thing with that vehicle?
We did, yes.
Okay. Tracked it forward and backward?
Yes, using the UVU footage and additional information that was obtained, yes.
And I believe you said that in total, Mr. Robinson visited the UVU campus 4 times that day.
Yes, that's correct.
And let's just be clear, that's all based on UVU surveillance video. Is that fair to say?
That's correct, yes.
Okay. Have you reviewed what's been marked States Exhibit 12.1 for identification?
I have, yes.
Okay. And, well, before we go there, of the video that you have personally watched, does the video include the 10th and the 11th, or just the 10th?
The video I've seen includes the 10th and then a very small portion, I think, about 0:30 of the 11th.
Okay. And I think you said initially you watched about 20 hours of video.
Yes,
Since that time, have you watched additional video?
yes,
UVU surveillance video?
yes.
Okay. And who provided the UVU surveillance video to you?
It was part of the collection of videos that was provided by Mr. Olson and his team that we already discussed previously.
Okay. Of all the hours of video that you've watched, do you have an idea of how many hours include Mr. Robinson or his vehicle?
Just with UVU or in
Just with
total?
UVU, I'm sorry.
Just with UVU would probably be about 16 hours.
And let's be clear, this is someone you believe to be Tyler Robinson.
Correct.
And this person that you've identified as Tyler Robinson, that you've been investigating and that you viewed in the numerous hours of video from UVU, would you recognize that person if he were in the courtroom today?
Yes,
Is he in the courtroom today?
he is, yes.
Would you point him out and describe something that he's wearing?
Your Honor, we object to unduly suggestive in-court identification for constitutional grounds.
Do you wish to specify an unduly constitutional? I'm trying to understand your objection, so I want to make sure I fully understand. before
Your
I-
Honor, I think there's some, and I'll defer to Mr. Byrd if he wants to jump in, but I believe there's a long line of case law that says, and you ask someone to identify the defendant when they're the only person, sitting at the table with defense counsel, that's unduly suggestive and taints any future or past, definitely future identification. So we object to that happening in this fashion at this time.
Mr. Sturgill.
Well, Judge, Agent Hull has testified that he has watched numerous hours of video take a step back. He has looked at personal identifying information of an individual by the name of Tyler Robinson. He's looked at the driver's license record, and he's also looked at the DMV records and has been able to determine what car that person drives. He's also looked at surveillance video that he believes depicts this Tyler Robinson. And I've simply asked him if that person that he has seen, both in driver's license photos and the surveillance video, if that person is here in the courtroom today. And I don't know that that's unduly prejudicial or suggestive. It's the routine. I don't
It
know
is
any other way to do it
creative.
other than the way I just did it, Judge.
All right, well, I wanted to
gonna be
verify
overruled.
the format of the question. I remembered it in my mind, but to Ms. Nestor, was that an accurate portrayal of the question that was asked?
Yes.
Okay. Mr. Sturgill, anything further before I issue my ruling?
Well, no, other than, Judge, I believe it's worth noting that Mr. Robinson is in plain clothes. Well, he's in
Counsel,
plain
please approach
clothes.
the bench.
This prosecutor is struggling. This is not great. I looked him up. He is he's the section chief of the SVU section. Okay, that's those particularly bad crimes, those special victims kinds of crimes. He's the chief of that division. He's been a prosecutor for 25 years. I don't know how he doesn't know how to do this better. I never have high expectations, and then I still get disappointed every time. I can't tell how much of this is on purpose and how much of this is just not getting it. Sometimes I get that you're going to ignore the point the other person is making, maybe because it's really good and you don't want to address it. But sometimes you're just not getting it. I feel like he's just not getting the
All
point
right.
she's making.
Based off of what's been presented in court, I'm not finding that particular question as previously posed as suggestive. I find for the purposes of this hearing only that in-court identification by Agent Hull of Mr. Robinson has been made. Again, this only relates to the preliminary hearing, and you may proceed.
Thank you, Judge. Agent Hull, have you reviewed what's been marked State's Exhibit 12.1 for identification?
I have, yes.
And where did you review that video?
So you're not going to ask him to ID Tyler then?
I reviewed it on my computer in my office.
Okay. And is that the first time that you've seen this particular video footage?
This particular version of the footage, yes.
Okay, so this particular version the first time, but have you seen the video that comprises, I guess, Exhibit 12.1?
Yeah, I have seen the original videos, if that's your question, yes.
So what is State's Exhibit 12.1? How would you describe it?
I would describe it as a compilation of the video that we obtained from Utah Valley University during the course of the investigation. that depicts the movements of the individual I believe to be Mr. Robinson moving around the campus on September 10th, 2025 into the morning of September 11th, 2025.
Did you prepare this video compilation?
I did not.
Okay, do you know who did?
Yes, Utah County Attorney's Office. I believe Ms. Durfler is the one that produced the video.
Okay. Do you know Ms. Durfler's first name?
Kimberly?
Okay. What, if anything, did you do to authenticate the video in this compilation?
I reviewed the video to make sure that it was a reflection of what I understood the original videos to show.
Okay. What, if anything else, did you do?
I reviewed it. I know that there was some zooms and some changes to the footage.
Okay. Did you meet with Mr. Olson with regards to this particular video?
Yes, this video was also part of that original meeting with Mr. Olson for the prior exhibit, yes.
Okay. So at the same time, you sat down with Mr. Olson and discussed the prior exhibit. And let's just be clear which exhibit that is. So I believe the 1102 statement that you gathered from him is exhibit 12.3, correct?
Yes.
Okay, so the same time that you gathered that 12.3 or that written statement that states exhibit 12.3, you talked to him about this specific exhibit as well?
Yes, Mr. Olson was shown this exhibit.
Okay. And did he include that in that 1102 statement?
Yeah, I believe he specifically referenced the exhibit by name, stating that it was a true reflection of the footage from the campus.
Okay. And let's just go back to what you were stating earlier. To you, it appears to be a compilation of videos that you've already seen,
Correct.
that you received as a mass dump, I guess, for lack of a better term, of view video. Is that fair to say?
Yes.
You could probably pick a better term than
And
mass dump.
The exhibit 12.1, does it appear to be the same as the raw video that you've seen previously?
It does, yes.
Okay. Are there some minor, are there any added additions or anything different about this particular exhibit?
There are some portions of the video where a zoom is initiated, which wasn't a function of the cameras. I believe some specific individuals have been blurred from the footage. And I believe there are some red circles to show poignant information or individuals within the footage itself.
Okay. So other than the red circles, the blur, and the zoom, does it appear to accurately depict what you've seen in the raw video footage?
I believe so, yes.
On your screen, I'm going to have displayed an image. Let me know when you see it.
The image is there now. Oh, it's gone again.
Is it there?
We're back, yeah.
Okay, we're back. So do you recognize what this is?
Yeah, this is the first frame of the video compilation that we just referenced.
Okay. And again, this video portrays what you believe is Mr. Robinson visiting campus that day?
Correct.
Okay, and is it throughout the day?
It is, yes.
And then I believe you said into the early morning hours of the 11th, is that right?
Correct.
Okay. Just the state would seek, or would move to admit what's been marked State's Exhibit 12.1.
Ms. Nestor?
Your Honor, we have objections to its admissibility. This is a compilation video that was put together from
We
a
know.
bunch of different sources by
He
the
said that a
county
couple
attorney's
times.
office. This individual did not create this compilation, can't testify to the accuracy of the actual materials that it was taken from. And furthermore, Mr. Olson himself is just referred to by Agent Hull. He specifically says people have altered these recordings. They've zoomed in when the actual recording isn't zoomed. They've added little circles to people they want you to pay attention to. They've blurred people's faces out. So, I mean, it's been clearly altered. And it's not, I mean, they admit it's been altered. So we have real concern about authenticity of it. Furthermore, this particular video should be protected. And so that deals with the admissibility factor. As far as the publication factor of it, the video should be classified as protected under UCJA 4-202.02 subsection 5, J is in jelly bean, and then little I and little double I, because this is going to interfere with the defense's ongoing investigation, with Mr. Tyler's ability, with Mr. Robinson's ability to get a fair trial. This is basically putting together photos that are clear with photos that aren't clear, putting them all together in such a format that it makes the case that it's all one person. It would be extremely prejudicial for people that may ultimately serve on this jury to watch this video before this case goes to trial. We don't believe a proper foundation's been laid, which would make it admissible at this point. So the fact that it would be shown to the public would be extremely damaging to the ability to put on a defense at trial. And so we object to its publication both in the courtroom and to the media, Your Honor.
Mr. Sturgill.
Judge, Ms. Nestor is correct. This is a compilation of a series of videos. The videos, as Sergeant Hull has testified to, is a compilation of raw videos that he has received from Utah Valley University. And he has not only seen this video, but he has seen all the raw footage. And by his estimation, or according to his testimony, these are all videos that are accurate and they depict what the raw footage depicts, other than those minor additions. Judge, if you refer to Mr. Olson's written statement, it's Plaintiff's Exhibit 12.3. He too has reviewed this video, and he has also identified this video as being accurate with the exception of those additions.
You guys hate her.
In his words, it's the zooms and the red highlights. They weren't part of the original recording, according to Mr. Olson. But other than that, as he states, the same as Agent Hull, these videos are accurate, and they were captured by UVU surveillance video.
Do you have a version of this video that does not have alterations, such as zooming or circling? My concern is that if the 1102 says what it says about the videos, these were the videos.
Right.
But then it was altered. And typically an exhibit which has been altered, and if it wasn't done by the person who supplied the 1102, that can become problematic.
I pulled this up
So
just
do
to
you have a
highlight that they
version
do.
of
This has been
exhibit
produced.
that does not have the zooming in or the circling?
was like 300
Again, I
terabytes
don't
of
know all
stuff.
the alterations that were made, but that seems to fall outside the 1102 because you don't have a person testifying 1102 saying, I made the alterations.
And here's what the
And so
alterations
that's the
are.
concern of the state, of what Ms. Nestor was talking about as it relates to the state's evidence. I have that concern about those alterations. I don't know when they were made, what they were made, how much was done to manipulate the video. And I say manipulate to, not saying it in a nefarious way, but I don't know what the scope of that is and how much it deviates from what was the original form.
Well, Judge, to answer your first question, do we have a version of this particular video that has not been altered? We don't, not right now, not today. I guess there's a couple of things I'd simply like to point out, Judge, and that is that we have two witnesses who have watched the raw footage. And Agent Hull here today on the stand and Mr. Olson in the form of his written statement, they have both said that this video, with the exception of these alterations, accurately depicts the video that was captured by UVU surveillance video. Judge, I will proffer that those changes made to the video were not done by either. I know who that person is. We could actually call that person as a witness if that would cure that. And we're prepared to do that if necessary. But Judge, I think that our burden is to simply authenticate, what this is.
Throw the intern under the bus.
It is a video that, with only a few exceptions, alterations, that really don't change the substance of the video or the content of the video. They're accurate. They depict what the cameras captured on September 10th and the 11th. And we have two people who have seen that raw footage, and they've explained that's the only difference between what we have originally in the original videos and what you're seeing here today. And the additions, I will submit, Judge, were only added to make it easier to view.
All right. Anything
Oh, we
further
know.
from the parties?
We know why you altered it.
All right, I'm going to go ahead and I'm sustaining the objection. Typically, when exhibits are admitted to the court, it is without alteration. If a party circles an exhibit, a photograph, that's not the original format, and I do not have the person who made the alteration, an 1102, to substantiate that. And what I have is the original video, and Mr. Olson saying, this is the video minus the alterations. And we have Agent Hull saying, this is the video and there are alterations, but I'm missing a link. And it may be minor, but in this type of case, I want to be thorough. And I want to make sure that what is minor is still important. And for those reasons, I'm going to sustain the objection and leave it to the parties on how you wish to handle the video in the future. I don't want to provide guidance either way.
Right.
But as it stands today, this exhibit, state's exhibits
They're going to fix it. They have a week.
12.1 is not
They'll
admitted.
put the intern on the
Judge, can I have
stand,
just one moment?
You may.
or they'll get a copy of the video before the intern went in and zoomed and put the circles on it and whatever. This is Judge Graff having an abundance of caution, in my opinion, because they have identified what the alterations were. They've said the alterations are zooms, red circles, faces blurred. So when we watch the video, we know, hey, we see that, that's an alteration. We see that, that's an alteration. And then that helps us weigh, what it is that we're seeing. We know the original camera didn't zoom in on this or whatever. That was a person who watched it. So for purposes of this hearing, personally, I think many judges would probably be fine with it. He is in an abundance of caution, not doing that. It's fine. It's his prerogative. It is going to be curable. If this freaking prosecutor can figure out how to do anything, I mean, good Lord, he's struggling.
Agent Hull, you testified that there were 4 visits to campus that day.
Correct, yes.
And the first 3 visits, based on what you have observed, is your opinion that those videos were captured by UVU, surveillance video, is that correct?
That is correct, yes.
Okay. The 4th visit, well,
Ask a non-leading question.
the 4th visit too was captured by UVU surveillance video, is that correct?
Correct.
Okay. Was there any other video that was collected either on the 10th or the 11th that you believe might be important or relevant to today's hearing?
There was a large amount of video that
Well,
was,
I'm going to be a little bit more specific. Was there, other than UVU surveillance video, was there any other video that you collected and subsequently gathered an 1102 statement for?
yes, we collected Ring doorbell footage from the surrounding neighborhoods.
Okay. Let me ask you this. Did that include video from a residence located at 680 West, 925 South Orem.
Yes, that's in the horseshoe area. Yep,
Okay. That's in Orem
correct.
and close to campus.
It is, yes.
Okay. And what can you tell us about that video?
There was a Ring doorbell video that was provided that showed a vehicle consistent with the one we had identified as belonging to Mr. Robinson,
Okay.
parking in front of the residence across the street.
Okay. And what can you tell us about the timing and the timing of that parked vehicle?
If I recall.
This is your
that
best evidence
vehicle
objection,
parked
Kathy.
Approximately 0:38 hours on the morning of the 11th.
Okay. So 0:38 hours, what time is that to regular people?
Just after midnight
At 12:38 a.m.?
in the morning, yes.
Okay. So how did this video come to your attention that you're talking about, this doorbell or whatever?
This footage was obtained as part of the canvass of the area that was conducted as part of the investigation.
Were you able to identify the owners of that residence,
Yes,
where that video was collected from?
correct.
Okay. And do you know who it was collected from and by whom?
It was Mr. and Mrs. Noble. I believe Agent Davis collected the video directly from them.
Okay. And do you know what date it was collected?
If I can refresh from my notes.
If referring to your notes will refresh your memory, go ahead and look at that. Don't read it out loud.
I don't have the specific date, but I do know that myself and Agent Davis returned to the address as we had done with previous videos and had the owners of the video verify that it was from their system. And we did have them complete an 1102 statement, which would be dated.
Okay. Do you know, so let's talk about this, what does this video look like?
It's a nighttime view looking from the front porch of the residence across the street.
Okay. And what about that video? Why was this particular video significant to you, or why do you think it was related to this case?
We know from the UVU footage that the person we believe to be Mr. Robinson had an interaction with law enforcement. And a short period after that, the vehicle comes to that house. And some additional evidence that was collected from cell phone data and things indicated that Mr. Robinson was in the area, and we were able to locate the footage of his vehicle on that Ring doorbell camera.
Or at least what you believe is his vehicle?
Yeah, the
Cell
vehicle
phone
believed to
data.
belong to Mr. Robinson, yes.
And is there something about this particular video and this this, I guess, vehicle that was captured that leads you to believe that it was Mr. Robinson's vehicle?
Yeah, the vehicle has very distinct wheels. I won't say that they're
Oh.
wholly unique, but in terms of the video footage that we were reviewing, the wheels on the vehicle are fairly unique and stand out.
Like
on the
Richard
video
Allen
footage.
unique or like actually unique?
And so again, this is video that you received early on in the investigation.
Yes,
And then in preparation for the preliminary hearing, you went back out and you met with someone about this video.
correct.
Who specifically did you meet with about this video?
Met with Mrs. Noble.
And what did you do with Miss Noble?
We did what we had done before. We had a specific file that we wanted, or files that we wanted her to verify. The footage itself is broken into, I believe, 10-second segments. So we had specific files that we had her view and confirm that they were actually from her system. Those were written on the 1102 as they have been before.
Okay, and who wrote those file names on this particular statement?
I believe it would be my handwriting on the 1102.
All right. What did you do next?
We had her view the videos and then complete a statement verifying the authenticity of those videos on an 1102.
Okay. Was this also prepared on a State Bureau form?
I believe this was on a State Bureau Investigations form, yes.
And in this particular form on which Ms. Noble provided her statement, does it have the advisory that it would be used in lieu of her testimony here today?
It does, yes.
Does it also contain a warning that if she gave a false statement, she would be punished, or it's punishable by a Class A misdemeanor?
Correct.
Okay. I'm going to have displayed on your monitor what's been marked State's Exhibit number 13 for identification. Let me know when you see that, would you?
I can see that.
Okay, and I'm going to have my assistant scroll through that slowly. Okay. Do you recognize that?
I do, yes.
What is that?
The 1102 that myself and Agent Davis collected from Ms. Noble.
Okay, and it appears, does it appear to be in the same condition as when you collected it?
It does, yes.
This is a copy, right?
Yes.
Okay. And the personal identifying information appears to be redacted, is that right?
It has been redacted, yes.
Okay. It wasn't redacted when you collected it, right?
No, the original form was not redacted.
So other than the redactions, it appears to be in the same condition as it was when you collected it.
That is correct.
State would move to admit Exhibit 13.
Ms. Nestor?
I know we renew our concern about unconstitutional hearsay being admitted. We also have the same concerns about the fact that the Agent Hole amended this himself, and there's no foundation as to when he filled that in, if it was before or after she signed it. And due to all those reasons, we object to its admission and object to its publication as well.
Mr. Sturgill?
Judge, again, it was collected in compliance with Rule 1102 of the Utah Rules of Evidence, specifically subsection B8. It's in writing. It's on a form. It includes both the advisory and the warning. And it was collected by Agent Hull. It's also collected in compliance and being introduced as reliable hearsay, which is lawful to do here in Utah under the state constitution, Article 1, Section 12.
Do you wish to lay more foundation about when the statement was written, whether it was before it was signed or not?
I can do that, Judge. I appreciate that, yes. Agent Hull, do you recall when you collected this written statement from Ms. Noble?
Yes, it was in April,
In April, do you know what day?
April 6th, I believe.
Okay. And you collected it, did you go to her home? I think, is that what you said?
Yes, myself and Agent Davis went to the residence.
Okay. And did you sit there while she prepared it?
I did, yes.
And did you witness her sign it?
I did, yes.
Okay. At this point, I'd move to admit
The amendment?
Exhibit 13.
The amendment?
All right, and to the state representative, could you scroll down?
Oh,
Okay.
this guy's going to drive me insane.
All right, pursuant to the Utah Rule of Evidence 1102 and Article 1, Section 28, Article 1, Section 12, which allows for reliable hearsay, I'm going to move it into, it's going to be admitted into evidence over the objection of defense. I note in particular that it states that I confirm that the above files were taken from our Nest doorbell videos and are accurate. And right before that statement is the notations that were allegedly made by Agent Hull. And so for those reasons, the court finds proper foundation has been
Busted my
laid,
balls.
and that this exhibit in its entirety is admitted into evidence. As it relates to publication, I will authorize publication in the courtroom and by the media if they so wish to capture it in that form. Again, following the same format, have it on that first portion of the screen for about 10 seconds, and then scroll down to the written portion for about 15 seconds, and then scroll to the very bottom to ensure that the full exhibit has been displayed. All right, that concludes the publication of State's Exhibit 13.
Okay. Thank you, Judge. The video that you took with you that day when you visited with Noble, or Miss Noble, had you previously, well, you've stated that the videos that you showed, the Nobles, were actually more than one video.
Correct.
Okay, and I believe you said they were like 10-second clips,
If I recall correctly.
short
yes.
clips. Okay. And you showed Miss Noble all of those videos that are identified in that statement.
The one shown on the statement was shown to Ms. Noble, yes.
Have you had a chance to review what's been marked State's Exhibit number 12.2?
Yes.
Okay, and when did you have a chance to review that exhibit?
I believe that was reviewed last week, I believe,
Okay,
with yourself.
okay. And does that video, is it a single video that you watched?
No, I believe it's 4 separate short videos.
Okay. And as far as, and I understand that, but as far as 12.2 is concerned, what does that exhibit consist of?
It shows the vehicle believed to be driven by Mr. Robinson arriving in front of the residence, an individual exiting the vehicle and moving away from it, followed by an individual returning to the vehicle and unlocking it. And then it shows the vehicle a short time later starting and leaving the area.
And those are the videos that you showed Miss Noble?
Yes.
Okay.
And you're going to show all of us? No, because you can't.
What I have
'cause you've got
displayed on your
credits.
monitor was Ben Mark's plaintiffs or State's Exhibit 12.2 for identification. Let me know as soon as you see, should be a still image.
It's there.
Do you recognize what's depicted there?
Yeah, this is the view looking what would essentially be west across the street from the Nobles residence.
Okay. At 12:38 a.m., I guess, or 0:38?
Yes.
Okay. And what is depicted in this? I think you've already described that. So, Judge, I would move to admit Exhibit 12.2.
Ms. Nestor.
Your Honor, we renew our objection to allowing in the evidence without the sponsoring witness. I do have some concerns because I'm not totally sure if this is a compilation, or if this is just one of the 1, 2, 3, 4, 5, at least 6 videos they took from the Nobles. So if we could have that clarification, I think that concerns me about authenticity, that I don't understand if this is just a portion or if this is the whole thing, or is this just all of them or none of them. And for those reasons, we object to the admission and to publication.
Thank you. Mr. Sturgill.
That's a good point. And I'll ask additional questions before I seek to admit it. Agent Hull, this particular video, you've described taking several videos to Ms. Noble and having her review them.
Yes.
Okay. This particular exhibit, 12.2, have you watched it in its entirety?
Yes.
Does it consist of either some or all of those videos that you showed Ms. Noble?
It does, yes.
Okay. And is it a single video? Is it a compilation?
So is it
that
some
to say,
or all?
Or is it 4 different videos?
It would
Or a number of different videos?
be a number of short videos sequenced.
Okay. A number of short videos in sequence?
I believe that's how this one plays, yes.
Okay. Just again, I seek to admit it.
Anything further from the parties? All right. Given my previous rulings on exhibits, I applied the same analysis and find that State's Exhibit 12.2, I believe, is admitted over the objection and may be published in the courtroom and by the media, if so chosen.
Okay, so before we play this video, again, what is it that leads you to believe that this is Mr. Robinson's vehicle?
The shape of the vehicle can be clearly seen as it pulls up, and the distinctive wheels on the vehicle also.
And well, let's go ahead and play it.
Is there any
Yeah, how
sound
distinctive
associated
are
with
they?
this?
There is, Judge, but it's night sounds. It's crickets chirping and,
Okay, I just wanted to
there's-
see if there
what's that?
was, I just wanted to see if
There's
there
nothing
was sound or
violent.
not. Okay.
Yeah.
All right, you may play the video.
Aftermarket, fancy racing, distinctive wheels? Or just, those aren't the stock wheels? You're saying you can see the wheels on that? Okay, now we can. Shiny silver wheels. Spokes, maybe? I didn't see anybody get out of the car.
so in the first part of that video, what do you see?
The vehicle we believe to be driven by Mr. Robinson pulling up and parking in front of across the street, but in front of the residence.
Okay. And then in the next video, what do you believe is displayed in that video?
There's an individual who gets out of the vehicle. You can hear the door close, and then that individual moves away from the front of the vehicle. There's actually two reflective panels on a dumpster, and you can see the individual past those reflective panels.
And in the last of those series of videos?
The second to last one, the individual comes back across those reflective panels to the vehicle, unlocks the vehicle and gets into it. And then in the last video, the vehicle is started and the individual drives away.
Just one moment, Judge.
Yes.
Yeah, can't say that was a really overwhelming piece of evidence right there. Now, granted, our view from home, from the back of the courtroom, zoomed in on the thing, etc., probably didn't help. But I'm sorry, I'm having a hard time.
You may.
Catching the special wheels on that. Oops. I'm going to have built-in skepticism to the special wheels because of the Richard Allen bullshit. That was, that was one of the things with one of the videos that they claim this car is his because of the special wheels. And they, number one, not only weren't special wheels, they were just not the stock wheels, but they were wheels available through an upgrade. Like you get one of the specific trim models for this car, and you get a racing type wheel. So it's like, it doesn't really make it that unique. But also you really couldn't tell on the video. Again, you couldn't even tell it was the right kind of car, let alone that that it was had some kind of special wheels on it. So I'm definitely going to be very skeptical of the identifying a car by special wheels. Where he's hinted where this will go at trial is they will corroborate it through cell location data. So when they can put him and his phone in the same location as this car across the street, okay, that's going to make a stronger case that it's him and his car, in my personal opinion. Really not sure why we're having this sidebar right now, but didn't quite catch where this might be going. That would be awkward. Yep. Don't blame you one bit. Don't blame you one bit on that one. See, I don't think this is it because the judge has already said he's not going to advise them on how to fix their problems with their case. That's their job. He's not your advocate. He's not the lawyer for the state's lawyers to tell them how to do their lawyering. They're going to need to go figure that out. There's a bunch of different pathways they could do it. Identify the source of the alterations and what they are, you know, put the intern on the stand, or just come back tomorrow with the raw, you know, the original that the intern altered. They're going up to the stand.
Ladies and gentlemen, we're going to take a 10-minute break for the attorneys to confer and come back at, well, roughly 4:30. So court is in recess.
All right.
And they're going to confer. So, I think this may be about something like, are we going to take a witness out of order, or, you know, going to have any problem if I rest now and then come back later, you know, with the corrected video? Maybe it's something like that, logistics. It's about all I can come up with if they've got to confer about it. Maybe the exhibit, the original, because remember they're supposed to produce all of this, you know, all their exhibits and things like that before the hearing. Their witness list, you know, has this compilation. It's all there as Exhibit 12. Defense hasn't got notice of a different exhibit, so I guess they kind of have to agree to it. Or maybe there's no notice. I don't know. This is logistical stuff. It's just the kind of thing that happens. Why would you not just present the raw data? I don't know. They're already preparing for you know, the show that they need to put on when it's trial time, and the jury needs to be impressed with the bells and whistles and stuff like that. So they're already kind of thinking in that mindset and preparing those types of things. And maybe it's good for them to have the trial run right here, since this prosecutor seems really, really not good at a lot of these kind of trial fundamentals. Now you see, okay, you tried it out. Now you see where it works and where it doesn't. So maybe that's part of what this is about. I really don't know. The easy thing, of course, is just put up the raw stuff that you got. Okay, maybe you have to show it multiple times. You know, meaning like you have to show, instead of having a nice video compilation exhibit that shows everything you want, you have to show 4 separate exhibits that are individual videos that went into your compilation. It's like there's trade-offs kind of with all of this, but just the problem that they're having with some of this real basic stuff is not really boding well for getting this kind of thing in at trial. Evidence is just basic lawyering 101. If you are going to be in trial, if you're going to be in a courtroom, you need to know all of the rules about all of your evidence and how you're going to deal with objections. You need to anticipate all of that. You need to prepare for it. You need to have your pathways, your plan for how do I get this thing into evidence? What do I need to do? What's the rule? What are the potential objections? Like, if you haven't done that, then yeah, you might get caught out in the cold with a piece of evidence that you weren't able to get in, that you needed to rely on. So it always baffles me, particularly when they have this level of experience, to see them struggling so much with some of this fundamental stuff, because that's really the basics. Your evidence is the key to your case. And so if you have not figured out the pathway to admit every single thing you want to get in front of the fact finder, then you're not really prepared. Just got to call it like I see it. Okay, this is where we were. Now that video was played in court, while it can be withheld until after trial, that exhibit must be released to the public after trial, correct? No, it's more nuanced than that. Now that it has been played in court, it is a judicial record. It is part of the adjudicative process. It's very specifically something that the judge is going to rely on for purposes of making a substantive decision in the case, meaning is there probable cause to proceed or not. So that means there is a much stronger presumption of a public right of access to it than there is to just some like random discovery motion or something like that. So highest level of kind of presumption of public access. But the presumption is not absolute. I did just very briefly do a 10,000 foot view from the Reporters Committee. Has all kinds of great resources on like different jurisdictions and things like that. Anyway, so I looked at what they have on the 10th Circuit. The 10th Circuit does not automatically treat the public right of access to court documents as a First Amendment right. Your right to sit in the courtroom in person and watch what is happening, this is understood to be a First Amendment right. That comes from the U.S. Supreme Court. But documents don't always get recognized as having a First Amendment right of access associated to it. There is a common law right of access that every court recognizes, but the First Amendment, not a given. So 10th Amendment has not specifically found, yes, there is a First Amendment right to adjudicative records like these exhibits. That said, it appears the test that they apply is the test that is the normal First Amendment test. We call it the press enterprise test from the case that gave rise to it. Or call it the experience and logic test. The press enterprise was a case by the U.S. Supreme Court from the 1980s that found public right of access to certain court proceedings, pretrial proceedings, motions to suppress, preliminary hearings, things like that. And so what they look at is whether there is a, let me get the wording exactly right. Whether the place and process have historically been open to the press and the general public, that's the history, and whether public access plays a significant positive role in the functioning of the particular process in question. Is it important for the integrity of the process, for public confidence in the proceeding, and things like that to be able to see it? So anytime they're going to apply the experience and logic test, they have wiggle room with the history side of it, right? Because let's say here in Utah, we just have never really made the exhibits from the preliminary hearings available. Maybe everywhere else in the country does, but we here in Utah don't. Then they in Utah are going to say, we don't have a history and tradition of this. And so it just depends on how narrowly or broadly you focus the question of what the history or tradition is. So that's a potential stumbling block. They do have that case that they've relied on previously in a lot of these decisions. Archuleta, the Archuleta case was one that involved denial of access to the exhibits in the preliminary hearing. That was a particularly bad case. There were like more complications, I think, beyond just the gruesomeness aspect that we're going to be dealing with here with a lot of these exhibits. It was a bad case, guys. It was really bad. There was there's just other issues with it. It's really kind of as far as I want to go with it. It's very inflammatory, and particularly, you know, in this area and at this time. So Archuleta is precedent from the 1980s, I think, from Utah, that you don't automatically get access to preliminary hearing exhibits. But even if they do find the history and experience and logic test has been satisfied, yes, there's a First Amendment right to it. It is still only a qualified right. It's not an absolute right. And so what overcomes constitutional rights? Strict scrutiny, things that pass strict scrutiny. There is a compelling interest, and the remedy here is narrowly tailored to satisfy it. There's no question, I think, that they're going to focus on the victim's rights under, under Utah law, the dignity and so forth. Is it a dignified thing for there to be like 500 gazillion angles of Charlie Kirk being shot in high definition, you know, such graphic detail that even the judge, who has like one of the best poker faces we've seen in a long time, he is so calm, he is so reserved, and even he jumps, okay, during this video. Does that need to be everywhere? Is that helpful to Charlie's legacy, memory, things like that? I understand the argument that it's not. I understand the argument that it's important to understand, you know, the evidence for the case as well. That's the question they're going to be dealing with, and that's kind of how the ruling on this would ultimately be framed. Very first question: is this even First Amendment protected under the 10th Circuit precedent in the first place? Because there may not be a history and tradition of access to preliminary hearing exhibits in Utah. But even if it is it a compelling interest to protect Charlie's dignity? And is that overridden by, you know, like, is it too broad? Is there other ways? I mean, that's the other thing that comes up with you know, crime scene photos and graphic images and things like that. There's kind of different ways that it can be handled to minimize like the worst part of it. But like, sometimes people are like blacked out, you know, so you don't see detail, but you can, like, you know, see the position of the body, stuff like that. Sometimes there's things like that that can more narrowly tailor than just flat out, no, you don't get the exhibit at all. Obviously, without seeing it, no idea if any of that is really feasible, or if that would kind of like defeat the purpose anyway. I mean, that's why people want to see it, right? People want to be able to zoom in and watch it in slow-mo and back up and forward and a gazillion times and everything, so that they can decide if they think it's a bullet or not. Is that an interest that is sufficiently strong to warrant treating a human being with that kind of just dehumanization? That's going to be the struggle. So it's not automatic. There is definitely a very strong presumption in favor of it, but not an absolute by any stretch of the imagination. The Right Flux, looking forward to your PM analysis. Hope you'll address the seemingly wobbly judge's posture in this pretrial. Is he too green a judge for this case? I don't think so at all. I've been very impressed with Judge Graff. His history before going on the bench was as a prosecutor and also as an appellate prosecutor. So he's a law guy. He gets the law, understands the ins and outs, knows the nuances. The courtroom stuff can be a little bit trickier sometimes, but I haven't really seen anything that raises a big red flag for me. Where, you know, he's wobbly, I guess he will reconsider himself. And to me, that's not a bad thing at all. I don't like when a judge just like makes a snap decision and then they're fixed in it and refuse to consider kind of any reason why maybe they got it wrong. Maybe that was a bad idea. He seems very ego minimal, you know, doesn't mind changing his mind or anything like that. People are going to push the boundaries. as soon as the camera zooms over to see the exhibit, I'm already thinking like, so has there been a revision of the rules? Did they like have a chat about this? Because yeah, it seemed like he said before, like we weren't going to see, but now we're seeing. And is this like, but then he, kind of changed around how we're going to handle the objections and stuff. I think there's going to be a learning process for everybody. It's not because this judge is green. It's just because everybody is kind of getting to know everybody and how they operate. And one thing that seems to me at this point to be kind of a good takeaway is that explicit is really important. Judge, you got to be real explicit about your expectations. He's already figured this out too. He's already telling them, you guys need to be real specific about your objections. Okay, we got these 3 separate issues and you need to be very explicit about each one. But I think the same thing goes in reverse. Judge, if you're going to tweak anything, you need to be real specific about what it is, because otherwise people aren't going to know and they're going to guess, and they're going to guess. I mean, at least the media is going to guess in favor of, I'm going to show it, right? That's kind of their job. So I think there's always a learning process anytime, especially like we've got a whole new prosecutor here today, this Mr. Sturgill guy. Send him home, bench this guy. Okay. Send him back to Lehigh Valley. Mr. Grunander was doing great. Not sure that Mr. Sturgill is a value add here, but anyway, everybody's going to get to know everybody, and there's always figuring out like, oh, this guy doesn't get that, or oh, she's going to do this unless I do the other. So they figure those things out, and then they adjust as the case goes on, and they get a little bit more experience with each other. We have some new members here. Alpha She-Wolf 26 has joined us. Welcome, welcome. Suze Annie has joined us. Welcome, Suze Annie. Appreciate having you guys here supporting us. A beautiful messy ball. At what point in Karen Reed and Richard Allen did you decide something was amiss and corrupt? At what point do you decide to acknowledge corruption? Well, I'll tell you what happened in Karen Reed and Richard Allen that carried a lot of weight with me. The defense told me that's what the defense was. Okay? Okay? Nobody mind read the case and tried to force feed some theory. I mean, it's just like, it continues to blow my mind, the arrogance of some of this stuff. You have any idea how much information asymmetry there is between people on the internet looking at stuff and the defense team? You know how much more information they have than you do? It's overwhelming. It's overwhelming. So the defense is in the best position to know what the defense is, including if there's corruption. And so when the defense tells me there's corruption, I'll take that seriously and I'll evaluate that. Until the defense tells me, I don't know why anybody would think they got some great insight that the defense doesn't have. I also don't know why anybody would think the defense is here re-saying the same objection for like the 50th time. Okay, the objection that was based on the legal argument that everybody knew they were going to lose. It's pro forma. There is controlling Utah law against it. You are literally doing this to preserve your record for federal habeas corpus review. That is like the level of protecting his rights they're going to. And you think they have fraud and corruption and they're just not going to mention that? It's nonsense. Okay, it's nonsense. So to answer your question, when Karen Reed and her defense team told me there's problems here, they said there was video. There's no video. They've been doing all these shenanigans with the discovery, been withholding all this type of stuff. There's been this whole federal investigation, by the way, that's gone on, that we got all of this information about it that undercuts what the prosecuting attorney has been saying. By the way, Karen Reed was framed. Remember that? Remember that? Karen Reed was framed. Yeah. When Richard Allen, his attorneys, like the day after they got appointed, roughly thereabouts, issued a press release saying he's innocent and there's like some very serious concerns about this process and things like that. I took that seriously. You know what I haven't heard one single goddamn word from Tyler Robinson's attorneys about? Factual innocence. Not a word. As soon as they do, I'll be the first one to listen. But I'm not going to force the defense on them. And there's a reason why they don't want to be associated with any of that, guys. There's a
Court is
reason
back
why
in
they don't want to.
session. We ended with the parties, the attorneys discussing. How would we like to proceed?
Judge, I think I just have a couple of questions for Sergeant Hull. To finish out the day, I think we're in agreement that once we've sorted out these few questions, we're all in agreement that we want to break for the day. Is that right, Ms. Nestor? Well, yeah, sure.
You may proceed with your questions, and
Okay.
we'll take it from there.
All right.
Thank you, Kay.
Agent Hull, I asked you earlier, after you had testified about all the video that you've watched, and video that you believe depicts Mr. Robinson from the UVU surveillance, and that combined with the driver's license and the DMV records, whether or not you believe that that person that you have seen in the video and on the driver's license record is in the courtroom today. And I believe your answer was yes.
Yes, that's correct.
And then I asked you if you wouldn't mind pointing him out and describing something that he's wearing. And I don't believe that I allowed you to do that.
Okay.
Would you do that right now?
Your Honor, just for the record, we would impose an objection based on the 14th Amendment for due process due to an unduly suggestive in-court ID. Also, we believe there's a lack of foundation establishing his ability to interpret the surveillance video. And based on that, we would object.
All right. I note that, well, to the state, do you wish to be heard on what was just stated?
Well, Judge, I think we had this discussion, and I think you ruled on that specific objection. And then after you ruled, I just neglected to come back and follow through with the question and the answer. That's my recollection of the bench meeting.
I believe I stated for the purposes of this hearing that identification by Agent Hull of Mr. Robinson was made. I could be wrong, but
Well, and I just wanted to clarify that, Judge, because there was some question about whether that in fact did happen. And so if that's your recollection of what happened, and if you're willing to put on the record that Agent Hull has identified the defendant, I think we're done.
does the defense want to be heard?
Not sure how to
Of course.
answer that.
Your Honor.
Well, if for the benefit of the record and for thoroughness, if you wish to re-ask that question, you certainly.
Oh, my
well,
Lord.
We can see what happens.
If I could, Judge, I'd like to. Would
Point
you
the finger
please
at him.
point him out and identify something that he is wearing?
Yeah, I
Need that
believe
moment.
Mr. Robinson is between Ms. Nestor and other counsel wearing a grey suit, jacket with a dark tie, and a light-colored shirt.
Judge, I would ask that the record reflect that Agent Hull has identified the defendant.
You've so asked.
I have no, I mean, I made my objection already.
Okay, I just wanted to check.
No, thank you,
All
Your Honor.
right. For the purposes of this hearing, I find that Agent Hull has identified Mr. Robinson. Again, this is only for the preliminary hearing. You may proceed.
Judge, I think for today, with Agent Hull, we're done for today. We'd ask that at this
She
point. we
gets
take a break
cross,
until
dude.
tomorrow.
She gets cross.
All right, so are you saying that you're going to recall Agent, well, we're going to
let me-
resume with Mr. Hall tomorrow morning?
Tomorrow morning, and let me explain and I was going to explain this, but let me explain why. Judge, our intent is to prepare an original version of the video that has been in dispute today. without the circles, without the blur, and without the zooming in. And our intent is to introduce that tomorrow as a different exhibit. And we just can't prepare that in the next hour or so. So we're going to need this evening to prepare that exhibit. And we'd like to return with that. Judge, what I would also suggest, well, let me get your take on that, Judge.
All right. Does the defense wish to be heard about ending for the day? We have about 19 minutes until 5 o'clock. What is the defense?
Your Honor, we're happy to accommodate the state on that.
All right. So for today, Agent Hall, you may step down, and we'll resume with your testimony tomorrow morning. Anything further, Mr. Sturgill?
Well, Judge, just one other thing, and it's a suggestion.
Agent Hall, can you wait just 1 second? I'm sorry. Go ahead.
I'm sure Ms. Nestor may have a position with regards to this, but Judge, we would invite you to review the exhibit that we've been talking about today. It is 12.1. We suggest that you look at it between today and tomorrow, because our intent is to seek to admit the version where it doesn't have the circle or the blur or the zoom in, and if that is admitted, we do intend to introduce that exhibit 12.1 as well. And I think it would be helpful if you saw that in advance, and you could compare that to the version that doesn't have the circle, the blur, and the zooming in. I would ask that you do that. I don't know if Ms. Nestor has a different opinion about that, but I think it would be helpful in determining whether or not that particular exhibit, 12.1, is admissible.
Ms. Nestor.
I don't have anything to add to that. I defer to what the court prefers to do on that. I do have another matter before Agent Hull's release that I do want to address with the court, but I don't have any concern if the court wants to look at it in advance. It's kind of a little bit of a long video. I think it's just about 5 minutes, maybe. It's not very long. So if you want to wait until tomorrow, it's not going to slow the matter down very much, but it's up to the court on that.
All right, I appreciate the parties. What I'm going to do is I'm going to wait until it's properly before me and a motion has been made for either of the videos, and then I'm happy to entertain the motion to review both of them, or however the parties. I don't want to issue a pre-ruling, so I'll wait till it's properly before me, and I can take it from there. Being that it's about 5 minutes, I'm not too concerned about how much time is needed. I also want to be thorough, so I'll wait till it's brought before me and we can address it from there. And turning to Ms. Nestor as it relates to your request.
Thank you, Your Honor. Your Honor, I recognize that Agent Hull is the case agent and is working with the state in preparing for this, but he is still on the stand, and I would ask that he be instructed that he can't discuss his testimony, even though he's the case agent. I don't think it's proper for him to discuss his testimony while he's excused for the night.
Mr. Sturgill. All right, so Agent, from this moment on until we come back in court, you're instructed not to discuss your testimony with anyone, as you are still on the stand for all intents and purposes. And we'll, if the state recalls you this tomorrow morning, then we'll proceed, okay?
Okay, Your Honor.
All right, may this witness be excused.
For now, Your Honor.
For today, all right. Thank you, Agent Hall. Anything further from the parties, or do either party need the benefit of the record before we adjourn?
No, Your Honor.
Not from the state, Judge.
All right, noting neither party wishes the benefit of the record, court is in recess until 9 a.m. tomorrow morning.
All rise.
9 a.m. tomorrow morning, which will be 8 a.m. Pacific time here. Once again, do the math for your time zone, whatever it may be. Well. Not a lot of highlights today. Some highlights. Christopher Bagley and David Hull witnesses for the day. From Christopher Bagley, we got, I heard a gunshot. We heard a gunshot, and it was a rifle, not a handgun. We know because of the crack versus bang distinction. Crack versus bang. We know they photographed the screwdriver up there on the roof, as well as the impressions of what he called the sniper pad that showed impressions from elbows, knees, and feet, where a person lied in a prone position. Also a shoe impression on the grass, as well as a scuff on the northeast corner of the Losee building. The shoe impression on the grass, this has got to just be, you know, there's no detail. We surely are not talking about like a footprint with, you know, the sole of the shoe, like leaving a distinctive mark. I mean, I'm sure we're just talking about some flat grass, but I don't know if it's muddy or the grass is thin. We don't get to see it, so could be a little more than just corroboration of what was seen on the camera, and not really that important, or it could be something more specific. Not a lot of detail on that yet. But then we also heard there were other bullets found at the scene, as well as this holster for a pistol that was found at the top of the amphitheater. So defense is eliciting those. We of course already know multiple videos. This isn't really any real new information. Dr. Guajardo's autopsy report is in the record, but we don't get to see it. We don't get to see it, nor did we get really any detail at all from it beyond death by homicide by gunshot wound. So that's disappointing to me, just because of the many questions around the how and the 30-06. And I anticipate a very straightforward forensic explanation to that, which will involve the words lead snowstorm. Lead snowstorm, guys, very common. Look it up. So common. They have a whole name for what it looks like on an X-ray when a high velocity rifle bullet fragments inside a human body. But not today. Not today. We're not finding out if lead snowstorm is making an appearance here or not. On video on campus 4 times on September the 10th and going into the early morning hours of the 11th. I don't think I knew that. I knew they had him the morning and then the time of. I don't think I knew it was 4 total, including later that night. Also that Tyler Robinson had an interaction with the police on that night. Not sure that, I mean, it's not in the court records anyway. I don't know if that's been sleuthed out or anything like that, but an interaction with the police. I think he mentioned it actually, didn't he? Yeah, now that I think about it, I think Tyler maybe mentioned it in one of his messages. And then, of course, the reference to the cell data that accompanies the charger that tends to place Tyler Robinson in these neighborhoods at this time. We're not going to get a lot of detail about that, but come trial, oops, that was loud. Come trial, location data is going to be big. I mean, I don't know how it wouldn't be. It's quality-wise going to be significantly better evidence than this very, very dark car with distinctive wheels. Like, okay, they're shiny. I see that they're shiny. Not seeing how they're distinctive, unless that's something I'm just expecting to see. I don't know. I didn't see any other wheels of any other vehicles in this video. So I don't know what a normal wheel would look like. I don't know what a normal Challenger wheel would look like in this setting versus like what this one looks like. So I think if you're kind of primed to accept a characterization like distinctive, okay, maybe you'll see that. But characterizations, no, I'm not going to just accept somebody's word for that. That's a show don't tell type of thing, and then I'll judge for myself if it's distinctive. Didn't see anything here that's like, ooh, wow, that's obviously Tyler Robinson's Dodge Challenger. But location data, going to be a lot more solid, a lot more precise as well. GPS data tends to be quite precise when they're able to get it. So as long as he has those location services on, that's probably going to be stronger evidence presented in the trial. Bass player 2011 IFY. I don't blame the prosecutor. These rules are stupid. This is the only high profile I've seen where the defendant isn't allowed to even be described. The judge overruled that objection. He said, I'm not finding that this is suggestive. He was going to allow it. And then the prosecutor just goes and does something else. He like forgot to do it or something. Did he misunderstand? I don't even know. And so then we got to come back here at the end after this recess. They have to have a little conference about, are we going to get to do that or not? And even when he finally did it, it was very, you're supposed to do it that. Doesn't he know that? And all we got was a little, that guy over there. Yeah, anyway. Oh, the drama of the courtroom. But, you know, I'm not going to disagree with you on the rules being stupid. The rules may very well be stupid, but they're still the freaking rules. And that's literally your job, is to know the rules so that you can navigate the rules in your trial and in your hearing. You have one job, know the rules and apply them. Like, you're not a showmanner. You are a lawyer. It's because of the law. You need to know the law. Know the law. Apply it. That's literally the definition of what you're supposed to be doing. So maybe it is stupid, but it doesn't really matter. It doesn't really matter. You got to operate within those parameters. So just continue to find it baffling how difficult they find it sometimes. My Mini 67 for Jeff to get a pint. Big up coping with all these wittering women. He doesn't mind. He doesn't mind. He likes I mean, is any man going to be like, no, get rid of all of these women around. Don't have them talk to me. That would be terrible. I guess I'm probably showing my age now, actually, because apparently some of the young men today are like that. I really don't know. User something. You realize YouTube hurts image quality, right? Well, of course it does. I mean, we have many layers of problems with video quality here. We have it on the screen in the courtroom. That's one degree of quality reduction. We have it being filmed from a camera in the courtroom. That's a quality of reduction. And then we have all of that being broadcasted on YouTube. Another reduction in quality. Yes, of course. Many layers. The best image quality is going to be the raw data file, and none of us are going to get that. Certainly not right now. Maybe once the case is all said and done and grandma requests go out. That's the Utah Public Records Law. Grandma requests go out. It sounded like grandma, didn't it? Like grandmother, grandma. It kind of does look like it. Anyway, grandma. Not my Nana. Anyway, those requests go out to the law enforcement agency for the investigative materials after the case is done. Then possibly some of this raw material will make it out into public. But otherwise, it's not. It's gone to the defense and discovery. They have hundreds of terabytes of raw data. We know from the discovery updates. Go to the Substack. It's the last piece I put out was a compilation of everything from the discovery updates that we've had in court, although of course not today. Now we have another one, but there's really nothing to add to the last one. So the defense has all of that, and they can use it for their own purposes. But typically speaking, when you're admitting it into court, because a lot of that stuff is proprietary and you need a special player and that type of thing, they just convert it all to MP4, and then they play it as an MP4 file for court and file it that way. So it's not going to be the raw data. There's going to need to be a waiting process for any of that. Michelle 8190, do we know whose house that is? Is it somewhere where Tyler would normally go? Very good questions. Very good questions. Across the street from the Nobles is really all that we know. Haven't heard anything about any connection to Tyler or not. So very good question, type of thing that the defense might be exploring. They're the ones in the best position to know because they can ask him. The state has their own resources. Again, probably the best one's going to be that location data. You know, they can go through his whole phone and try to see if he's ever been there before. It's going to take time. It's going to be a lot of stuff to go through. But that is certainly a possible avenue that they could go down with their investigation to try to rule in or rule out any type of prior connection with this area or with that house. Losee, you trained us, Andrea. Maybe trust your followers. We're not randos. The info out there is more verifiable. People are notoriously bad witnesses. The problem with info out there is, I mean, we're like here arguing about authenticity for court. There's no authenticity requirement for the internet. Okay, so that's problem number one. There's no thoroughness requirement for the internet. There's no rule of completeness for the internet. There's no best evidence for the internet. People can take whatever they want. They can clip it however they want. They can crop it however they want. And it may or may not be fair. You have to take so much on faith in the, you know, public sphere when it comes to stuff like this. Now, is it impeccable, infallible in court? Of course not. But there's a lot higher standard, and somebody at least has to get under oath and say this is what it is, and you have an opportunity for both of the sides to be heard on it, so that if there is a problem, we would know. We would know. Like, there is zero chance. I'm just telling you guys. You know, I mean, you know, some people will believe me and some people won't. I'm just telling you guys. If there was any chance, that wasn't Tyler Robinson at the house, and they can prove it, and that's been fabricated. This is all just a lie that, you know, somebody has come up with, and all, you know, 28 law enforcement agencies have bought into it and so forth. But it's all a lie. It's fabricated. The defense is bringing that up. They are not sitting here, oh, let's let my client, young man, no criminal history of any kind, let's let him sit in jail facing death for another 2 years before we bring up that there is fraud in the process. It's just not, it's not going to happen. There's a gazillion reasons why. Getting into the whole, like what we are seeing them do with making their record for appeal purposes, that applies equally to issues with fraudulent evidence. This is a fundamental due process violation, okay? Like across every level. Due process, when it comes to like the integrity of the evidence and the not being misleading and things like that, applies to the discovery process through Brady. It applies to the warrant process through Franks. It applies to the trial itself and the presentation of evidence through Napui. Okay, all U.S. Supreme Court cases where they've said, you know, the prosecutor being dishonest, fundamental violation of due process. This team is going to be screaming from the rooftops if they have any hint of that whatsoever. And they're going to be doing it at the earliest opportunity because they want this kid out. They want him not facing death. They want him not in jail. That's their goal. Every case is unique, guys. That's the fun thing about following cases. You know, the Karen Reed case, remember it was the feds that were the heroes in that case? How often are the feds the heroes? How often are the feds the ones that we were like, thank God the feds got involved, figured everything out, sorted out the whole corruption thing going on with this this Massachusetts Police Department. I'm not necessarily going to count on that happening many times outside of Karen Reed. But it happened in that case because cases are unique to their facts. And so I accept people are going to have differences of opinion about where they come down on those facts. Totally fine with that. But there is nothing inconsistent about being like, wow, they had a really shitty case in that one case, and they have a much stronger case in this other one. Why? Because they're different cases and different facts and different evidence. Amy Abadi, and we also have a photo from someone smoking meth in the bathroom in Provo. I hope not. I hope not. Someone smoking meth in the bathroom. Not helpful. Goose 7574. Thank you very much for going over this in the prior hearings documents. Well, you are welcome. I am keeping the Substack, QR thing up there because that's where the document archive is. And yeah, things do get a little slow and dull in court sometimes, and we have the breaks and all of that. And so if at any time you want to go do some light reading, head on over. It's right there. Plenty of stuff to get familiar with if you have not already dug into the court file. There are hundreds of documents. There's a lot that has happened already. And so getting up to speed on that is just a possible way to maybe kill some of the boring dead time that is inherent in any kind of court process. To Truth for Liberty. Utah allows autopsy report to go to legal representative. Wondering if that means the legal representative can release it to the public. I would expect that. I mean, the legal representative is not bound by, court privacy rules. It's privacy interests that justify protecting these types of documents anyways. There's a lot of variation all over the country with, autopsy reports are far more likely to be held close. But some states, they'll release them to family. Some states, they'll release them to the estate, which is, I think, what this means, the legal representative of the estate. Some, they won't release it to anybody. It's like it goes to law enforcement and that's it. Where did this come up recently? There was a case. It's a cold case. I can't remember the name now. Anyway, something was happening, and the family was trying to get access to the autopsy report. I think this was in California, because California doesn't allow the family to get access to the autopsy report. So a lot of variation with rules like that, but it's just generally grounded in privacy. Yes, there's a lot of detail, and they review a lot of stuff like your entire medical history, and there's toxicology, and there's other stuff. And so personal medical information, one of the most protected things that we have in terms of the privacy interests associated with it. So yeah, you got a privacy interest in something like that, the government can violate it if they're just willy-nilly, handing this type of report out. But it can be waived by the person who holds the right. And so the legal representative has the right to do that. Now, is she going to want to? I kind of doubt that. It sounded like the prosecutor was saying she doesn't want it public. That it's kind of at their request to help preserve his dignity and stuff like that. They don't want it public, and that's their call. That's their call. So, not holding my breath to see it anytime soon. But we'll see. We'll see. Andrew Matthews, 1916. What do you think of the defense objections? They're annoying. They're super annoying, but I understand why they're doing it. They are being very cautious with this standing objection to make sure that they don't get in a situation where they're treated as having waived an issue because they didn't raise it, or it wasn't specific enough, or it wasn't clear that that objection would apply to this particular piece of evidence, and so forth. So I understand why she's doing that. Some of them, I think, yes, are creative. The suggestive in-court identification. This is creative because this is one of these, I don't want to say it's a cutting edge legal issue, but it's just, it's something that up until recently, there wasn't a whole lot of dispute about whether you could do this or not. Case law consistently all around the country, yes, people can do in-court identifications. And the argument that it's suggestive is because it's the only person there. He's the only person there who's a defendant, who's like clearly a defendant, not a lawyer. And so it's suggestive because you already know who you're supposed to point at. It's not like it's not a lineup. It's not like there's choices of defendants sitting at the table for you to identify. But there is also a long tradition of that, from the stand. And so they tend to allow it. But yeah, there's issues with memory and suggestiveness and it tainting people's recollections and things like that. So it's clever. It wasn't going to win, but she's made her point. And now also what she's done is she's set it up so that if they ask him that in trial, she can raise this again. You were asked to point him out, and he was the only person to identify. There was nobody else you even could have identified. And then, do you know how memory works? And do you know it's a process of revision, of rewriting every time you access the memory, and you can overwrite it with new information. And when you're asked to point out the only possible person, it's going to affect your memory, stuff like that. So I understand the pain in chat because it is a little bit aggravating, but there's nothing here that strikes me as like improper. There were a couple that were kind of stupid. The best evidence one was really stupid. The best evidence rule is an objection that the best evidence of the contents of a writing or document or video is the item itself, not testimony about it. But she objected to the video, and she objected to publishing the video. And so, then how can the prosecutor elicit a point about what's on the video without asking the witness? That was a pretty weak objection. But I don't hold it against her for making them at all. I think it shows that they are trying to make the best record they can. They are trying to preserve every single option for him. What does that tell you? They are anticipating appeal. They are anticipating federal habeas, all of that stuff down the line. They are conducting themselves accordingly. So I continue to expect more of the same. It's kind of been the theme of this case so far, and it's why I don't know, it's why I guess many of you who may differ with me about kind of where we're at and what the defense has to work with and so forth. I look at this case and how the defense is handling this case, and the focus is on process, not on substance. Just to reiterate, they have never once told me that Tyler Robinson is factually innocent. They've never even implied it. Never suggested it. To the contrary, they've kind of suggested otherwise, that because there's such incriminating evidence against him, if I see it before trial, I wouldn't be able to be fair. I would have such a firm opinion of guilt that I couldn't be a good juror. This is all pretty clear from the way that the defense is handling the case. And where they are setting up these potential errors, they're on procedural issues. Cameras in the courtroom. What hearsay testimony gets allowed and so forth. That's where they see the room to operate and the room to be able to work for him. That could change. And when it does, I will absolutely be paying attention. But it's been 10 months so far. And there hasn't been really a whole lot of reason to think there's some whole other story here to be told by the defense other than the mitigation story. That's where I was going to finish when I was ranting and the judge cut me off. Was there's a reason why the defense is not aligning themselves with this the theories and everything. Okay, they put a guy on the stand to call the comments about Erica, the theories about Erica, to call them terrible and disgusting. They don't like this stuff. They don't want to be associated with it. And there's a couple reasons why. One, the factual asymmetry, they know what they have to work with that the rest of the world doesn't. So they know where the room is to try to make a factual innocence case. But the other reason is because if people are only interested in this case and this client because they think he's innocent, just engage this hypothetical, okay? People are really only interested in this because they think he's innocent. Then let's say we go to trial and it's definitive, right? He's on video and you see it all, and everything is corroborated, the cell phone location, the confessions, it's there in the metadata, all of it. Okay? It's all corroborated. He's stitched up. Then the case is really about mitigation. The case is about Tyler Robinson and who he is and does he deserve death. And that's what the defense would be focused on. And they would already know here that as soon as the guilt innocence part is done, the carrion pickers are gone. They're gone. They no longer have any interest in the case because they don't actually care about Tyler Robinson. They don't actually care about Tyler Robinson. They care about drama and a story that is titillating, you know, massive corruption and cover up, all these people involved, nefarious, backstabbing, international implications. A lot of dopamine there. Not a lot of dopamine in kid gets radicalized online and how. And who he talked to, who he was before. What he cares about, what he was like in school. What his friends and family and neighbors thought of him. What his teachers thought of him. Was he a good kid? Was he a bad kid? What were his interests? What was his relationship to the church? How did this happen? If this is a mitigation case, that's what the defense is focused on, and that's what they care about. And that's what they care about possibly more than anything else, because their primary goal is to make sure their client doesn't get killed. And if there is a strong case against him, and they're in the best position to know that, then they're going to know how important the mitigation side of the case is. But nobody else is going to care about that. That's why they resent it. They know. They know that as soon as the case becomes about who Tyler Robinson is, I'll still be here. I'll still be here. Some of y'all will still be here, but a lot of y'all won't. So they know it. I know it. It just is what it is. Well, guys, as I said before, I'm going to do things a little differently tonight. I know you doubted me, and I have to admit I doubted it as I said the words that I'm going to wrap up real quick after they're done. I know. I thought, no way. I know some of you thought no way too. But yeah, we're going to do it. We're going to do it. We're going to wrap up. We're going to be back at 7:30 Pacific. Have a little time for just things to simmer, things to sit, reflect, maybe do a little research, some things to look at. Got a few things to come back with, some of the state's cases, some of the rules that we've talked about today, stuff like that, just to shed a little bit of light on what happened in court and what the nature of these disputes are. So we'll do our little more casual kickback, go through the notes, and talk about the details later this evening. But for now, I am going to sign off, guys. I am invited to go and talk about what happened in court today on the Charlie Kirk show. So I will be there in, I don't know, probably about an hour or so. Feel free to check that out or not as you see fit. But hey, y'all were here. Y'all saw what I saw. Just there to kind of report on how court is going at this point. And otherwise then, take a little time, maybe go outside, move the old biological container around a little bit, check the trees, all the good things, but come back for a little late evening sesh, chew over what happened today. And then we'll be back at it again tomorrow, guys. So same time, if you want the live stream of the hearing, come and watch it with me. Come and chat about it. We'll be getting started at about 7:45 Pacific tomorrow, just to recap and be prepared for anything to happen with the court. But that's going to be it. I want to thank all of the mods. Mods, you guys. You guys are a lifesaver. This case tends to have a spicy chat. So a little more work for the mods, just to make sure that everything is being done respectfully, and nothing's gonna get the stream taken down. Guys, watch the threats and stuff. Let's not be doing that. It's really not necessary. So really appreciate the contribution from the mods. Of course, Jeff, the head mod, appreciate him and all of his support very much. Thank you to everybody in the chat who contributes. Those of you who agree with me, those of you who don't. I don't mind being challenged. I don't mind pushback. I'm happy to explain my thought process. And again, we may come together, we may come to agreement on it, we may find middle ground, we may not. And that's just part of all of us trying to become wiser and better informed. Not being outside of an echo chamber makes us more intelligent. We do need to consider all sides of things. It doesn't mean that everything is a good idea. But it's worth hearing and evaluating and moving accordingly. So thank you to all of you for how you contribute to that. And just thank you for your interest in the justice system, particularly the criminal system. I've said before, and I will simply repeat, that one of the reasons I wanted to cover this case in the first place is because I knew right off the bat, as soon as it happened, I'm like, there's going to be massive interest in this case. And a lot of these people will have never watched a criminal case before. This is not your typical true crime, kind of devotee situation where, it's primarily of interest to people who like to watch court cases. This is very different. I think it's primarily of interest to people who haven't necessarily focused a lot on the court system. And so just to have the opportunity to kind of shed some light on how it works, my experience with it, the role of the defense in all of this and how they work, because that's my background and that's what I understand. That's how I process cases. I look at it through the eyes of how a defense attorney is going to see it and what they're going to anticipate and the kind of strategy decisions that they face and things like that. And so trying to share that with you guys, I think it's a big part of my goal to help have a better understanding of how the system works, and the way that I may be the only one, but I do continue to have faith in this justice system that we have. It's not perfect by a long shot. Many, many things could be and should be improved. But by and large, works most of the time. It's my view. It may not be yours, but it's just going to be part of the perspective you get here, I guess. But that's part of my goal, is to explain, why I think that and how I see it that way. So thank you all for your interest. Thank you all for being here. Look forward to seeing you guys back bright and early tomorrow. If you feel like checking in for the late night, please feel free to do that as well. It will be a chill scene. So guys, with that, we are calling it a day. Appreciate all of you, and we will see you next time.